rigorous cross-examination, and now it is time for the attorneys, their last time to try to sway this jury. The defense saying that it was self-defense, that this former police officer acted in fear of his life when he shot and killed the victim in this case, Chad Oulson. The prosecution saying it was over anger, not fear, that the former cop pulled his gun and took the life of another. Before we go in, let's bring in Ed Bull. He's the attorney, the sitting attorney in Iowa, and joins us now in Marion County, Iowa. Forgot what county there for a second, Ed. Good morning to you. This is it. This is closing arguments, and they are arguments, and this case is contested. What are you looking for from both sides as a last word to this jury?
The state just has to be methodical, keep inching forward their case. It's clear this was anger, not fear. The defendant left the movie theater multiple times to go get help, and he shot a guy over a cell phone screen during previews. I think I'd much rather be the state of Florida today than this defense counsel.
All right, we're going to watch it play out. Of course, the state goes first in the closing arguments. Then it'll be an opportunity for the defense, and then the state gets the final word. Scott Rosenwasser is going to deliver for the state of Florida. Let's go in now and watch together the closing arguments in the movie Popcorn Murder Trial.
Man killed over popcorn toss. When you think about it, you think that should be on a headline of a newspaper. Big, bold, black letters. Man killed over popcorn toss. Or you're standing in a checkout line in the grocery store, and you look at that. Or you're surfing on the internet, and you see that, and you click it, and you think, well, that's sensationalized. No one could ever think that would take place. There's no way that a man was killed over a popcorn toss. And it's not just rhetoric in this case. It's not something that we talk about and we say as if to make a point, to make it flashy. Because in this case, we know that's what happened. You don't have to look between the lines. You don't have to say, well, maybe, possibly that's what it was over. We know that's exactly what it was over. As flashy and as sensationalized as that sounds, that's what happened. And we know that. How is it that we know that? Because people, 2 to 3 people in the theater heard this defendant say that right after he shot and killed Chad Oulson. Derek Friedoff, Mark Turner, and the Summit Cent, Charles Cummings. These 3 people do not know each other. Derek Friedoff was sitting a row in front of the Oulsons and to the left. Mark Turner was sitting all the way to the right in the defendant's row. Charles Cummings was sitting a row in front of Mark Turner. All across the theater, they heard the defendant say, "Throw popcorn in my face." That's why we know this case is truly about a man killing another man over a popcorn toss. These 3 people, Derek Friedoff, Mark Turner, Charles Cummings, they don't know each other. They're not friends. They're not family. There is no evidence that would lead you to reasonably believe that they got together to frame the defendant, that they got together in the theater and they huddled together and they said, you know what? We don't know Curtis Reeves, but let's make up a story that he said, "Throw popcorn in my face," or some words to that extent about the popcorn. It would be completely unreasonable to believe they got together to frame the defendant. Some grand conspiracy. This case is absolutely, unfortunately, about a man killing another man over a popcorn toss. Now, you don't have to really read too much between the lines or go very far below the surface to determine why this happened. Now, when I say this, I am not saying this as an indictment on law enforcement in general. We are only talking about the defendant. And what do we know about the defendant? Well, there's certificates and evidence. A career law enforcement officer, trained in de-escalation tactics, not only through the department, but through Busch Gardens. How you take a volatile situation, and I submit to you this wasn't even a volatile situation, but how you take the most volatile situations and you de-escalate it, lower the volatility. Yet, despite all that training, Instead of de-escalating the situation, the defendant instigated the situation. The defendant started it and he stopped it. And what you have to look at is what's happening here. Here's an individual. The defendant is a person that I submit to you based on the evidence likes those danger situations, likes the adrenaline, the units that he was involved in. He likes the control. Now, I'm not saying there's anything wrong with leadership. Of course there isn't. That would be silly to say. But likes the danger and likes the control. And that's how he started this, that's how he instigated it, and that's how he ended it. And that's what this case is about. It truly is about a man who killed another man over a popcorn toss. Now, the defendant wants you to believe this, and I submit to you that both versions of the events that the defendant told you are absolutely 100% not credible. And I submit that you know that already. The defendant wants you to believe this. A retired captain from the Tampa Police Department who's been involved in robbery, homicide, fugitives, the Special Weapons and Tactics Team, also known as SWAT. Remember during his testimony what he's saying. Man, it's eye-opening. When I first started, the level of violence and the dangerousness, you wouldn't believe it. Yet that very same person wants you to believe that in all his years doing all those jobs throughout Tampa, the one person that scared him the very most, the one person that he had to shoot and kill was in theater number 10 on January 13th of 2014. The person that scared him the most is a father and a husband that said, "Leave me alone, I'm texting my daughter." Maybe Chad Oulson scared him the most in his entire life in that moment in theater number 10. I'm texting my daughter. He reaches and he grabs a popcorn and he throws it at him. In his entire career, that's the most he's ever been scared. Absolutely unreal and unbelievable story. The defendant in this case shot completely out of anger. And we know that because of the words that he stated afterwards. And not only that, you're going to have the videos back there with you. You're going to have the state video, you're going to have the defense video. They're both basically the same. Very minor differences. Watch the reaction that the defendant has when he's shooting, because that demonstrates the anger, the explosion, and that's why those words come flying out of his mouth immediately after he shoots. He lunges forward. He's not back in a life or death struggle like he wants you to believe. And we're going to talk about his stories. That is absolutely not what happened. He lunges forward. And how was he able to do it so quickly? Because when he was moving back, that gun was at his hip already. That's exactly what happened. That's how he was able to fire. He already had it at the ready. But we're going to talk more about that later. Now, when he's interviewed in the cruiser, think about this. Now, you have that tape statement. Listen to it as many times as you want. Okay, and again, those videos are on the computer. You're going to have a computer that's going to go back with you. So you're going to be able to look at the videos. There's a player. You can move it back and forth like we are doing on cross-examination. When you listen to that post-Miranda statement, think about it. Now, you have to rely on what you believe is in that statement. I submit to you it shows a cool, calm, and collected person telling an unbelievable story in order to justify what he had done. A very self-serving statement, and a self-serving statement does not equal self-defense. A retired police officer sitting in a cruiser, cool, calm, and collected, making up a story that is contradictory to every witness in this case. There are 7 to 9 eyewitnesses in this case, including 2 that the defense called. And none of them even remotely touch the story that the defendant wants you to believe, including his wife. Sitting right next to him, inches away. She didn't see some violent life or death struggle. Do you think that she would have noticed something like that? Of course, because the defendant's story is 100% untrue. A self-serving story. Now, why did he tell that story? It's a great question. I submit that he told that story because he had no idea that so many people observed what happened in that theater. But here's what he really didn't expect. The silent witness. Who was the silent witness the defendant never in a million years thought was going to speak the loudest words in this case? It was that video. I submit he had no idea there was a video in there. The silent witness spoke the loudest because when you watch that video, every single thing that he said was untrue. Every single thing. And then he came into court and took that stand and looked you in the eye and told you a completely different story from the unbelievable one in the cruiser. Why is that? Because he knows what really happened on January 13th of 2014. Just like the witnesses that came in and told you. Just like the video tells you. He shot and killed a man over a popcorn toss. He started it and he ended it. End of story. Now, we had a jury trial the past 3 weeks. When we have a jury trial, the state, sometimes people call us the government, okay? But it's the state of Florida. It's the three of us prosecuting this case. We have to prove the case to you beyond a reasonable doubt. That's our burden. We gladly accept it. It should be that way. Now, what is a reasonable doubt? At the conclusion of the case, you're going to hear all of the law. I get a copy of the packet as well. So you don't have to memorize the law. It's kind of complicated. We're going to go through it. I have a lot of boards and an easel. We're going to go through the law. Okay? Now, a reasonable doubt. This is part of the instruction. A reasonable doubt may come from a lack of evidence, and it may come from a conflict in the evidence. Now, I submit to you there is no lack of evidence in this case. 7 to 9 eyewitnesses and the video. And the defendant's self-serving statement. It's almost like when someone says they didn't commit a crime because they have an alibi in another county, but then it's proven that they're in the county. It's like, why make up such a story? A conflict in the evidence, let's talk about that. I submit to you whenever there's a jury trial, there is a conflict in the evidence, right? I mean, just the very nature of a dispute is there's a conflict in the evidence. And that's not a reasonable doubt in and of itself. Because if you think about it, then you could just have some people come in and say, well, I said it's red, this person said it's blue, conflict in the evidence. How would you ever prove a case? You couldn't. So what do jurors do? Obviously, what a juror does is you take all of the evidence. There's a lot of evidence in this case. And you got to sift through it, you got to look at it, you really got to analyze it, and you got to say to yourself, what evidence here is credible? And Judge Barthel's going to read you an instruction. And what she's going to say is you can believe all of a witness's statement. You can believe none of a witness's statement. You can believe some of it, discard some of it. That's totally up to you. And what's interesting about this case is we have a mixture of all of that. There are witnesses where you can believe everything they said. You could take some of what people said. Vivian Reeves' testimony, Jennifer Shaw's testimony. You could take some of that. Others of it, I submit, you're going to have to discard because it's certainly not credible. Ultimate bias in that. But we'll talk about all this. You could completely disregard a statement. Both of the defendant's statements are completely unreasonable based on the totality of circumstances. He didn't fear anything. He wasn't vulnerable. He was an instigator. He started it and he ended it. So just a conflict in the evidence isn't a reasonable doubt. You have to take all the evidence, find out what's credible. So what you do is you take the not credible evidence, you put it aside. You take the credible evidence and you look at it. And we're going to go through the elements of the crime. So you take the credible evidence and you apply it to all the elements. And what you do is you start with the highest crime charged. And again, we'll talk about all that in just a little bit. But you take the credible evidence, you apply it to the law, that's how you come up with a just verdict. Now, the other instruction that is contained within a reasonable doubt is this. A reasonable doubt is not a forced doubt, an imaginary doubt, a possible doubt, or a speculative doubt. Okay, I'm going to repeat that because it's really important. It is not, and the most important two are possible doubts or speculative doubts. Those are not reasonable. So there's a story that I tell for every closing argument. Obviously, I'm going to tell it today. So let's say that it's the summertime and you're out walking your dog and it's nighttime, and you hear thunder, you see lightning, you smell rain, and you go to bed. When you go to bed, you wake up, and your neighborhood is soaking wet. Has it been proven beyond a reasonable doubt that it rained? Absolutely. Because common sense tells you that. And remember, you don't leave your common sense at the door. Thunder, lightning, smell of rain, your common sense, it's been proven beyond a reasonable doubt it rained. Now, is it possible the neighborhood kids went walking around that night when you were sleeping? You got Christine, you got Carol, you got Jeff, and you got Bad Brian, okay? Now, is it possible that Bad Brian went out and took a super soaker gun and sprayed the whole neighborhood with water while you were sleeping? I mean, you could talk about that any day. Is it possible the sun's not going to rise? Based on the evidence, thunder, lightning, smell of rain, and your common sense, basically what comes from the witness stand and what's in evidence, it's been proven beyond a reasonable doubt that it rained. It's not possible Bad Brian did that super soaker thing. That's ridiculous. That's not reasonable. Now, can you speculate that a helicopter went over the neighborhood with a bucket of water going to a fire and that the bucket of water landed on the neighborhood? Sure. But based on thunder, lightning, smell of rain, and common sense, that is completely unreasonable. Can you speculate your car's not going to start tomorrow? Sure. But that's unreasonable. So those doubts are not reasonable. So you got to be careful when you start getting into possibilities and speculation. You have to focus on the credible evidence. So let's talk about speculation, because there's so much speculation in this case. It's really important to talk about it up front. I'm going to call these speculations shiny objects. Because what happens with a shiny object? See, if you look at a shiny object, let's say there's a whole bunch of shiny objects floating over here. If you look at those, you're going to forget to look over here at this table where all the credible evidence is. And when you look at all that credible evidence, I submit you're going to find the defendant guilty of either murder in the second degree or of manslaughter. Because these shiny objects, if you look at them, you lose focus of what really happened in this case. So I have a list. It's a fairly long list of shiny objects. Now, if a lot of questions are asked about a shiny object, or you yell about a shiny object, the only thing that happens is this: it doesn't become any more relevant and it doesn't become any more important. It becomes shinier. That's all that happens with shiny objects. So let's talk about all the shiny objects, the unreasonable doubts in this case. The sheriff's office should have recreated the scene, and the theater was too dark and too loud. That's a shiny object. First of all, it'd be impossible, literally impossible, to recreate that scene. The best law enforcement agency in the world couldn't recreate that scene. And why is that? Because think of all the moving parts. You'd have to know where everybody was seated. Not only that, what angle they were at any given time, because every angle would be important. Where the Oulsons were, where the defendant was, where all the witnesses were, what the exact scene was at that exact time, while they were in that angle, while someone was talking or not talking. Every single thing would matter, and you can't recreate the scene. It's impossible. A light meter wouldn't tell you a thing. A sound meter wouldn't tell you a thing. Who tells you? Witnesses. They take the stand under oath. They tell you what they saw, what they heard, and none of them got together to frame anybody on January 13th of 2014. It's impossible to recreate the scene. So when a paid witness for the defense gets up there, Michael Knotts, and talks about recreating a scene, it's impossible. We wouldn't bring that to you. I submit to you there would be a very long cross-examination about it. Like, how could you possibly tell this jury that this scene could be recreated? Plus, how would you even document that? A camera would never in a million years ever tell you what an eyewitness can tell you. Just can't happen. It's a shiny object. Now, was it too dark? Remember at the beginning of opening arguments, I said, hey, please make sure that a witness is not pigeonholed into one word. Remember, muted, dim, dimmer, dark, darker. One word means nothing. What's important is the picture that's painted. And you saw it happen during the trial. Now, what did all the witnesses tell you? Even Joanna Turner, and we're going to talk about her. All of them told you, yeah, it was dark. It was muted, it was dimmed, but we could see. We could see. We could see 5 seats down. We could see 10 seats down. When we get into the theater, we can see. That's the real evidence in this case. And what they saw was the defendant started and ended. What they saw was the defendant kill another man over a popcorn toss. Now, could they hear what happened? Oh, it's so loud. The previews are so loud. We couldn't possibly hear it. Well, that's not true, because every witness came in here and they told you, yeah, previews are on. But we could hear. Now you think about the layout of where everyone was in that theater. You have the defendant with his wife sitting in the back row. Directly in front of them is the Oulsons. Going back into the defendant's row all the way to the left are the Hamiltons. They could see, they could hear. You go all the way to the right, you have the Turners, Joanna and Mark. They could see, they could hear. Even closer is Jane Roy. She could see, she could hear. Then you have the Oulsons. To the right of the Oulsons, you had Charles Cumming. He could see, he could hear. Then in front of the Oulsons, you have Derek Friedoff. He could see, he could hear. Nicole Oulson, even Vivian Reeves. There's not a question if it's too dark or it's too loud. Now, there was an interesting moment, though, in the trial. There was a very interesting moment. Okay, you remember Matt Reeves, and we're going to talk about Matt Reeves. Okay, I would submit to you that Jennifer Shaw and Matt Reeves were in a tough situation. They were credible and not credible at the same time. But Matt Reeves said something that was really interesting. Now, think back to the defendant's first statement in the cruiser. Again, it's an unreasonable statement. Didn't happen. I mean, it absolutely didn't happen that way. But think about what he said. He said that while he's leaning back in this life or death struggle, he's yelling what? What's he yelling? No, 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 and whoa, whoa, whoa. What's Matt Reeves say that he heard when he came into the theater? Now, you rely on your own recollection. I could be paraphrasing it. He said 2 different things, but he said, I heard, get out of my face, or something like that. And then defense counsel asked him, well, how did you recognize it? Well, it's my dad's voice. Of course I heard it. Now, think back. I'm sure you know where I'm going with this. Think back. Who in this case said that somebody said at that point in time, get out of my face, or words to that effect, stay out of my face? You can't confuse no, no, no and whoa, whoa, whoa with get out of my face. But who told you that was said by somebody?
Come back into the movie, and the guy put his phone away. And I was like, thank God. I said, I see you put it away. I told the manager for no reason. In other words, I went in and ratted him out. He was going to put it away. I would have gone, right. And he turns around in his seat, and he says something about he was, I don't remember, if
So who is saying that someone is saying words that are close to that? The defendant. So was Matt Reeves able to hear Chad Oulson telling this defendant, basically, stay the hell out of my face, leave me alone, stop instigating me, just leave me alone? So was it really too loud? Or did Matt Reeves come in here just to try to say the defendant said it because he wanted to help out the defendant? Matt Reeves is also the only witness that said it was nearly pitch black. Not a single witness told you that. Not a single witness. The Sheriff's Office investigation, a shiny object. In fact, it was a super shiny object. We heard many witnesses, extensive cross-examination. There was a suggestion that the Sheriff's Office investigation was bad. I'm going to use a very non-legal term here. There's a suggestion that the Sheriff's Office investigation was crappy. You know what? The Sheriff's Office investigation was crappy. Absolutely. It was a terrible investigation. There's no doubt about that. You could bring in one witness, you could bring in 50 witnesses. There's not a single person that would listen to this case and say, wow, they did a fantastic job. They did not. Absolutely did not do a great job. No doubt about that. But it's an incredibly shiny object.
Scott Rosenwasser giving the closing argument for the state of Florida. We're going to step aside, take a short break. We're going to rejoin right where we left off. You won't miss any of it. We do have some breaking news to pass along. President Biden has made a decision. He's set to nominate federal appeals judge Ketanji Brown Jackson to the Supreme Court. Not a huge surprise. This is according to the Associated Press. She was a front runner from the very beginning. It is a historic move. This will make her the first black woman to serve on the nation's highest court. Let's bring in trial attorney and former president of the National Bar Association, C.K. Hoffler. Your thoughts, C.K., on this decision? Not a huge surprise.
It was not a huge surprise, but what a great decision. And I applaud the president for this decision and for announcing it at this time while we're amidst a war. But this is such a magnificent development. Judge Ketanji Brown Jackson is eminently qualified. She has clerked for Justice Breyer. She has the judicial temperament to serve in this capacity. She has the leadership. She has an incredible background, a diverse background of experience for a lawyer, and that makes her a phenomenal nominee for this position. She also secured bipartisan support when she was confirmed within the past year. And so on all fours, if you have to check all the boxes, she meets the criteria. But most importantly, for me and for so many, because she is an African-American woman, she is making history, and she is so broad and diverse, has such richness in her background, having represented the least of these. And certainly that perspective is going to be very important on a lot of the issues that the U.S. Supreme Court will be facing. So I think that this is a magnificent development. I applaud also the other front runners, Judge Kruger, Judge Childs, who also were phenomenal candidates, and I could not be more excited for the president's final pick.
All right, and the formal announcement expected later today in Washington. CK, thank you. We're going to step aside, take a break. When we come back, we'll pick it up right where we left off. It's closing arguments on a Friday, right here on Court TV. Stay with us.
How's she doing?
28 years ago, Curtis Reeves, a former Tampa police officer, shot and killed Chad Oulson in a movie theater. Today, his fate is in the balance. He may be walking out of this courtroom at the end of the day, or he may be headed to prison, potentially for the rest of his life. He's 79 years old now. We're watching the closing arguments from both sides. We're going to pick it up right where we left off. Scott Rosenwasser is delivering the close for the state of Florida.
A super shiny object to take you away from looking over here. Because in reality, it doesn't mean a single thing in this case. Now, do we want law enforcement to do a great job? Of course we do. You kidding me? But in this case, it didn't mean a thing. Because we brought in witnesses, eyewitnesses, credible eyewitnesses. And you saw how they were cross-examined. They were tested. It doesn't mean a thing that the sheriff's office didn't do a great investigation. Think about all the witnesses that testified in this case. I'm going to try to name the most important witnesses. You had Nicole Oulson. You had Vivian Reeves even. Her testimony kind of meant something because what she doesn't tell you speaks volumes. Jane Roy, Joanna Turner, called by the defense, Mark Turner, the Hamiltons, Angela and Alan, Charles Cummings, Derek Friedoff, 9. They came and told you what happened. It doesn't matter. Let's say the sheriff's office, just for the sake of argument, asked one question of each of those witnesses. Does that mean when they came in here and testified about what they saw and what they observed, it doesn't mean anything? Of course not. It doesn't matter in this case. Not a single bit. You could just remove the sheriff's office from the whole case in this case. Now, there are some investigations where it really does matter. Thankfully, it's not this case. It's a big, shiny object. We absolutely agree they could have done a better job. Not only do we have all those witnesses, we have the silent witness, the video, that tells you what had happened. The detectives, this is shiny object number 3. The detectives didn't have the qualifications. They didn't know enough about self-defense to be involved in this case. All right, let's talk about that. Doesn't mean a single thing, okay? You have a defendant here who has all this law enforcement experience. It's not some unsophisticated person that for the first time he's ever been interviewed. And when you listen to the post-Miranda statement, he's asked plenty of questions. But let's say he was just asked one question. Do you really believe that this defendant didn't understand what was important to tell the detectives and that the interview was the defining moment? He knew enough to make up a story to justify an unlawful shooting. Perception distortion, he's throwing out this terminology. He knows what's going on. Perception distortion is not when you make up an attack that never happened, okay? That's just called being untruthful. It has absolutely no bearing in this case at all. It's a shiny object, means nothing. So when their paid witness takes the stand and says, oh, you'd like to ask him these questions, at the second time, and it's on tape, Detective Proctor, when he goes back to him, he says, hey, is there anything you want to tell me? No. But you know what he does says? You know what he says? And we'll talk about it again later. You know, I'm back here, and I'm second guessing. You know, I'm not sure he hit me. This incredible hit that scared him to death, that no one saw, I'm not really sure that happened. That's what he says. You don't get second chances when you kill somebody. It's a shiny object. Shiny object number 4, witness contamination. You can talk about it with 50 witnesses. You can yell about it. It means nothing. It becomes shinier. There is no evidence at all of witness contamination in this case. In fact, we have so much evidence against it when you think about it. Okay? First, you go with the basic premise, no one really knew each other, and they wouldn't get together in the theater to conspire to frame Curtis Reeves. Well, then you might say, well, maybe they just absorbed some information and it was planted in their mind like inception, and now they're testifying. That is ridiculous. That's the very definition of an unreasonable doubt. And you had an opportunity to see them on the stand and judge them and observe how they were testifying. But here's the point that I'm making. Think about Joanna Turner and Mark Turner and that testimony. Joanna Turner, some of what she said I would state to you is credible, some is not credible. And we'll talk about Joanna Turner in a little bit. But with witness contamination, that shiny object, think about this. They lived together. Joanna Turner said she spoke to Mark Turner. She shared her information about this thermos that, just for whatever reason, she believes there's a thermos somewhere. Well, we know there's no thermos. She said it actually wasn't a cell phone. We don't know what happened there. But my point is this. They shared that information. Did Mark Turner come in here? Did he take that stand and say, oh, I saw a thermos too? No. It's the opposite of witness contamination. She shared information with Mark, but they testified differently because they came in here under oath. They told you what they saw, what they heard, and what they observed. It's the opposite of witness contamination. It's what's supposed to happen. It's a very shiny object, witness contamination. It sounds terrible, but it didn't happen. And there's no proof at all. Well, there's people sitting at a table. Who are these people? Any proof Derek Friedoff got with Mark Turner, or that Mark Turner got with Charles Cummings, or Charles Cummings got with Alan Hamilton? That's pure speculation and an unreasonable doubt. It's a shiny object. All right, shiny object number 5. Detective Proctor interviewed 2 witnesses, which are the Hamiltons, for 5 minutes off tape. What does that mean? That means this. Detective Proctor interviewed 2 witnesses off tape for 5 minutes. That's all it means. They came in here and they testified. Shiny object number 6. We already touched on that. The detective's interview. Maybe they weren't asking the right questions. The defendant knows what he had to say. He made up an entire story. The witnesses came in here. They told you what they saw, what they heard, what they observed. Shiny object number 7. A holster was in Detective Proctor's drawer for 1 week locked up. Oh my goodness, there was a holster in his drawer for a week. So what does that mean in this case? What is
All right, we're
this
just going to
shiny
put a quick break. We'll pick it up right where we left off. Stay with us.
Retired police captain Kurt
In just a few hours, the fate of 79-year-old Curtis Reeves will be in the hands of a jury. After the attorneys finish their closing arguments, the jury will be tasked with deciding if the defendant acted in self-defense like he claims when he shot and killed Chad Oulson in a movie theater 8 years ago. He's accused of second-degree murder and aggravated assault for the 2014 incident. Reeves spent hours on the witness stand Thursday telling the jury about his career in law enforcement and the day that he shot Oulson in the theater. We'll soon find out what effect his testimony had on those 6 jurors. Let's take you back now to the Dade County courtroom, right where we left off. Prosecutor Scott Rosenwasser delivering his close.
What does this shiny object mean? It means this. There was a holster in Detective Proctor's drawer locked up for a week. That's exactly what it means. Now, if this holster was important because it was a whodunit case, because there was blood or something on it, and it would degrade in his drawer for a week, well, then it's a big deal. It wouldn't be a shiny object then. It would be a big deal. Is this case about the holster? Or is this case about the defendant shooting another person? Obviously, you know the answer. The defendant started it. The defendant ended it. Shiny object number 8. The video surveillance was taken by Cobb Theater employees, and all the way out of state it goes. And then it comes back in a box that no one opened until it had to be opened. All right, what does that shiny object mean? It means this. The DVRs from the Cobb Theater were taken, and they went all the way out of state. And then they came back in a box that was locked until someone had to open it. And now you get to see that very video. A video from the state and the video from the defense. And when you watch it, whatever the subtle differences are, it basically tells you what happened, because that's the silent witness. It did go, and it came back, and you watched it. End of story. It's a shiny object. Was it the best practice? Of course not. No one would argue it's the best practice, but it doesn't matter. Shiny object number 9. This is the testimony of Jennifer Shaw, Matt Reeves, and to some extent Joanna Turner. I want to be very clear on this point. Jennifer Shaw and Matt Reeves are absolutely not bad people. They are not bad people at all. They're good people. But in this particular case, for this time frame, testifying for the defendant, they're just not credible. Has nothing to do with who they are as people. They're just too biased because they're too close. Now let's talk about Jennifer Shaw's testimony. You remember she took the stand and she started crying. And I'm not making fun of the testimony. I just have to point out to you things that were just not right. So she takes the stand and she starts crying. And what's the first thing that she cries about? You know what? My dad asked me for the first time to help him. It was so shocking to me. He was deteriorating before my eyes. And she starts to cry. And this was over the kayak paddles. Now, this is why cross-examination is good. You know, it's good for the state, and it's good for the defense, absolutely. It's the purpose of it. So what really came out after the tears about the deterioration of the defendant? What happened that day? The paddles, the kayak paddles, were actually stuck. And together, they twisted and pulled. Now, there's a lot of times that we went through probably some incredibly painstaking questions about physical ability. And if you were watching this trial and you just tuned in, you were probably like, what in the world are you all talking about? Well, you all know what we are talking about and why we are doing it. Because if there's the suggestion that the defendant shot and killed another person in a movie theater because he perceived himself as vulnerable, because he's a fragile egg that at any moment can break and be killed by either popcorn or even a fist, we got to address it. And that's the reason why we did it. Did it seem like a lot of information? Sure. There's probably points in times where you were like, oh my God, we could skip these 7 hours. But it was important to bring up. So Jennifer Shaw, she's crying. I'm watching my father deteriorate before my eyes. But all that happened was the paddles were stuck, and together they were able to twist and pull, and boom, after 10 minutes together of doing that physical activity, they were able to pull the paddles apart. So was he deteriorating, or the paddles were just plain stuck? That's it. And on cross-examination, what did she tell you? Okay? Actions always speak louder than words. The defendant's words don't mean anything, meaning his statement to police and on the stand. His actions, what you observe and what other people say, mean everything. We saw a video. We're going to talk about Dr. Foley in a second about all these x-rays and MRIs that were done like a year or so after this happened. What can the defendant do? What did Jennifer Shaw tell you the defendant can do? He can bike, right? Mountain bike, road bike. He can kayak, wiki-wachi. That's 3 or 4 hours of paddling, lots of turns. He would hunt, walks around the neighborhood, pulls a wagon, washes cars, pressure washes the house, mows. You know in Florida that if you don't mow after a week, it's a jungle. Mows on his electric lawnmower, washes cars, prunes, hedges, shoots sporting clays, shoots bows and arrows. The list went on and on and on. Just days before this shooting, what was he doing? Did he perceive himself as this vulnerable, fragile egg as he went 10 feet up into a tree to hunt? Walked at 100 yards each time, was able to sit in the car for long car rides, could drive up to North Carolina. And it seems kind of silly, but all those things take coordination. And if you have so much arthritis and you're deteriorating to that point, you can't do it because it's not the right picture being painted. That's why it's an incredible shiny object. Matthew Reeves, the only person to say it was nearly pitch black, okay? They're not bad people. They're just not good witnesses in this case. Too close to home. Joanna Turner. Joanna Turner was called by the defense. Now, why didn't we call Joanna Turner? So think about this. Let's say there's a traffic crash. You got 5, 6, 7, 8 witnesses that tell you the light was red. And they don't know each other. And there's no reason they'd make it up. And then you have one person that says, you know what, I saw it and the light was green. What would your common sense tell you? It would tell you, you go with the red group. Joanna Turner, the shiny object Joanna Turner, is in the green group. For whatever reason, she perceived something that resembled a thermos. There's no thermos, but I specifically asked her. Now, her testimony, I'm sure you all recognize this. You use your own opinion. Maybe the last person that spoke to her, that would be the answer she'd say. But what she said was for sure it wasn't a cell phone. Now, we're going to talk about the cell phone in a little bit. That's an incredibly shiny object in this case. So there was no thermos. Now, let's just say there was a thermos and there's no evidence there was. What did she say? Well, at the time that I saw this flicking motion of what she perceived to be a thermos, she didn't even think anything violent was happening because she just went back to watch the preview. But that's why we didn't call Joanna Turner. Not that she intentionally was misleading anybody, she just didn't perceive it correctly. Why bring that evidence before you? That's why Joanna Turner wasn't called. Shiny object. Getting to the end of the shiny objects. Number 10, the testimony of Dr. Foley, Dr. Adams, and Dr. Cohen. Dr. Adams charges $450 an hour. You would remember him. He used to be the medical examiner at the Hillsborough County. Took the stand, went through an incredible amount of information. Basically,
as we approach the top of the hour, we need to step aside, take a break, and we have a short programming note here, a new Court TV special on the cases that are Black History in the Making. Airs tonight. Court TV anchor Michael Ayala will have an all-star panel with him, including attorney Benjamin Crump, Mark O'Mara, of course, the man who defended George Zimmerman, who was later acquitted of killing Trayvon Martin. Also on the panel, our favorite Court TV guest, C.K. Hoffler, will be there. Michael will take a look back on the black icons of the past and talk to the panel about the cases changing the course of history as we know it. And I'm sure they'll talk about the Supreme Court nominee announced this morning as well, formally announced later. You can watch it tonight, 7 o'clock, 6 Central, right here on Court TV. When we come back, we'll pick it up right where we left off. It's closing arguments in the movie Popcorn Murder Case. Stay with us.
2 loads of snot.
Court TV and a busy Friday. We're watching 2 trials play out this morning here. First in Louisville, Kentucky, former police officer Brent Hankinson's actions on the night of the police raid where Brianna Taylor was killed is the focus of the trial. Prosecutors claim that Hankinson went against protocol when he fired his weapon, endangering the lives of Taylor's neighbors. You can watch that trial, if you'd like, over on courttv.com. We're streaming it there and on our YouTube channel, and of course then in Florida. Today is a big one. Its closing arguments are underway this morning in the movie Popcorn Murder trial. Defendant Curtis Reeves spent all of yesterday on the stand testifying to what he claims happened just before he shot moviegoer Chad Oulson. He told jurors that he thought he saw Oulson throw a cell phone at him. But surveillance video was shown again with Reeves on the stand, and at times it left him seemingly without answers. Now let's take you back into that Dade County courtroom. Prosecutor Scott Rosenwasser is delivering his closing argument. We're picking it up right where we left off.
This was the testimony, I believe. Dr. Adams was speculating about all the possible events that could happen to the human body. At some future time, in some unknown way, with some unknown variable, hitting some part of the body might possibly, maybe, hurt somebody or kill them. That was basically his testimony. But here is really the telling moment with Dr. Adams. Now remember, of course, he's being paid. Now, I'm not telling you that people that come to testify shouldn't be paid. They got to pay their bills. Of course they should be paid. But you can consider that as part of their bias, right? So he's paid $450 an hour. Now think about this. What's important in this case? Well, we have eyewitness testimony, we have a video that Chad Oulson did reach over. He should though, okay? And he grabbed the bag of popcorn, he flicked it, and as his hand was coming back, once that act was completed, he was shot and killed. Nothing was happening from that moment on. His hand was coming back from the popcorn, and that's when he was shot. So, the defense asked Dr. Adams, well, why don't we see stippling on his fingers? And the answer was, now you rely on your own recollection. Remember, what the attorneys say, it isn't evidence. If I recall, he said that because he had a fist, that's why there was no stippling. Well, Mr. Martin got up, and Mr. Martin was cross-examining him and said, well, at a previous time, didn't you say that it was because his fingers were outside the cone of the stippling? Oh, no, I didn't say that. And they went back and forth for a little bit. So finally, the document is shown to Dr. Adams, and what's he say? Yeah, you know what? Now think about this. This is a very intelligent guy. He used to be the head of the medical examiner's office. I didn't understand Mr. Martin's question. So Mr. Martin said, well, today you said you didn't understand the question, and I asked it again. You didn't ask during that sworn statement for me to repeat it. You must have understood it. Again, he's not some bozo. He's a very intelligent person. Now, how is it then that he didn't understand such an important question? I mean, that's a really important question in this case. Well, once he's confronted with it, and he's like, well, gosh, I really can't say that. I mean, I had to have understood it. Then what did he say? The court reporter took it down wrong. Because she's got some motive to do that. I mean, you can mistype a word, you can misspell it, you can switch a word around, but you can't change the entire context of a statement. I mean, just Dr. Adams wasn't credible. Dr. Foley, we already talked about him. That's the x-rays. Actions speak louder than words. We're not going to go through all of Jennifer Shaw's testimony again. Dr. Cohen came in, and she told you that when people get older, they age, and their bodies change. And you know what? When people get older, they do age, and their bodies do change. In fact, the defendant was older, and his body changed. Doesn't mean a single thing. Let's say he was sitting in a theater with 2 broken legs and a rotator cuff injury, and someone threw popcorn on him. Oh, well, now that he's got 2 broken legs, he can shoot and kill somebody. That totally makes sense. You know what? His back's hurting really bad. He's got a herniated disc. Popcorn goes on him. Yep, absolutely. We can kill him. Sure, you get older, you can just kill people. But actions speak louder than words. All of that testimony are shiny objects. And she talked about people perceiving themselves as vulnerable, and if they perceive themselves as vulnerable, that's why they may do a certain action. Is the testimony and the evidence and the video in this case, does it demonstrate that the defendant perceived himself as vulnerable? Absolutely not. Did he try to de-escalate things because he felt vulnerable? He leaned in twice to Chad Oulson. He instigated. He started. Did he perceive his health as deteriorating? I mean, all these little things we talked about seem so silly, and I almost hate to bring them up. But the week before, he's hunting and going up in trees. That day, he drives. It sounds silly, but his wife could have driven. Could have dropped him off at the front if he was such and such poor shape that day. They chose the back row, for crying out loud, all the way in the middle. If your back hurts, you're going to sit at the aisle because you don't want to walk around people. We all know how uncomfortable that is. And yes, of course he used the wall for balance. No one wants to step on people's toes. If you have such concerns for your safety and you perceive yourself as vulnerable, you don't do a single thing the defendant did in this case. And it just goes along with his statement. It's so untrue. And that's why you keep going back to, it sounds sensationalized, but he started it, he ended it, and he killed someone over a popcorn toss. The last shiny object, and then we're going to talk about the facts of the case with the law. Cell phone DNA. The more you talk about it, the louder you talk about it, just makes it shinier. Look over here, don't look over here. Why is there no DNA on that cell phone? I mean, obviously you all know why. There's no way ever in any fact pattern.
Judge, I'm going to object. That's a misstatement of the evidence. There is DNA on that phone.
Okay, I'll rephrase it.
Thank you.
There is DNA that is uninterpretable on that phone. It doesn't matter. It literally doesn't matter. There is no way ever that phone was used in this case against the defendant. Ever. Not a single witness sees this phone event take place. And his wife, who's sitting next to him, do you think that she would have seen a violent attack with a cell phone happen if she's sitting right next to him? Oh, I closed my eyes. Come on, really? All the people in the theater didn't see it. The silent witness video doesn't see it. The defendant has no injuries. How in the world is that even remotely possible? Oh, that's right. His left eyelid had a red mark behind his glasses. Now, the only reason I had his glasses passed around is just to show you that the hard part on the nose is there, like on most glasses, and if he was hit in the face, he'd have a mark. It'd cut him. If it was that hard that he literally thought he was going to die at some point because that's how violent Chad Oulson was, the most easily bruisable person, because he testified he's easily bruisable. Jennifer Shaw testified he's easily bruisable. A phone is thrown at him. Now he changed his story. First he said he was hit with a fist. Maybe the hand had a phone in it. Now the phone was thrown at him. This phone never, ever touched him in that manner. Ever. Ever. And if you remember, there's so much information that comes about sometimes. You know, you almost have to be like an encyclopedia of knowledge. If you remember back when he was testifying, he said something really interesting if you caught it. Okay? He said, because you couldn't see Chad Oulson in the picture frame, that he was too far away from him when he threw that phone. Very interesting that he said that. But here's something else. Remember, he changed his story. Because in the post-Miranda statement, when Chad Oulson jumped up, the popcorn fell. So based on his statement, and you have to listen to the whole thing because he talks about it and then they go over it. He says the popcorn went by the wayside almost immediately. Which means when you see that video and Chad Oulson standing up, we shouldn't see the popcorn, or we should see it fall. But what we really see is popcorn being tossed and then a shot takes place. That's how we know with 100% certainty the defendant wasn't being truthful. But what's he say? He says that when Chad Oulson stands up and the popcorn falls by the wayside, it's at that time this attack happens that's not seen on video or by anybody in the theater, including his wife. And he says at that time is when he was hit by the phone. But he doesn't really know, because when he looked down, he saw the phone, so he just put two and two together. But on the stand, he talks about this phone attack happening 8 seconds before. How in the world is that? He changed his story. Now we have two unreasonable stories I submit to you. Self-serving stories don't equal self-defense. If he was hit by a phone, or even if he was hit by a fist from a 6'2" person who's raging mad, how in the world does he not have an injury other than a left eyelid behind glasses? You know why? Because it didn't happen. He was explosive and he was mad about the popcorn. That's what this case is. He started it and he ended it. Those are the shiny objects. So let's talk about what this case is. What's the credible evidence? You take those shiny objects, you put them away. What's the credible evidence in this case? We know that the Oulsons came to the theater on a Monday. They dropped their daughter off at daycare. They sit in the theater, second to back, last row. We know at some point one of them wanted another piece of candy or something. Chad Oulson goes out to the concession stand and comes back. I believe if you look at the video, it looks like they're there first. It doesn't matter. Then the defendant and his wife sit behind them. He has his phone. He's not talking. He's not conducting business. The light's on. Previews come on. Now, according to Jane Roy, who doesn't know anybody and would have no reason to come in here, say anything other than what she observed, she said almost immediately after the cell phone message came on, boom, here comes the defendant. Now, it's the previews. I'm not saying he should have his cell phone on. Certainly doesn't justify what happened to him. And do you really believe that this cell phone light was so incredibly bright that it was ruining his movie experience for the previews? Anyway, that's not even a big issue whatsoever. So what happens? The defendant leans in. Now, I submit to you, based on all the evidence that you've heard, he does not lean in and say, "Sir, I'd really appreciate it if you would just turn your cell phone off." No. Not the guy that is into the adrenaline and the danger and likes to be in control. Nicole Oulson and Jane Roy, who don't know each other, testified about the defendant's demeanor. He leaned in and he was telling Chad to turn his phone off. He did it twice. Now, would a person who perceives himself as vulnerable, oh, yeah, I don't want, I got a lot of things going on. I don't want to really get into any roughshod, and I can always de-escalate it with my background training experience. Does that guy get up right away to go to tell the manager? No, he's got to lean in a second time and tell him he's going to the manager. Why do you have to tell someone you're going to the manager? Get up and go to the manager. But he wants Chad Oulson to know. So he leans in and tells him.
The passion is flowing to this morning in the close. Let's take a break here, pick it up right where we left off. Stay with us.
In honor of Black History
popcorn murder trial is nearing its end as attorneys are delivering closing arguments today. Defendant Curtis Reeves has gone to great lengths to tell jurors that he claims he acted in self-defense when he shot and killed Chad Oulson in a movie theater back in 2014. He told jurors his account from the witness stand, testifying on his own behalf as the victim's wife sat silent in the gallery. Reeves said he viewed Oulson as a volatile man when he asked him to put his phone away. And he claimed that he tried to de-escalate the situation before he fired his weapon. This morning, the state has been arguing that Reeves fabricated an unbelievable story about his encounter with the victim. Here's more from prosecutor Scott Rosenwasser and his closing argument.
So he leans in and tells him. So he gets up, he goes. Now, what does Jane Roy say? He's mumbling to himself. He appears agitated, he appears angry. And this is when it starts to begin, when we're talking about ill will, hatred, spite, or evil intent. And it culminates, whatever how many minutes later it is. I don't know if it's 3, 4, 5, it doesn't matter. But it culminates after the popcorn when he explodes, throw popcorn in my face. This is when it starts. Because Chad Oulson, should he have turned his phone off? Sure. But he's like, look, man, just leave me alone. Mind your own business. Do what you gotta do. So he gets up and he goes to the manager. Jane Roy testified that he appeared agitated. Now, we have a video that's in evidence, you watch it. I'm not saying that he was at the desk yelling and screaming. Witnesses came in and said, okay, he was there and he was talking. Now, these witnesses testified, I think her name was Simpson and maybe Mr. Peck, that, well, he came, he was telling us about what happened, he was polite. But when you watch his mannerisms, he could very well be polite, but he was certainly agitated. And remember something that Vivian Reeves testified to. These are just little nuggets. If you don't recall it this way, absolutely do not just take it from me. You have to rely on your own memory. But even she said she was kind of ticked off. Now, he goes and he tells the manager. Now, he doesn't tell the manager. What could he have done? He could have stayed and waited for the manager to go. But when I asked him that question on cross, well, what did he say? Oh, the manager told me to go back. He still could have stayed there. He could have waited for the manager. Just because the manager tells him to go back, all of a sudden, oh yeah, I'll just... If he was really concerned, could have waited for the manager. So he goes back into the theater. Now, this is where I submit he was being truthful. He goes back into the theater, and what happens? Chad Oulson, either he put it away or he turned it off. It doesn't matter. It truly doesn't matter. The point being this. The issue has been resolved. Everyone can enjoy their movie experience. So what does the defendant do? The person that's trained in de-escalation, does he sit back down in his seat and let it go? What's he do? He initiates again. He pokes him. I see you put your phone away. I wouldn't have had to go telling you. Why in the world does he have to say that? Because he's the alpha male. He wants to let him know. Because he's used to being in control. It's like getting in the last word with a kid. It's spiteful. He could have just sat right down. So Chad Oulson, what's he do? Well, as the defendant states, because there are some gems in there, okay? The defendant states that he then turns around in his seat, and it's a big difference, in versus jumping up. Now, the reason that I gave those photos to you, the defense photos, was for you to see with your own eyes that he was, in fact, turning around in his seat to have this conversation. And who's that consistent with? Derek Friedoff. Remember what Derek Friedoff's testimony was? Going back before the manager, Derek Friedoff testified he heard bickering. Bickering's an interesting word to choose. When your kids bicker, you know your kids are kind of like back and forth. They're not having a friendly conversation. There's bickering. So when the defendant wants you to believe, sir, I'd really like for you to turn your phone off. That's not what Derek Friedoff testified to. And what did Derek Friedoff say? When he went to the manager, everything settled down. Homeostasis, everything's fine. And when does the bickering start up again? When who is reintroduced into the equation? The great instigator. And now it's back up again. Because he started it and he ended it. So Chad Oulson turns around in his seat, and I gave you those pictures to look at, because had he been standing, he would have looked the way that he looked at the time that he was shot, at the time that the popcorn came into play. He's standing there, he turned around in his seat before. Now remember, Derek Friedoff told you, and even the defendant said this, at no time was Chad Oulson turning around prior to the popcorn and initiating a conversation with the defendant. He was always looking forward. He was the one out of the two that was trying to de-escalate it. Now, he could have remained quiet, but I submit to you the defendant would have just kept going and going and going. But he's looking forward. Leave me alone, sir. Leave me alone. If anybody, Chad Oulson is trying to de-escalate the situation from the person that's instigating it. So what happens? The credible testimony is this, that at some point in time, he does get up. And at some point in time, it's clear as day what he does. He leans over and he grabs the popcorn and he flicks it on. Is it reasonable to believe that this defendant, with all his background, training experience, and his karate experience that we're going to absolutely address in a little bit, felt that when that popcorn bag was grabbed from him, he was going to die? Because that's what some of the instruction for the law of self-defense is. Did he reasonably believe he was going to die right then and there? There is no way in the world. Or did he reasonably believe that he was about to suffer great bodily harm? Now, there may be an argument made, well, you know, he didn't know that he was going for the popcorn. He just saw a hand coming at him. We're going to address that whole thing right now. First of all, we know it's about the popcorn because that's the statement. Don't lose fact of that. Okay? If you hear, oh, a hand's coming at him, he reasonably believes because a hand was coming at him. No, he killed them because of the popcorn, because he said that right after the shooting. Throw popcorn in my face. He knew what happened. It's not just a hand's coming towards him. He knew what it was. And when you watch the video, you see the popcorn and you see from the hip the shot. That's this case. Let's say you want to make the argument that he didn't know about the popcorn. You'd have to disbelieve Derek Friedoff, Mark Turner, Charles Cummings. And let's say you want to make the argument he saw a hand coming at him. Did he reasonably believe that that hand was going to kill him? Absolutely not. Did he reasonably believe that that hand was going to punch him so hard that his orbital bone was going to fracture and go into his brain? Come on, no, that's unreasonable. And you can't shoot somebody for punching you. You can't. Oh, he's vulnerable. That's what no, he's not. He's an instigator. He's not this vulnerable person. Okay, so he's sore. You can't kill anybody for that. So Chad Oulson stands up. Now, there's a lot of dynamics going on. He grabs the popcorn, he tosses it, he's shot and killed. In that time frame, Nicole Oulson's standing up. And how is it no one sees this royal battle? How is it? How's that? How does Vivian Reeves, who's right there, not see this battle? If you want to say, well, Nicole Oulson's saying there's no battle because she's got an interest in the case, how does Vivian Reeves not see a battle right in front of her eyes? How does no one hear or see this life and death struggle? Because remember, I asked him on the stand, was this a life and death struggle? Oh yeah, this was a life and death struggle. In my entire career, I've never seen anything like this. Come on. So he shoots and he kills Chad Oulson and basically shoots off Nicole Oulson's finger. And we know why. So what's the law in this case? What was the defendant charged with?
All right, let's get a quick break in here. We'll pick it up right where we left off. Boy, what a closing argument. Back with more after this.
This is an important message for everyone.
Welcome back to Court TV Live. The fate of defendant Curtis Reeves will soon be in the hands of a jury. After attorneys finish their closing arguments, that jury will be tasked to decide if the defendant acted in self-defense like he claims when he shot and killed Chad Oulson in a movie theater. He's accused of second-degree murder and aggravated assault for the 2014 incident. Did the defendant hours on the witness stand yesterday, telling the jury about his long career in law enforcement and then about the day that he shot and killed Oulson in the theater. We'll soon find out what effect, if any, his testimony had on those 6 jurors. Now, back we go to Dade County and the courtroom right where we left off. Prosecutor Scott Rosenwasser is on a roll delivering his close.
There's a lot of laws that apply to this case. At first glance, it might seem confusing. It's going to be like a law school class. And we're going to talk about it. So, the defendant has been charged with second-degree murder. When you hear murder in the second degree, it's the same exact crime. For whatever reason, in the jury instructions, they flip them around. It's the same crime. He's also been charged with the crime of aggravated battery. That's for shooting Nicole Oulson. Now, at the beginning of the instruction for second-degree murder, you're going to hear about this. This is called Introduction to Homicide. This is either going to work or it's not going to work. We're going to say that it's not going to work right here. It'll work. That's all right. I'll give you a second. All right. So let's use this one just for now. Okay. Don't need that other one. All right. So Introduction to Homicide. Make sure everybody can see this. If I put this right here, can everybody see it?
No.
Can everybody see this now? Okay. All right. Introduction to Homicide. So this is the instruction that you're going to hear. In this case, Curtis Reeves is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which we're going to talk about, which is unlawful. A killing that is excusable or was committed by the justifiable use of deadly force is lawful. If you find Chad Oulson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. So let's talk about justifiable homicide. This is the instruction. The killing of a human being is justifiable homicide and lawful if necessarily done. So let's talk about that. Every word in jury instructions is important. Okay? Necessarily is very important in this instruction, meaning, was it absolutely necessary and it makes sense? Because if you're taking a human life, you got to be 100% sure. There's no gray area when you're taking another person's life. It's justifiable homicide and lawful if necessarily done while resisting an attempt to murder. Okay, we'll just throw that one out. We know there's no attempt to murder the defendant. While resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house. All right, so this last sentence here is about in the home, doesn't apply, we're in a movie theater. Okay? So was it necessary while resisting an attempt to commit a felony? All right, so let's talk about that. And that's why I'm talking to you about necessary. Okay? We're going to talk about this in just a second. I just want you to keep that in mind. Okay? Is it necessary? That's justifiable homicide. Then you learn about excusable homicide. Now, here's excusable homicide. Can everybody see that? The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Now, the reason that when I started my cross-examination with the defendant, I asked is, was this an accidental shooting or did you intentionally shoot him? You know, me and well, why would we ask that question? This is exactly why, just to cover. Okay? This is not an accidental shooting. This is an intentional shooting. It's just that he's saying he intentionally shot him and it was lawful self-defense. Everyone understand what I'm saying? This is not an accidental shooting. It's an intentional shooting. He's just saying he had a defense to it, which I submit to you obviously wasn't very credible. All right, everyone understand that? That's what this means. When the killing is committed by accident and misfortune in doing a lawful act. So let's say someone's cleaning their gun and the safety's off and the table leg breaks and the gun falls and someone dies because the gun went off. That is an accident and misfortune. The defendant intentionally shot Chad Oulson, so none of these apply. By law, though, you might say, well, why are we hearing about these then? Because the law requires that you hear this. That's why you're hearing it. The law requires it. When the killing occurs by accident, number 2. Number 3, committed by accident, and it talks about a dangerous weapon not being used, okay? Accident, accident, accident. This whole instruction doesn't apply, okay? Number 3 talks about a dangerous weapon, okay? And then there's a definition. A firearm is a dangerous weapon. So the whole excusable homicide doesn't apply to this case. Again, the law requires you hear it. That's why I'm telling you about it. So what's the crime of murder in the second degree? So here, remember we were talking about at the beginning of closing arguments that crimes are built of elements. And when you go to school, the way people explain it are their building blocks. And we have to prove each of these elements to you for the crime. The way it works is this. There's a highest crime that's charged. The highest crime that we've charged in this case is called murder in the second degree or second degree murder. Again, it's interchangeable. If and only if you feel we have not proven that crime beyond a reasonable doubt, do you go to the next one that we're going to talk about, which is right here, manslaughter. Okay? We're going to talk about that one in a second. This is the main crime that's charged. When you deliberate, you start with this one. You take all the credible evidence, and you take those facts, and you go down the line. Okay, number 1, Chad Oulson is dead. Obviously, we have that. So we know that element's satisfied. Okay? So that's how you analyze a case as a juror. So let's talk about what second-degree murder is. Element number 1, did we prove that? Yes. Element number 2 and element number 3 go together, and that's basically what the defense is in this case. Element number 2, the death was caused by the criminal act of Curtis Reeves. Number 3, there was an unlawful killing of Chad Oulson by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Then there's definitions. An act is imminently dangerous to another and demonstrating a depraved mind if it's an act or series of acts, and then there's more things. So you take all the credible facts and you apply them to the elements. Would a person of ordinary judgment, would that person know it's reasonably certain the act was an act reasonably certain to kill or do serious bodily injury? Okay, if you shoot someone basically in the chest, obviously a person of ordinary judgment would know that act would kill somebody or seriously injure them. Number 2, we're going to save for a minute. Number 3, the act, which is the shooting, right? That's the act. Okay? So was the shooting, would a person with ordinary judgment know shooting person in the chest could result in death? Yes. That's number 1. Number 3, is shooting someone in the chest a nature, is that an act that itself indicates indifference to human life? Absolutely. If you shoot someone with a firearm in the chest, obviously it's an act that's indifference to life. The one that we need to discuss is that this act, the act of shooting, was the defendant shooting Chad Oulson, an act done from ill will, hatred, spite, or evil intent. Now that's the issue for second-degree murder. So in order to determine whether or not when he shot him, he was acting from a place of ill will, hatred, spite, or evil intent, that's when you go back to the totality of circumstances that we had just been discussing. In a very summarized fashion, it's the cell phone light bothering him. That's the beginning. The interaction, the instigation to have that cell phone turned off. When it's not, to get up to go tell the manager, to come back and reinitiate the contact. That's all evidence of ill will, hatred, spite, or evil intent. And when he takes that firearm out and he puts it to his side, when he slides it up from that pocket, because I submit to you that's exactly what happened. And when that popcorn went on him, he lunges. Again, you have to watch that video because it's very powerful to see. It's like he's saying, and that action in and of itself, when you look at everything, was done from ill will, hatred, spite, or evil intent. Coupled with the statement.
The great instigator is what Scott Rosenwasser calls the defendant. He says he started it and he ended it. We'll take a break, pick up right where we left off as he concludes his opening statement. Then, our closing argument? Then the defense with an opportunity to address this jury one final time. Stay with us.
Buckle your seatbelts.
Welcome back to Court TV Live. Let's shoot back into the courtroom. We're going to pick it up right where we left off with the closing arguments.
However it was worded from the witnesses, the impact of it is throw popcorn at me, throw popcorn in my face. In other words, who are you to throw popcorn at me? And he lunges forward and he kills Chad Oulson. Do all those acts show you that when he shot Chad Oulson, that he did it with ill will, hatred, spite, or evil intent? And I submit to you, it does. He started it, he ended it, and it was a man that was killed over a popcorn toss. Now, if you do not feel that we have proven the case beyond a reasonable doubt for murder in the second degree, then and only then do you get to manslaughter. Now, one other thing that I want to bring up about second degree murder. On the verdict form, you're going to see what are called interrogatories. So on the verdict form, there's questions after the crime. So let's say that you believe, and I submit to you, we've proven that case beyond a reasonable doubt. You would check off that the defendant is guilty of murder in the second degree. Then there's 3 questions, and you would only check one of them. And it will say, did the defendant, I'm paraphrasing a little bit, did the defendant possess a firearm? The next one would say something to the effect of, did the defendant possess and discharge a firearm? And then the third one would say, did the defendant possess, discharge, and cause great bodily harm or death? Now, obviously, that's what this case is about, and you would check the third question. By law, you have to have all these things done. That's why I'm telling you about them. All right, so if you feel as though, and I submit we have proven that case beyond a reasonable doubt, but if you feel as though we haven't, the next crime is called a lesser crime. It's called manslaughter. This is the law of manslaughter. Element number 1, Chad Oulson is dead. Obviously, that's been proven. Then you can do 2A or 2B. Curtis Reeves intentionally committed an act. Did he intentionally shoot Chad Oulson? Yes. That caused the death of Chad Oulson? Yes. You really don't have to go to 2B. If you go to 2B, you have to read, there's a long instruction. I'm not going to read it to you. You're going to have it in your jury packet, or Judge Barthel's going to read it to you. But really, 1 and 2A is fine. So what's the main difference between murder in the second degree and manslaughter? Whether or not someone acted with ill will, hatred, spite, or evil intent. That's the only difference. So if you find that the defendant shot and killed Chad Oulson, but it just wasn't legally justified, it was not a lawful shoot, it was a bad shoot, that would be the crime of manslaughter. Murder in the second degree is if based on the totality of circumstances, ill will, hatred, spite, or evil intent. So manslaughter is a lesser included crime. If you do not feel as though we've proven second degree murder beyond a reasonable doubt, there can absolutely be no doubt. I submit there isn't for murder in the second degree, but it's certainly manslaughter. This was not a justified shooting. Absolutely 100% not a justified shooting. That would be manslaughter. Under manslaughter, there would be 1 interrogatory, and it would just say something to the effect of, was a firearm used, or something like that. The other crime that the defendant's been charged with is the crime called aggravated battery. Okay, and again, you're going to hear all these instructions. Aggravated battery is basically this, that the defendant intentionally touched or struck Nicole Oulson against her will, okay? And it sounds silly, but this, you just have to bear with me for the explanation. He shot her, so obviously he intentionally touched or struck her against her will. You don't have to use your own body if a shooting counts, because he was the mechanism behind touching or striking her against her will. In committing the battery, did he intentionally and knowingly cause great bodily harm to her, permanent disfigurement, or permanent disability? Well, her finger was basically shot off. You saw the photographs. Or, number 1, did he intentionally touch or strike her against her will? Yes. Number 2, in committing the battery, did he use a deadly weapon? That's probably maybe the easier way. Yes, he used a firearm. Okay, weapon's a deadly weapon. If it's used in a way likely to cause death or great bodily harm, that's the definition you'll get. Obviously a firearm. Okay, so that's aggravated battery for shooting Nicole when she had her hand up. Now, if you think, well, How could that be? Well, there's a law called transferred intent. And here's the law for transferred intent. Basically, if a person intends to shoot a person, so if the defendant intends to shoot Chad Oulson, and in the process shoots a different person, Nicole Oulson, the law transfers the intent to shoot the intended person, Chad Oulson, to any person who was actually shot. So it sounds kind of circular, but because he intended to shoot Chad, and Nicole had her hand up, and he shot Nicole, the intent is transferred to her. Now, the caveat to that is if you find that he was acting in self-defense, then it doesn't apply. Okay? That would be the caveat to that. So what's this case really about? Okay? The defendant is claiming that he lawfully acted in self-defense, that there was a justifiable use of deadly force. This instruction is a little bit complicated. I'm going to go through it just to explain what it states. An issue in this case is whether Curtis Reeves acted in self-defense. It's the defense to the crimes of both second-degree murder and manslaughter. If the death of Chad Oulson resulted from the justifiable use of deadly force, and deadly force, of course, means what happened here, the defendant shooting him with a firearm in the chest. Now, that reminds me of something that I need to address. Real quickly, at the very bottom on my board, and you're going to get this instruction, we do not have to prove for second-degree murder that the defendant intended to kill him, just that he intended to shoot him. And the fact that he died is fine, if that makes sense, okay? Not that, him dying, of course, is not being fine. But we don't have to prove that when he shot him, he meant to kill him. We just have to prove that he shot him and he died, okay? That's what this means. In order to convict a second-degree murder, it's not necessary for the state to prove the defendant had intent to cause death. Just that he shot him and he killed him, okay? Just a little teeny distinction. All right. Back to justifiable use of deadly force. Again, every word in here is incredibly important. The use of deadly force is justified if Curtis Reeves reasonably believed. So remember, in the first instruction, was it necessary to kill Chad Oulson? Absolutely not. Here, did Curtis Reeves reasonably believe that the force was necessary? So you kind of paraphrase that. The use of deadly force is justifiable if Curtis Reeves reasonably believed that shooting and killing Chad Oulson was necessary to prevent his imminent death or great bodily harm to himself, while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older. All right, so that seems like that's like a loaded paragraph. Let's break it down, okay? There's a crime called battery, okay, and we talked about it. I was cross-examining the defendant about it. Battery is when you intentionally touch or strike someone against their will. Bob is walking down the street, he punches Joe. That's a battery. He slaps Joe, pushes him, trips him.
We need to step aside and take a short break. A quick programming note, a new Court TV special on the cases that are Black history in the making airs tonight. Court TV anchor Michael Ayala will have an all-star panel with him, including attorney Ben Crump, Mark O'Mara, of course, the man who defended George Zimmerman, who was later acquitted for killing Trayvon Martin. Also on the panel, trial attorney and frequent guest here on Court TV, C.K. Hoffler. Michael, we'll take a look back on the Black icons of the past and talk to our panel about the cases changing the course of legal history as we live it. You could watch it. It's tonight, 7 p.m., 6 o'clock Central, right here on Court TV. We're going to step aside and take a break as we approach the top of the hour. More closing arguments in the movie Popcorn Murder Trial. We'll pick it up right where we left off after this.
I absolutely hate
the hour. Welcome back to Court TV Live. We're watching two big trials play out this morning here at Court TV. First in Louisville, Kentucky, former police officer Brett Hankinson faces 3 counts of wanton endangerment for firing his gun in the raid that ended in the death of Brianna Taylor. Prosecutors claim that Hankinson neglected protocol when he fired his weapon, endangering the lives of Taylor's neighbors. You can watch testimony today on our website, streaming at courttv.com, along with our YouTube channel. And in Florida, closing arguments underway this morning in the movie Popcorn Murder trial. Defendant Curtis Reeves spent all of yesterday on the stand testifying to what he believed happened just before he shot moviegoer Chad Oulson. He told jurors that he thought Oulson threw a cell phone at him, but when he was shown the surveillance video again on cross-examination, he didn't have a lot of answers for that. Let's take you back into that Dade City courtroom. Prosecutor Scott Rosenwasser is delivering his close. We'll pick it up right where we left off.
Throws popcorn on him, throws soda on him. That's a battery. That's a misdemeanor crime. Now, if someone is over the age of 65, it becomes a felony only because of the age. That's the only difference, which is why you're hearing about this crime. Battery over 65. So Bob and Joe are walking down the street. Joe is now 66, 69, let's say 71. And Bob pushes Joe or punches Joe. It's a felony, but because he was over 65. That's it. So, looking back at this instruction, the use of deadly force is justifiable if the defendant reasonably believed that shooting and killing Chad Oulson was necessary to prevent imminent, meaning right then. Would it be reasonable for the defendant to think, at that time sitting in the theater, with the lighting condition as they were, where people can see, people can hear, is it reasonable to believe, would a reasonably cautious and prudent person believe they were about to die? Absolutely not. So shooting and killing Chad Oulson wasn't necessary to prevent imminent death or great bodily harm to himself. Okay, great bodily harm. There's a definition for great bodily harm. It doesn't include bruising. It doesn't even include moderate harm. It is what it is, great bodily harm. Would a reasonably cautious and prudent person in the defendant's position, with all this training about de-escalation tactics, would a reasonably cautious and prudent person believe that as he sat there and the hand came across and grabbed that popcorn, that he was about to suffer great bodily harm? No. This is not a justified killing. Absolutely not. Now remember, don't lose fact of what the sentence was that he said, because it's not just a hand coming towards him. He knew popcorn was thrown at him. He knew that bag was grabbed. And when you watch the video, you can see it. The bag, the popcorn, and he shoots, and he lunges forward. And he says, don't throw popcorn at him. He knows it. It's not just a hand coming in that's so important. But again, let's just say for some reason you want to discount that. A hand coming in does not lead a reasonable person to believe they are about to just be beaten to a pulp. It's simply not true. And he started it. And this felony offensive battery is only because of his age. That's it. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death. We already talked about that. Or great bodily harm. We talked about that. Or the imminent commission of, there should be a Y here, but imminent commission of aggravated battery against himself or another. So let's talk about that. We got to break that one down. Did he have to kill Chad because he felt he was about to die? The answer we've already covered is no. Did he kill Chad because he thought he was about to be beaten to a bloody pulp? by a hand just coming in. Again, don't focus on that. He says the popcorn, he knows about the popcorn. So none of this applies. So let's talk about where the imminent commission, meaning about to happen, that's what it means. Imminent commission of this crime. Was he about to have an aggravated battery committed against him? Okay? So what's the evidence in this case? And you really got to analyze this. The evidence is this. He reaches in and he grabs the popcorn. He brings it back, he throws it. His hand is on his way back. Nicole Oulson has her hand coming up. He's killed. Is there anything that is about to happen? No, because he had already just completed the act. In fact, he wasn't even so far back to start anything because he was shot for throwing the popcorn. Did he shoot someone because he was about to be attacked? No, the popcorn had already been thrown and that event was over. And you can see it in the video as well. He throws it and as his hand's coming back, that's when he's shot and killed. There's no imminent commission of anything else. Now, let's say that the fact pattern was that he throws the popcorn and he stands there for a couple minutes and now he starts to jump over the seat and attack him. That would be a fact pattern that would apply here for this instruction. But in this case, the video shows you that he had thrown the popcorn, his hand was coming back, and that's when he was killed. And it's all about the popcorn. That's why the defendant is not justified in killing Chad Oulson. That's what these instructions say. Now let's look at this paragraph because it's extremely important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used, meaning the shooting. At the time of the shooting, what were the circumstances? Okay? I know I'm repeating it a lot, but it's so important. At the time that the defendant shot and killed Chad, he had already thrown popcorn on him, his hand was coming back, and he shot him because of the popcorn. That's the circumstances. So at the time he shot him, what was happening? His hand was coming away. And he knew it was about the popcorn. Despite what he says in any of his statements, both of them, that actually contradict each other, that's not believable. Those are the facts. Now, the danger facing Curtis Reeves need not have been actual. Now, I blew this particular part of the instruction up because it's really important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances. That's what we just discussed. The danger facing Curtis Reeves need not have been actual. However, this is what applies. It need not have been actual. However, to justify the use of deadly force. So the danger facing Curtis Reeves need not have been actual, but in order for him to shoot and kill Chad Oulson, the appearance of danger must have been so real that a reasonably cautious and prudent person under those circumstances would feel that the only way to avoid what happened was to kill Chad Oulson. Okay? Now, what would be an example of this? Because it's not this fact pattern. This fact pattern doesn't even come close to this. Okay? The appearance of danger must have been so real. Okay? The defendant is sitting in his chair. He's just instigated this person. He reaches over and grabs the popcorn, and now it's coming back. That's the circumstances. That's it. Okay? There's no imminent commission of anything. He had just completed throwing the popcorn. Again, we know it's about the popcorn from the statement. What would be an example of this? Okay? Because it's very important not to be confused by what this means. Here's an example of how the appearance of danger must be so real that a reasonably cautious and prudent person would think they have to kill another human being. Two people get in a road rage incident. They pull over to the side of the road. Driver 1 gets out. Driver 2 gets out. Driver 1 starts making some threats to driver 2. I'm going to kill you, I'm going to kill you. Okay? Now, in this case, there's no threats like that. Now, the defendant wants you to believe there's threats. But remember, not a single person hears any of these threats because it didn't happen. Driver 1 gets out, driver 2 gets out. Driver 1 is threatening to kill driver 2. Driver 1 suddenly turns around, runs back to his car, reaches in, grabs his wallet, turns around with this black object. Driver 2 is like, oh my God, this guy just said he's going to kill me. He's turning around with a black object. I'm going to have to kill him. Bam! The appearance of danger was so real that a reasonably cautious and prudent person under those circumstances would realize that shot had to be taken. That would be a perfect textbook example of what this means. Because he was just threatened. Someone was going to kill him. The guy turns around and runs back to his car. He grabs a black object. Now, could that wallet have killed driver number 2? Of course it couldn't. But the appearance of danger was so real. He threatened to kill him. He ran to his car. He grabbed the black object, and he suddenly turned around. Any reasonable person under those circumstances would say, yeah, I can see how that guy would think that a gun was just taken out. Obviously, that wallet couldn't kill him. But
Quick break. We'll be back right after this with more of the prosecution's closing argument. Stay with us.
Police officer shot and
to the courtroom we go. We'll pick it up right where we left off as the state finishes up its first half of its closing argument.
I would have shot him too. Textbook example of what this phrase means. It does not mean that because Curtis Reeves, in his mind, believed this imaginary attack happened, that he's justified. Because a reasonably cautious and prudent person in his situation, sitting there, having popcorn just dumped on his lap, would not believe you have to take another human being's life at that moment. It even sounds crazy to mention it out loud, but that's the fact pattern in this case. This instruction does not justify killing Chad Oulson. Even if he reasonably believed that he didn't. I submit to you, he made up a story in the cruiser to cover his tracks, not realizing so many people saw it, and not realizing the silent witness video captured the whole thing. He didn't reasonably believe for a second his life was in danger. And that's why he changed his story from his post-Miranda statement. Because think about what he did. Think about this. He went from one attack to two. Because what does he get by changing his testimony to two attacks? This reasonable belief that something's happening. The day of the shooting, again, I submit to you this story is not even credible. But he says that he was attacked after the popcorn fell, completely dispelled by every witness and completely dispelled by the video. But during the trial, he changes his story to say, you know what happened? And it's funny because I asked him, you remember, I said, why? How in the world do you get these two stories? He's like, I don't know. How do you not know when you kill another human being? So why does he change his story? Because he has to add an attack. Because he knows that post-Miranda statement is so bad for him. So he changes his testimony, and he indicates this. He states, no. The popcorn didn't go to the wayside, and I wasn't attacked with him virtually on top of me. Remember, he's saying all that? Remember his first statement? So what happens is I'm sitting there, and he jumps up, and the popcorn falls by the wayside almost immediately. And now he's coming over on top of me. And I'm back in my chair. Well, that's when he was getting the gun, in reality. But let's go with his statement. I'm back in my chair, leaning back, and I got my left hand out. And I'm yelling, no, and whoa. And I'm touching his chest or his shoulders because, remember, his own words. He's virtually on top of me. He's in my lap. Well, on the stand, he's like, no, I meant leaning. What? The defense attorney is talking about minutia words to witnesses. He's changing from virtually on top of me and in my lap to leaning? Are you kidding me? How many reports do you think he's written in his life where it's important to be truthful and accurate? Come on. Because he's painting a picture that he had to kill him, not knowing there's a video out there to disprove it. So he says he's got his left arm out and he's touching his chest or his shoulders. And, I gotta kill him. I can't believe I didn't shoot my hand because my left hand's out as I'm fighting him off in this life or death struggle. That's truly not happening. And we know that didn't happen for several reasons. One, there's no stippling on his left hand. Everyone that was shot, everyone that was in front of his gun has stippling. Nicole and Chad. How is it that he doesn't have stippling on his left hand? Well, possibly it's the same reason why he doesn't have an injury from a phone that was thrown at him. He's not some magic person. It's because it didn't happen. But you don't even have to look at that common sense argument. You just have to watch the video. I played it slowly and rocked it back and forth like you can do it in the jury room to show you that what actually happened is as he's shooting out from the hip, when the popcorn hits him because he's mad, He takes that left hand, you can clearly see it in the video if you watch it, and based on his muscle memory, he slaps it against him so he doesn't shoot his hand. So when he's like, oh my God, I'm so surprised I didn't shoot my hand, watch that video. His left hand goes up, and based on his muscle memory, he immediately brings it to his chest. And that's exactly what happened here. He intentionally killed Chad Oulson because he was mad. You see it plain as day on the video. In court, he changes the story, and what's he say? In court, he says, well, I came back from the manager and he was staring at me. Now, why was that important? Because he wants to be like, I'm the great de-escalator. You know, to calm him down, I wanted to tell him everything's all right. But he didn't tell that to Detective Proctor, because to Detective Proctor, he says, I reinitiated, because that's truly what happened. Then, on the stand, he gives this version. Well, I came back from the manager, and that's when I was attacked, a full 5, 6, 7, 8, whatever the number is, seconds before. So when I saw his hand coming towards me, that's why I realized I had to kill him. But we know for a fact that didn't happen. Number one, why would he change his story? Number two, what's this first attack that happened 8 seconds before? Well, first he says that he's hit with a fist, then he says it's a fist with a phone in it, and finally on the stand he threw the phone at me from some distance. Because I demonstrated on the video that he wasn't even in the camera when it happened. Let's just go to the next illogical thing. How in the world was it that he's able to be hit with a phone and not be injured? How in the world is he hit with a phone and his wife, who's sitting right next to him, doesn't see it happen? How in the world does not a single person in a theater see that happen? How in the world is it not captured on video? How in the world does he get hit with an object so hard that he continues to go forward and not react with his hands? That's because he's trained in karate. That's what his testimony was. Not even making that up. No human in the world gets hit with a phone that hard and doesn't yell, ow, oh my God, I can't believe this, and go for their head. It never happened. None of it happened. What happened was he killed Chad Oulson for no reason other than the fact he was mad. And if you don't believe that's the reason, he unlawfully killed him, and it's manslaughter. I'm going to show you 2 pictures. I'm going to show you 2 pictures, and these pictures tell you the story. In my left hand, this is the defendant, Curtis Reeves. You may see that his left eyelid is red. From all accounts, people testified that he was touching his face afterwards. The detective indicated that he was rubbing his eye. This is Chad Oulson's picture. Did this person reasonably believe this was necessary in this case and in this fact pattern? The defendant is guilty of either murder in the 2nd degree or of manslaughter, and he's guilty of aggravated battery as well.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, we'll take let's take 15-minute recess
Okay, there it is, the first installment of the prosecution's closing argument. Remember, they get the last word as well. Up next is going to be the defense. What are they going to do to counter that? Let's talk about it quickly with civil rights and criminal defense attorney Mark Begnaud. He's in Decatur, Georgia, watching along with us. Mark, your thoughts on a very passionate closing argument from the state?
That was a heck of a closing, Ted. I thought that was fantastic. He brought a lot of energy. He brought a lot of authority. He was compassionate. I mean, from how it looked when he's talking to the jury, establishing eye contact, really talking to them, really excellent. And then the content. I mean, at the beginning when he's going through and just dicing up all of what he expects the defense to say, so many quotable moments. He came back to shiny objects a lot, kind of couching the defenses as shiny objects. It's a dismissive way to look at it, right? He's saying these are just shiny objects. These are a sideshow. They're saying, look at this, don't look at the real thing, which I found really effective. And his closing is littered with things like that, coming back to he started it and he ended it, great framing device. And then when he gets to the heart of the matter, you know, you can't claim you're old and shoot somebody. He made that point really well. You know, if somebody had broken legs and was sitting there and somebody throws popcorn on him, you can't shoot him. Somebody has a herniated disc, you can't shoot him. If you're old, you can't shoot him. I think he did an excellent job of making his case and of dicing up what the defense is expecting to present.
Yeah, absolutely. It was fascinating and really sabotaged what we're going to hear next from the defense. We're going to take a break. When we come back, it will be the defense opportunity to address this jury for the last time. Their close when we come back. Stay with us.
How's she doing?
Better now.
back. The state of Florida finished up their closing argument in the movie Popcorn Murder trial. Curtis Reeves' attorney Richard Escobar will now address the jurors in the defense close. We saw a lot of emotion the first time around. Well, Mr. Escobar has a lot of passion and emotion. We know that from watching this trial. Let's see what he does with his close.
You don't judge a person until you have walked a mile in their shoes. It's a very wise old saying, and one that actually is embodied in the laws of self-defense, not only in the state of Florida, but in this country. The Constitution of our great country embodies the right and the law of being able to defend yourself. There's a great wisdom in our laws, both nationally and here locally. A great wisdom. That wisdom in the law of self-defense starts with a term called perception. You're going to work with that term throughout your deliberations in this case, because the law protects that reasonable perception. Reasonable perception. You have to walk in the shoes of someone before you judge them. You've got to walk a mile. The law of self-defense requires us all to judge the reasonableness of that perception, not here in the comfort of a courtroom, in the protection of a courtroom with deputies that are armed to give us that security. The law of self-defense requires each and every one of us to stand in the shoes of Curtis Reeves, a 71-year-old man at the time of this incident, a decorated law enforcement officer who had countless and countless hours of training in the use of force, in the assessment of danger, and the risks that take place when we are faced with a dangerous encounter. Curtis Reeves, at the time of this incident, had more knowledge, more experience, more study in that area than anyone in this courtroom, and certainly anyone that was responsible for investigating his fate. Perception. The prosecution came up here. I think I counted, we're probably at 28 to 30. It doesn't matter. This doesn't matter, this doesn't matter, this doesn't matter, this doesn't matter. And by the way, this doesn't matter either. And this doesn't matter, and by the way, this doesn't matter either. Ladies and gentlemen of the jury, everything matters. Do not discount anything. Do not discount anything that we do and we say and we present, and do not discount anything that the prosecution presents either. because it matters. We live in the greatest country in the world that considers our system of justice the very best. And the very best because we have to consider the evidence. We have to analyze the evidence and judge that evidence. And this very court, the judge, is going to instruct you on a great deal of rules that you can apply in this case. I'm going to ask you to thoroughly review every one. We're about to start doing that ourselves. I'm going to take you first through those rules, and then I'm going to take you through every piece of evidence that came before you in this case. And it does matter. Matt, your instruction number one. So you have not guilty. The court's going to instruct you on an instruction called plea of not guilty, reasonable doubt, and burden of proof. It is the bedrock. It is the foundation of our system of justice. And one of the reasons that it's one of the first ones is that that's where we start. This is where we start, all of us, in administering justice in this very courtroom. And what does it tell us? What does the wisdom of this law tell us? It tells us that Mr. Reeves has entered a plea of not guilty. And it tells us that this means that you must, not can, you must presume or believe that he is innocent. That's how we start this trial. There's a reason for that. There's a reason for that. Because it's not Mr. Reeves' obligation to prove his innocence. It's the prosecution's obligation to prove not only the crimes alleged, but is to prove beyond and to the exclusion of every reasonable doubt that the defense of self-defense is not present. That's his proof. So we start with that presumption. And where does that presumption go? That presumption stays with the defendant as to each material allegation. At each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Very powerful instructions for the protection of our liberties. Up a little bit, man. Let me take this off first. Okay. Reasonable doubt. That's a word that, again, you're going to be instructed by Your Honor, that you're going to be considering in this particular case. And so, wherever the words reasonable doubt...
The defense delivering the closing argument on behalf of their client, Curtis Reeves. Back with more right after this.
I'm Vinny Politan. Welcome to Closing Argument.
get you back into the courtroom where the defense is delivering a closing argument on behalf of Curtis Reeves. Here we go.
Wherever the words reasonable doubt are used, reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. Such doubt must not influence you. However, on the other hand, if after carefully considering, comparing, and weighing all of the evidence, all of it, ours and theirs, there is not an abiding conviction of guilt, an abiding conviction of guilt, or even if you have that conviction, but it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond and to the exclusion of every reasonable doubt. That's your guidance in this case. And one that, no, we cannot say that doesn't matter. That is not our system of justice in America. Where do we look? Where do we look for that reasonable doubt to determine guilt or innocence? Where? It is to the evidence introduced at this trial, and to it alone, that you are to look for that proof. And to it alone, that you are to look for that proof. Where can that reasonable doubt arise? From the evidence, conflict in the evidence, or lack of evidence. Now, the prosecution says, look, we had horrible law enforcement officers. It doesn't matter. It doesn't matter. I about fell out of my chair. It always matters in our system of justice. It always matters. If you have a reasonable doubt, you shall, not can, not possible, you shall find the defendant not guilty. Because it's their obligation and it matters. I need to blow it up on that last part. Thank you. If you have no reasonable doubt, then you shall find the defendant guilty. It goes both ways. Next one, Matt. Justifiable use of deadly force. This is an instruction that the court is going to give you, and you are going to be able to work with this instruction for a very important function in your decision. Justifiable use of deadly force. our Constitution, the laws in Florida, protect us as citizens to be able to defend ourselves in the face of danger. That's why these laws were enacted by the legislature, and that's why we have a Constitution not only of the United States of America, but also a Constitution of the state of Florida. And in looking at this instruction, the use of deadly force is justified if Curtis Reeves reasonably believed that the force was necessary. Remember what I told you from the very beginning? You don't judge a person until you have walked a mile in their shoes. That doesn't say you judge Mr. Reeves by what the prosecutor here has experienced in life. You only judge Mr. Reeves and you step in those shoes as a 71-year-old former decorated law enforcement officer that not once in his entire career fired his weapon in the line of duty, that was asked to start one of the most dangerous squads that you could have in a law enforcement department. An individual that traveled the entire country to learn those cues to prevent that danger from happening. In the law of self-defense, it doesn't tell you, get smacked first, get punched first, and then you can see what you can do. Because as their witnesses themselves have told you, law enforcement, medical examiner, you name it, one punch can cause great bodily harm, and one punch can cause death. You've got to stand in the shoes before you judge someone. What else was in those shoes? What else were in those shoes? You were in a theater, in a darkened time of that theater. Previews were playing loud. The distance between Mr. Reeves and Mr. Oulson was extremely short. You remember in opening statement, Mr. Lawswasser said, "Oh, he was in that row way over there." Did they even give you any measurements here? Not a single measurement was given to you by the prosecution, because they want you to think that that particular distance was a row way over there where this was happening. But that doesn't work, because you've got to stand in the shoes of Mr. Reeves as he was seated there in that seat at very close range to Mr. Oulson. When you're applying this very instruction, because Curtis Reeves reasonably believed that the force was necessary to prevent, let's circle it, prevent. You don't get a punch first and then you get the justifiable right to defend yourself. That's not how it works. To prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense, we're going to talk about this one, the felony offense of battery on a person 65 years of age or older. Now, the wisdom of the law, 65 years of age. If I go over to Miss Flores, and I go to Miss Flores, and she doesn't want me to touch her, but I do this. It's called a misdemeanor battery. Ms. Flores is, I won't tell you her age because she's young. But the law has recognized that the aged in our community are vulnerable. And they have...
Was it murder or self-defense? It'll be up to a jury. We're going to step aside, take a break as we approach the top of the hour. Closing arguments will continue when we return. Also, when we return, Julie Grant will be here. Stay with us.
How's she doing?
Are, call United Healthcare now. Count on us to have more for you.
On January 13th, 2014, 71-year-old Curtis Reeves and 43-year-old Chad Oulson sparred verbally, then physically, over Oulson's cell phone use. Investigators suggest the exchange spiraled out of control when Oulson threw popcorn at Reeves, who was sitting behind him. Reeves responded by discharging his firearm, killing Oulson with a bullet to the chest. Police arrested Reeves for second-degree murder. He pleaded not guilty 11 days later.
Mr. Reeves, we'll speak in confidence.
Yes, sir.
Thank you. You may step back.
On January 31st, 2014, the state attorney's office added a new charge against Reeves, one of aggravated battery for also injuring Nicole Oulson, Chad Oulson's wife, who was seated beside him in the theater.
I remember feeling this should have been over. He's got what he wanted. Why is he still doing the, haha, you did what I told you, I won? That's kind of how it felt to me.
Good Friday afternoon to you, and thank you for being with us here on Court TV Live. I'm your midday host, Julie Grant. Today, both the state and the defense in the movie Popcorn Murder trial are presenting their final arguments to this jury. Curtis Reeves is accused of murdering Chad Oulson after the two men got into an argument inside of that movie theater back in January of 2014. Sadly, it all began over Oulson's use of his cell phone during the previews. Reeves is facing 2 charges, second-degree murder and aggravated battery. That charge for the injury to Nicole Oulson. She showed the jury how badly her finger was injured earlier in this case. If convicted on the top count, Curtis Reeves could be looking at a life sentence. We want to turn now to our guest. Before we go back into court, we want to bring in for some analysis of the closing arguments thus far, criminal defense attorney and former prosecutor Joe Tamburino. He's standing by in Minneapolis. Joe, always great to see you. What do you think so far of what the state has done and what the defense is doing?
Thanks for having me on, Julie. Nice seeing you. I think the prosecutor really has a good argument. I think he's laid out his case very well. I think the defense has an uphill battle. They're definitely doing a good job, but it's a bit of a stretch in this case with some of the issues, such as if, the defendant actually felt that his life was in danger, he was going to get some type of serious harm. I think it's going to be a tough case for the defense.
Joe Tamburino, glad we have you to watch along with us. Thank you so much. Let's go in together now. We're going to pick up exactly where we left off. We're in the defense closing arguments.
And they have sought that wisdom to say, if the aged are vulnerable, we've got to protect them. Because one battery, one misdemeanor punch could cost them their lives. That's not Rick Escobar saying that. And that's not this prosecutor saying that. That is our legislature that have, through countless studies, have determined that we've got to protect those that are most vulnerable. And so they've elevated, think about that, they elevated a misdemeanor crime to a crime of a felony that you can spend 5 years in the Florida State Prison.
Objection, improper argument.
It's a felony of the 3rd degree. Oh. That you can spend 5 years in prison if you batter the agent. Now, let's continue. A person is justified in the use of deadly force, again, if he or she reasonably believes that such force is necessary to prevent imminent, hasn't happened yet, imminent death or great bodily harm to himself or to another, or to another. Who did we have in this theater seating in rows 9 and 8? Curtis Reeves, Vivian Reeves, both up way beyond 65 years of age. The imminent commission of an aggravated battery. That's another way. Not just someone 65, you can do it this way. Totally justified. There's another way. If, in fact, someone's committing an aggravated battery, the throwing of a phone. Their witnesses, not even mine. I brought officer after officer. Officer, tell me, what can cause great bodily harm, which is an aggravated battery? Oh yeah, this phone, if it's being used as a weapon, just about, I believe one officer said, just about anything can be used as a deadly weapon. Up a little more. So those two sections give you, this is what can justify the use of deadly force. But now, how are we going to make that determination? Because in deciding, that next paragraph is in deciding whether Curtis Reeves was justified. So, in deciding whether Curtis Reeves was justified in the use of deadly force, you must, not can, not maybe, you must judge him by the circumstances by which he was surrounded at the time the force was used. All of the circumstances, his knowledge, his close proximity to the individual, the low lighting conditions, the noise level, the problems that he was having physically. I think that when you all, and we're going to talk about Foley a bit later, not only did you hear from Dr. Foley, again, one of the preeminent radiologists in the country, not only did you hear from Dr. Foley, but he showed you on the x-rays and the MRIs some of the most trusted procedures that all of us in our lifetime at some point in time will have. And he showed you area by area by area of Curtis Reeves's problems. Disc herniations, impingements on the cord, his actual skeletal system from the very back. I'm not going to bring out the skeleton, but all the way down the back, he had black discs, all the way back, bone on bone in his hands, bone on bone in his back, bone on bone in his cervix. You've got to stand in those shoes because that's what the law requires. All of the circumstances, every single one of them. It's not what Rick Escobar would do. It's not what the prosecution would do. It's what someone in Mr. Reeves' shoes would reasonably do. That's the beauty of the law. It does not punish individuals that reasonably perceive that danger. That's the beauty of our Constitution. That's the beauty of the law of self-defense, that it does not punish the reasonable perception of an individual that is facing danger. And let's even talk about the danger, because it goes one step further. It tells you the danger facing Curtis Reeves need not have been actual. Need not have been actual. That danger didn't have to be actual. But as long as he reasonably perceived that it was a dangerous situation, the law protects us. There may be other courts in the civil arena that someone can pursue, but in the criminal arena, the law does not punish those that reasonably perceive that they're in imminent danger of great bodily harm or death. even if that danger is not actual. The appearance of danger must have been, however, real, and that a reasonably cautious and prudent person under the same circumstances, again, would have felt that that danger was so real. It does matter. Everything matters. Based upon the appearances, Curtis Reeves must have actually believed that the danger was real. It's another very important paragraph right below it. And again, it's protected by the U.S. Constitution, the Florida Constitution, and our Florida laws. And as we walk in society, and as we interact with people in the great state of Florida, we're protected by these laws. And what does it say? That as long as Curtis Reeves is not engaged in unlawful activity, which there's no question he was not, was at a movie theater, getting ready to watch Lone Survivor, watching the previews. So there's no question that there was no unlawful activity. And was attacked in any place where he had the right to be. Certainly he had the right to be at the Cobb Theater to watch The Lone Survivor. He had no duty to retreat and had the absolute right to stand his ground and meet force with force, including deadly force. Those are the protections that all of us as citizens of this great state enjoy. It's a dangerous world we live in. Things happen in split seconds. It's very difficult to judge what comes next. It's very difficult to understand the makeup of that person that's about to attack you. But there are cues that officers, former officers, retired officers like Mr. Reeves have been taught.
You are going to see more of the defense close in just a few minutes. We have to step aside for a break. What do you think so far about these arguments? These are the final arguments the jury will consider before they go back to deliberate the fate of Curtis Reeves. We'll be right back after this.
Retired police captain
So glad you're with us this Friday afternoon. Welcome back. I'm Julie Grant. Let's go in together to that courtroom in Dade City, Florida, to hear more of the closing arguments from Curtis Reeves' attorneys. These are the final arguments the jury's going to hear before they're going to deliberate his fate and decide whether or not this homicide was murder or justified.
Have been taught that hopefully protects them and allows them to prevent that fatal blow to strike. Those cues, it wasn't only Dr. Bedard. Again, you know, they complained that our experts were expensive. Our system of justice wants that. They want to get it right. Our system of justice does not want to get this wrong. They complain that our experts charged an hourly fee to help in the investigation of this case. Roy Bedard, one of the nationally recognized experts in use of force. He wasn't my expert only, right? Remember what he told me on stand? Roy Bedard testified for this very prosecutor months before. This very prosecutor. He wasn't about to testify on this one for him.
Objection, improper argument.
Did they touch him with a 10-foot pole? Did they even come up and chat with him about his opinion? His opinion, which was the most important opinion, that Curtis Reeves did not fire that weapon in response to popcorn being thrown. His theme, his primary theme that he came up here, he said, ladies and gentlemen of the jury, this is about a man that shot another man over popcorn. Their expert witness, Roy Bedard, got up here and under oath said, absolutely not. 0.72 seconds between that period of those hands coming to grab that popcorn and the firing of the shot. Remember, Roy Bedard said there's an action and a reaction. The human body takes time to perceive what you're seeing, to decide what you're going to do from that act, and then to carry out the act. 0.72 seconds. Impossible. They didn't touch that with a 10-foot pole. They could have brought Roy Bedard for the government. Let's not even go to Roy Bedard. Let's go to Detective Aaron Smith. Remember all the questions I asked him about his training? Hey, we have training on use of force. Yeah, we have these training exercises, and we look at all these cues, and yeah, it's really scary, Rick, when we fail. Really scary, Rick, when we fail. Did you hear Aaron Smith get up here and say that the shooting of Mr. Reeves was about someone throwing popcorn on him? They had Mr. Smith right in their little palm right here to just ask him one, maybe two, maybe three questions on that issue. Not a peep. They stayed away from that 10-foot pole. I'm not going there. Again, it's constant. If he reasonably believed that it was necessary to do so to prevent death or great bodily harm. But here doesn't say that Mr. Reeves had to try to go and run out of the theater before he used deadly force. Perceives the danger, that danger is reasonable in his shoes. He can defend himself under the Constitution of the United States of America. He can defend himself under the Constitution of Florida, and he can defend himself under the laws of self-defense in the state of Florida. And if he doesn't, it could cost him his life. Another very interesting portion of the wisdom of the law. And our laws are very intelligent. Look what this section says here. In considering the issue of self-defense, the members of the jury, you may take into account the relative physical capabilities and capacities of Curtis Reeves and Chad Oulson. Why does the law do that? Does the law do that because they recognize that a 40-plus-year-old man, 43, 40-year-old man, 6'4", 200-pound man, is much more dangerous when he is attacking a 71-year-old man with the physical problems that he had on January the 13th of 2014? Of course, that's what they're telling you. You've got an individual that has much more capabilities at 40, 43 than an old man at 71, even if you don't consider his physical issues. You judge an individual after you've walked a mile in their shoes. It's a very wise old saying that has great practicality in the application of the law. If in your consideration there's an issue of self-defense and you have a reasonable doubt on the question of whether Curtis Reeves was justified, you shall. It would be a miscarriage of justice if we don't. You shall find Curtis Reeves not guilty. That's not me. The court is going to give you that instruction. The court is going to tell you the importance, ladies and gentlemen of the jury, of applying this law and applying these rules to the evidence that you've heard. There's absolutely no reason not to apply these laws. They're laws that we all follow as citizens, again, of this great country, to make sure that in each and every case, justice is carried out. A miscarriage of justice is the absolute worst thing that could ever happen in our system of justice. Matt, can we go to the next one? Transferred intent. I want to talk a little bit about transferred intent if we can, because it's a concept that sometimes you may need some explanation. But it's a short one, not a long one. And I think the prosecution gave you a little bit of insight that the intent transfers, the intent to do harm against one person, but you end up doing harm to another person, that intent transfers. But just as important is that if, in fact, if the death of Chad Oulson resulted from the justifiable use of deadly force, if you find that the death of Chad Oulson resulted from the justifiable use of deadly force, you must, not can, not maybe, You must find the aggravated battery or the felony battery or the battery of Nicole Oulson was justified. Meaning the battery on her, the aggravated battery, the felony battery on her. You must find that it was justifiable. And why? Because the initial act by Curtis Reeves in defending himself against Chad Oulson was reasonable in his shoes. For a second, we're not going to use the board. Want me to turn it off?
Okay.
Ladies and gentlemen of the jury, who is Curtis Reeves? Who is Curtis Reeves? One of the most decorated, accomplished police officers in the history of the Tampa Police Department. You're going to have an opportunity to see, not all of them, because unfortunately back in those days, in the 60s, they didn't keep all of the training manuals and all the training documents. But you're going to see a stack of training that this individual attended and was certified all over the country. If you remember, he initially went into the Navy, and from the Navy he went to go work for GTE for a couple of years, and then he applied to become a police officer. An individual to serve our community. An individual that walked out of his home every day not knowing whether he would return. Not knowing whether he would return to his wife. Not knowing whether he would return to his children. And not knowing whether he would return to the occupation that he grew to love. Serving others. He had a mentor, a wonderful sergeant in the selective enforcement group, an individual that took Curtis under his wings and tried to teach him everything that could be taught to a 24-year-old rookie police officer.
We just saw Curtis Reeves' family sitting behind defense table as his counsel's delivering final arguments to the jury. What do you think about this case? You've been watching intently. All the evidence is in. Tweet us. Let us know what you think. We know a homicide happened. The question is whether that homicide was justified or was murder. We'll be right back. Welcome back to Court TV Live. Let's go back into the courtroom together. Now we're seeing the defense closing arguments in the movie Popcorn Murder Trial.
Those rookies face the dangers that veterans do. They're out there apprehending individuals that do awful things to others. Shootings, beatings, thefts, abuse, domestic violence, every single day. 8-hour shifts, 12-hour shifts, seeing the horror of our community day in and day out. It is no surprise that police officers that are out there on the streets must get the training that's necessary to avoid, to prevent injury. Not to allow the injury to take place first, and then you get to do what you need to do. And Curtis, I think, told you as he was testifying in this particular case that he attributes his success within the department to that one sergeant that took him under his wings. And Curtis told you that his goal when he was promoted to do the same thing for others that sergeant had done for him. He was in patrol for a relatively short period of time. Curtis was a talented police officer. He rose through the ranks pretty quickly. Somehow, this prosecutor thinks that because you rise through the ranks of a law enforcement agency, that somehow you're just some mean individual that likes to go and just face danger and fight and do ugly things. I've been doing this for 37 years, 4 years as a prosecutor.
Objection, improper arguments.
That is not how law enforcement works in this country. As in every profession, we have good officers, we have bad officers. As in every profession, you've got good lawyers and bad lawyers. As in every profession, you have good doctors and bad doctors. But the title of law enforcement does not make you a bad person. Simple man, excelled at the academy. That was recognized from the very beginning. Got the top award when he went to the police academy. I think even some of the officers that came here and testified told you how important it is that first academy training is crucial. You're going out into the streets, and 99.9 of them are going out to the streets as patrolmen. And he went out as a 24-year-old, and within a year and a half, he was in that selective enforcement. A dangerous position, much more dangerous than even patrolling. He's going and he's hunting these individuals that are committing robberies, they're committing shootings, that are abusing individuals, torturing individuals in our community. And he learned a great deal in selective enforcement because now the opportunities to go out and get training courses were much more available. He did so well in selective enforcement that he actually started some of the divisions that Tampa Police Department had never known. Tampa Police Department never even had a fugitive squad until Curtis and another officer formed that squad in order to go and arrest some of the most dangerous individuals in our community. It was clear in his career that the upper brass of the Tampa Police Department had the utmost confidence in his training and in his judgment to serve our community, to protect our community. And Curtis told you that as he was going up the ranks, he was actually even pulled into the detective ranks even before being assigned as a detective for 2 and 3 month intervals in order to help the detective division. And he learned a great deal from that division as well. That fugitive group exists today in 2022. How many years from its inception? Curtis obviously wanted to move up in the ranks, not because the ranks made him a control person, a bad person.
You're not going to miss a moment of the defense close. We just have to squeeze in another break. Stay right there. This is Court TV Live.
Officer shot
Welcome back to Court TV Live. I'm Julie Grant. Thank you for being with us on this Friday. Let's go back into the courtroom together now. Watch more of the defense closing arguments.
But because with promotions comes income. He had a wife, 2 kids, going to school almost full time. Yes, the GI Bill was paying for his school. He's trying to make a living for himself and for his family. And he graduated from the University of Tampa, summa cum laude. Can't be any higher. The Tampa Police Department to recognize his achievements. They recognize his dedication to our community. They recognize his intelligence in helping that department grow to be a much better department. Of course. And as he moved up the ranks, if you remember, one important part of his career is when he became a homicide detective for 5 years. What exposure did Curtis get when he went into the homicide ranks? One very important one, I will tell you, is that he had daily, weekly contact with the medical examiner's office. As a homicide detective, you go into that office and they're cutting on that body. Right there with you present. And as they're cutting on that body, they're dictating the reasons for these injuries, the causes of death, and it is an incredible educational process to the realities of how vulnerable we are, young and old, to violence. You're reminded that in a moment's notice, you can be alive. And in a moment's notice, you can be crippled or dead. It's an experience that most of us in this country, we don't get to know. We just don't get to know it. We're not exposed to it. We can't feel it, we can't touch it, we can't hear it. Curtis Reeves saw it every week. Those experiences don't leave you. They don't vanish. They stay with you. Forever. He was a wonderful homicide detective. A no stone unturned homicide detective. Because it does matter. It does matter. Don't let the prosecution tell you that it doesn't matter. Because it does. In his career, probably the most prestigious.
Objection, improper argument.
In his career, he was asked, along with one of the other sergeants, to form the tactical response team for the Tampa Police Department. Let's even think about that responsibility that was given to him, and why? The tactical response team is called out for the most dangerous situations that the law enforcement community confronts day in and day out. It was not only a responsibility to actually formulate the blueprint of that team, but more importantly, it was a responsibility to ensure that the men and women that were going to be part of that team were going to have the tools necessary to come home to their husbands and wives and children.
Objection, improper argument.
That's the responsibility that was put on his shoulders. And carrying out that responsibility, he had to go travel the country to make sure that he could find out as much as he could about the risks of danger and how to prevent.
All right, we're hitting the pause button. You're going to see all of the defense closing arguments, but I have two great guests on the program who we want to weigh in on what we're seeing so far. Still with me in Minneapolis, Minnesota, criminal defense attorney Joe Tamburino, and we want to welcome forensics analyst and professor of forensics at Jacksonville State University, death investigator Joseph Scott Morgan. Joseph Scott Morgan, great to see you, my friend. It's been a while. I think the last time I saw you in person was probably at that conference at Duquesne University on serial killers, and here we do not have anything like that kind of a situation. We have a guy who is on one side of the law all his life, finding himself on the other side of the law. Looking at the case, what's your assessment of the death investigation? Did anything go wrong here?
I don't think that anything necessarily went wrong. I think my biggest contention right now, or observation rather, listening to defense in this particular closing argument, is the fact that you've got a veteran police officer that has obviously highly decorated, very well trained, and you would think that along this continuum, he would understand the use of force and the continuum of force, if I can be so bold. And as we wind down this closing argument, that specter is going to travel into that jury room with these jury members. They're going to hear it over and over again. They're going to be talking about his career and that flash moment at that particular time in the theater when he drew that weapon and fired into this man's body. I don't think that that's going to be, they're not going to be able to escape it. I think that the defense wants it both ways. They want to say, well, he's elderly, infirmed, all these sorts of things, but yet he's highly decorated and in a very particular skill set relative to response tactics and all of these sorts of things that come along with SWAT. So it's going to be interesting to see how this kind of spins out.
I'm glad you said that, Joe. The other day we were talking thematically, and I'm probably going to have to ask you to keep the answer really tight, Joe Tamburino, because we're going to be up against a break. But when you think about themes, one of the guests said, should the jury see him through the captain lens or the old man lens? This is the guest's words, not my words here. But what do you think? Should they have committed more to one theme or the other?
I just have a hard time getting over. If he was really in fear of Mr. Oulson, why at some point in time did he leave the theater, go to the manager, make a complaint, but left his wife in the theater next to Mr. Oulson? I think that should have come out more in the trial, because if you're really in fear of this guy, that he's going to cause you serious bodily harm or death, you would never leave your wife next to him. And I'm surprised the prosecutor didn't bring that up more often.
And you were a prosecutor at one point in time. That is a great observation, Joe Tamburino. We'll see if they say it on rebuttal. We'll have to watch. Joe Tamburino and Joseph Scott Morgan are going to stay with me as we go into our next hour. Please do the same. We'll be right back. How's she doing? Always great to have you with us this Friday afternoon. Welcome to Court TV Live. I'm Julie Grant. We are watching the movie Popcorn Murder Trial playing out in its final stages in Florida. We're in the closing argument stage of this case, so all of the evidence is already in. What you're hearing is not technically evidence, and the judge will tell the jury that. It is argument, but sometimes it can be very, very powerful, especially because it's the last thing the jury's going to hear before they go in to deliberate. Also, just want to give you a note. We're broadcasting on our website this trial and the one in Kentucky, the trial of Officer Brett Hankinson. So you have your choice. You can go there as well if you'd like. Let's go back together exactly where we left off and hear more from defense counsel.
And how to prevent his fellow officers and himself from getting hurt or getting killed. You know, back in that period of time, I'm sure that it wasn't as sophisticated as it's becoming even today. But those same cues, you certainly want to create distance from the person that's attacking you. Why? Because the shorter the distance, the greater the danger, the quicker that individual can strike, cause great bodily harm, or kill. The lighting level puts you at a disadvantage. Even Detective Smith told you that. He also told you that noise puts you at a disadvantage in those situations. And why? We get our information from here and from here. And if you're in low lighting situations and noise is loud, you're putting that individual in the greatest of disadvantages. Relative physical capabilities. You've got someone that is a big fella, a young fella, and you're a 71-year-old individual with all kinds of medical issues. It puts you at a disadvantage, no matter how much training you've had. The training is to prevent. The training is to prevent. And so he formed this tactical unit that in 2022 is still in existence by the Tampa Police Department. 15 years. 15 years he commanded that unit. And not once in his entire 27 years of law enforcement, not once, did Curtis Reeves pull a gun and fire that gun at anyone.
Objection, improper argument.
It's in evidence. 27 years, he's not a trigger-happy, retired police officer. After 27 years, Curtis decides to retire. Old doors close, new doors open. His reputation at the Tampa Police Department was...
Objection, improper argument.
Why do we think that such a large corporation as Bush Entertainment would want to hire Curtis Reeves? 30,000 to 40,000 people visiting that amusement park on a daily basis. Why do we think that that responsibility was placed on his shoulders? That responsibility was placed on his shoulders because Curtis Reeves was going to do everything humanly possible to make sure that Bush Entertainment was safe. Curtis told you how he had to change from a law enforcement mind to a corporate mind, because what are corporations concerned with? They don't want anybody hurt at their amusement park. They don't want to get sued by anybody at the amusement park. And they want people to have a happy experience so that they can return. Profit and safety are at the forefront of those corporations. And so, what did Curtis tell you that he did? He just said, oh, well, I'm a police officer. You listen, Captain Curtis Reeves, I don't need to go to any of those courses of yours. I'm going to handle this my way. Is that what he told? Just the opposite. He went to training after training after training after training in order to make sure that he could develop and know and understand the tools that he was going to need in order to be the best director of security that Busch Gardens had ever had. It was a great job. It's a great corporation. It's a big corporation. You're going to be able to see not only the training that he received in the Tampa Bay Department, at least the majority of them, but you're also going to be able to see all of the certificates and all the training that he received from Busch Entertainment, because fortunately it's a corporation, so we're able to get more of those because they keep them. For 12 years, he served 12 additional years, 27 at TPD, and now 12 additional years as head of security for Busch Entertainment. We didn't hear anybody coming in here and say, you know, that Curtis, when he was a member of Busch Entertainment as head of security, he was a wreck. He was reckless. He was mean. He was out of control.
Objection, improper argument.
Didn't hear Pete. Because Curtis Reeves was an outstanding head of security for Busch Entertainment. It was a great job, he told me. But unfortunately, his health dictated otherwise. It's the realities of us getting old. We want to keep doing things that we did when we were 30, 40. But we realize when we get up every morning that there's reminders. Reminders of the aging process. Reminders that we want to forget. That we really don't want to confront. That we don't want other people to see. It's that fear if we stop walking and doing the things that we've always done, that we're going to end up in a wheelchair.
Objection, improper argument.
What did Dr. Cohen? Dr. Cohen was not, some expert that we, picked that was traveling giving expert testimony. She was the professor right here in our community, the University of South Florida, that developed the first aging studies here at USF. Incredible experience throughout the country as far as academic experience. What does she tell you about the aging process and what it does to everyone? We all get there. Some people a little sooner than others. Some people a little later. Some people a little different. But we all get there. And when we get there, it's a scary place. Because we know that it doesn't necessarily get better. We know that as our bodies deteriorate, as Dr. Foley told you, it doesn't happen overnight. It takes many years for that process to take place, and it gets worse. With every single year, it gets worse. And you go to bed at night, and you're reminded of that. You wake up in the morning, and you're reminded of that. And when you pick up your grandchild, you're reminded of that. And so will Curtis Reeves being reminded of that day in and day out. Retired from a job that he likewise loved with Bush Entertainment. I think Jennifer told you at one time her dad was invincible. He could do everything. Physically fit, kept in tip-top shape, and loved the outdoors. I think she told you that Curtis didn't want to give that up. He may not be able to hunt like he used to, but any glimmer of that hunt was worth whatever pain he was enduring.
Objection, Your Honor, this is improper argument.
It's not improper argument, that's what she testified about. All right, I'll overrule. For those that are hunters, being 10 feet up on a tree may not be viewed by many as really hunting. We're normally 30 feet up in the air because you don't want that game to see you. He makes a big deal that this apparatus, which is so easy to get in and go in, is some testament to you all that Curtis Reeves is some robust hunter from the year of his 20s. As citizens growing old, as Dr. Cohen has told you, you want to avoid sitting down and withering away.
All right, we need to step aside for a break. You're going to see the rest of the closing arguments in just a moment. Thank you for watching Court TV Live.
Tonight on Closing Arguments.
Welcome back to Court TV Live, and thank you for watching along with us. We are watching the movie Popcorn Murder trial play out right here in Florida. Also on our live stream on CourtTV.com is this trial, of course, and the trial in Kentucky for former Officer Brett Hankinson. Thank you for all of your tweets. This is not an easy case. We're going to go back in exactly where we left off.
And so he goes on his life now to retire and spend time with his wife, built a new home. These are precious years. They're your golden years. You build a home for retirement. You want to enjoy it with the most important person in your life. Someone that's been by you 50 plus years. Who better knows? Curtis Reeves. Than Vivian. All his pains, all his aches, all his inabilities. She's right there with him. Unfortunately, she's going through it herself. And so life, with your long lived life and partner, your wife.
Objection. Improper sympathy arguments.
Sustained.
So life, in your goal, can be wonderful, and likewise, can be painful.
Improper sympathy arguments.
What's approach?
Improper sympathy arguments. That is the basis the prosecution has articulated. Their words, not mine. Let me bring in my guests to see what they say about it. We have with us attorneys Don Malarsic and Joe Tamburino and death investigator Joseph Scott Morgan. Okay, Don Malarsic, I want to bring you in first on this one. Is that an improper sympathy argument?
You know, I think it is, Julie, but it's really, really easy to fix. All he has to do is kind of tone down the descriptive language about his wife and just give the facts to the jury and let the jury draw their own conclusion. So it probably has crossed the line, but it's a really easy fix, and I'm sure that's what we're going to hear when we go back after the judge talks to him. He's just going to lay out the facts about the relationship, how long it was, the children that they raised together, and the time they've spent together, and I think that will overcome the objection.
Don, thank you. Joe Tamburino, I want to bring you in next. We've seen a lot of arguments. I just got a question on Twitter, somebody saying, why does the state keep saying improper argument and objecting over and over again? Joe Tamburino, I want you to answer that, if you would, please.
Yes, well, what happens is during a closing argument, you can't bring up things that either have not been admitted into evidence or are improper in the sense of character evidence, character slurs, or if you're playing to the feelings of the jury. You can't personalize something so much to the jury toward your client or toward the state. Now, the prosecutors just say improper argument, which is basically this global objection, but what they argue after that is more specific. I don't know what's happening at the bench, but that could be what they're arguing.
Joe Tamburino, thank you kindly. Let me bring in Joseph Scott Morgan. He is a death investigator and professor of forensics at Jacksonville State University. Okay, Joe, earlier you were telling us about your analysis of the investigation, of the incident itself. Looking at the facts presented by both sides, all the evidence is in. Tell me how you're seeing things. Who has the more favorable set of facts?
I think that at this moment, Julie, I'm looking to the prosecution at this moment in time because, again, they have this kind of dichotomy that's going on with this robust man that has been involved in law enforcement for all of these years, but yet in this 1 second in the theater, he makes this decision relative to taking another person's life, escalating suddenly to deadly force. And that's going to be a problem, I think, for the defense to try to mitigate that in any way. There, you know, the reality is that this wasn't a round that was fired at a great distance. He was there close up, even if it is dimmed lighting. He should have been able at that moment in time to evaluate the situation, even that split second. Remember, he did have time to go and cool his heels about when he went out into the lobby, and then he returned into this environment. I think that's a salient point right there.
All right, Joseph Scott Morgan, thank you so much. I think we're going to listen back in together live.
Of his father. In fact, he was the one that had gone to that hunting trip right before this incident occurred. It's important to listen to all the evidence because it matters. Curtis Reeves was an individual that was quickly deteriorating. Dr. Foley told you that. And on January the 13th of 2014, that is exactly the person that walked in to the Cobb Theater with his wife to watch Lone Survivor. It was a matinee on January the 13th of 2014. It was a time for Curtis and Vivian to enjoy what they did often. Go to a midday movie, see what the previews are showing for the future, so you can stay active and go to another movie. And both Vivian and Curtis told you that they were going to meet their son there. And even though Curtis had been on this hunting trip with Matt, it was important for Vivian to spend any time she could with her son Matt. Matt was running late. If you remember in the video, we're going to show some videos a little bit later on. They were there in that lobby after they entered. They were in that lobby for some time, wanting to see, you know, whether Matt was going to show up or not. And they knew he was going to show up, but what time was he going to show up? And they eventually went and bought one popcorn and one drink to share. You remember Vivian saying, I brought my little baggie so that I could put popcorn in that baggie, and I could eat popcorn from my baggie, and Curtis could eat popcorn from the bag. Curtis, as being a retired law enforcement officer, and as he indicated on the stand, being encouraged by a federal statute that encourages retired police officers to carry their guns everywhere. Well, let's think about that. Talking about the wisdom of the law, remember? Why is it that we have a federal statute that encourages retired police officers to be armed at all times? Because those police officers are needed at times to protect our community. They're needed because we live in a violent society, unfortunately. They're needed because we don't know when that next violent episode is going to take place. Had to carry concealed firearms permit as well. And he had a little itty bitty gun. Not a big one. Not a Glock 44, strapped to the side of his pants to show how tough he was. It was a little gun, a little styrofoam poster that you put in your pocket, that you're encouraged by a federal statute to carry. Remember, this is the same gentleman who testified to this, that he had never pulled his weapon in the 12 years that...
Objection, improper argument.
It's testimony. This is the same gentleman that did pull his firearm and shoot anyone in the 12 years that he served as head of security for Bush Entertainment. So they go into Theater 10. By the time they get there, Mr. and Mrs. Oulson are already there. They sit behind Mr. and Mrs. Oulson. At some point in time, commercials are on. Not previews, commercials. Mr. Oulson playing with his phone. No big deal. No big deal, because at that point in time, it was commercials. The announcement hadn't come on to turn off your phones. And then the announcements come on. And it wasn't just a little bitty announcement. You remember what Mr. Hamilton said, former deputy for Sumter County. Remember what he said? Man, they were playing that announcement to turn off your phone so much that I felt like pulling out my own phone. Because it was over and over and over again to make sure that the experience for everyone in that theater was a good experience. As people, as citizens of this community, is that not what we all want for each other? The prosecutor calls it, with Mr. Reeves having that light shining on his face and leaning forward and saying, "Sir, could you please turn off your phone because the announcement went on." He calls that instigation. Again, I almost fell off my instigation. Is that an act of instigating anything? As people, can we not talk to each other and say, "Sir, can you turn off that phone, please"? Is that the prosecution's theory?
Are you noticing what I'm noticing? I'm sure you are. So many objections being lodged by the state in this closing argument. And have to tell you, in trial advocacy, that's a big no-no. You only do it when you absolutely have to do it. It's seen as kind of disrespectful to interrupt the other side's argument. And you also don't want to appear to the jury like you're hiding anything. So the general rule is only object when you really have a basis and you have to protect the record for your case. I think we should start counting them. What do you think? Stand by. We're going to get you back into the courtroom live right after this quick break.
The following information is for
Welcome back to Court TV Live. I'm Julie Grant. We are watching together the movie Popcorn Murder Trial playing out in Florida. I was just communicating with our Julia Janae, who's inside the courtroom watching along. She said the jury doesn't seem to mind with the objections from the prosecution. They have been numerous, and most of them have been on the basis of the argument being improper or out of bounds for a closing argument. And we've seen the court largely overruling the objections, sustaining some of them. She said it's been a long day. Everybody is very tired on that jury, very hungry. Let's go back in and see where defense counsel goes next.
That was instigation? Curtis told you profanity. Fuck you or fuck off or Curtis leans back in his chair, waiting to see if maybe he was going to turn his phone off because he saw Nicole kind of maybe interceding to some extent. And when that wasn't happening, you see him again. Sir, you leave me no choice. I'm going to have to tell management. Now, let's think about that process. Is that a familiar process that certainly he was accustomed to as head of security for Bush Entertainment? Remember, he told you part of the training that he had received at Bush Entertainment is that, hey, if someone's having a problem with a patron, don't deal with it yourself. You go and get a manager who has the authority to deal with that particular problem and let the management take care of it. He thinks that's instigation. So I guess everyone at Busch Gardens are instigating because they go and tell management about an unruly individual at their amusement park. It's a darkened theater. Can I tell you how dark it was? Unfortunately, we can't. Whose fault is that? Whose fault is it that we can't tell how dark that theater was? You think Detective Proctor called Rick Escobar on his cell phone and said, hey, Rick, come on over, man. We got a shooting over here. I want you to try to preserve whatever you want to preserve. Now you can call Rick Escobar. Oh, Public Defender's Office. You know their number. Think that happened? In our criminal justice system, we rely on law enforcement to do things right. Because it matters. Because if they don't do things right, if they don't preserve evidence, the disadvantage that we face is insurmountable. I think Victor Smith told you, yeah, you're right, Rick, we preserve it not only for the prosecution, but we have to preserve it for the defense as well. So he's telling me over here it doesn't matter. Yeah, got a crappy investigative team out there, Rick. No problem. It doesn't matter. Just listen to me. Just listen to him. That's what he's telling you. Just listen to me. Because all that doesn't matter. We'll get into Dr. Knox a little bit, but he was an expert in the field of crime scene reconstruction. That's what he teaches. Not only in Jacksonville, but around the country. law enforcement officers from all of them. He told you the dangers of not getting it right. He told you the dangers of missing those pieces of evidence that can shout out the truth in a criminal investigation. It doesn't matter to the prosecution because they're not being accused. That's why it doesn't matter. But for anyone that's accused, oh, ladies and gentlemen of the jury, it matters. And so Curtis leaves that darkened room, whatever darkened it was, and goes down the road and goes to the manager. And you're going to a little bit see that again. And you'll have it in your deliberation room. You'll have a computer, a defense computer and a prosecution computer. You'll be able to look at all the videos and analyze all of that. And I encourage you to please do that. Because it matters. And so you'll see when he was talking to the manager, he was calm, he was polite, he was resting there on the counter. Remember Michelle Simpson was there? And what did Michelle tell you? Yeah, looked over there, there was no signs of any aggravation or hatred or being mad. Because Curtis Reeves has dealt with these situations countless times before. And what did he tell you? He's a mouthy guy. And his perception at that point in time is that's what it was. He was a mouthy guy to get the manager take care of things, and everybody can enjoy the experience again. There's one very important, critical piece of evidence that you've seen in the videos. And that is he leaves the counter, tells the manager exactly where he's at.
Stepping aside for a quick break right now, don't go anywhere, please. Also, quick reminder, we're also live streaming the Hankinson trial in Kentucky. Just go to courttv.com if you'd like to keep up with that case as well. We'll be right back.
Tonight on Closing Arguments.
What is this jury thinking in the case of the movie Popcorn murder trial? They're listening to the closing arguments of defense counsel. Let's go back in together now.
He comes back, and the first thing that Curtis does when he comes back is what? He grabs a bag of popcorn from video. It's in the video. That's the first thing he does. Do we think, does the evidence show that when he comes back, he wants to have any problems with anybody? He wouldn't be grabbing a bag of popcorn, I can tell you that. Because in his training, as he's told me, if he's about to get into something with someone, he better have both of his hands available. That slaps you right in the face. He grabs the popcorn from his wife and he sits down. It is at this time that there's that conversation by Mr. Oulson where he is irate over the fact that Curtis has turned him in. And you got that from Mr. Cummings. You got that from Jane Roy. You got that from Curtis Reeves. This guy is upset that Curtis had gone and told on him with management. And so the only thing that Curtis does is say, look, I see you turned your phone down. You've never gone to tell management. And I say that you were going to put your phone on. That he calls instigating. As human beings in this community, we can't have that kind of conversation. If we can't, God help us all. And so at that moment, he jumps up, that being Mr. Oulson, and turns around, and the profanities and the attack occur. One thing I can tell you is, thank God for that video. I have no idea why he thinks the video is good for him, but thank God that we have that video. As bad as it is, as limited as it is, because it only records on row A, you'll be able to see that and analyze it and do everything that you need to do. It's supposed to be recording the scene of bistro. Thank God we got at least a glimmer of a section in that camera that captured row A. I wish it would have captured row B. Had it captured row B, we wouldn't be here. And what do we see? Somehow, the prosecution tells you that the first attack is a fabrication. And we're going to see the videos in just a few seconds. That first attack, Mr. Oulson, is clearly, half his body is in row A. And coincidentally, while his body is in row A, we see this either reflective or illuminating light. You recall what Mr. Koenig said. It was 6 pixels. Rectangle. Madam Clerk, can I see the cell phone?
All right, while he's heading to the other side of the courtroom there, we're going to hit the pause button. I want to bring in my guests before I have to say goodbye to two of them, Joe Tamburino and Joseph Scott Morgan, both standing by, watching along, watching the case progress. Just want to get your thoughts where we are at this juncture. Joe Tamburino, let me begin with you, please, and the advocacy that we're seeing today from both the state and the defense. And it's not over. The state, as you know, still gets rebuttal. Your thoughts, please.
I think the state did a good job, and I think the defense started out well, but this is too long. You're starting to lose people. I mean, whatever you've got to say, you can say in less than 2 hours. I mean, I like to do an argument within an hour. You start losing people. So I think this has gone on too far.
I'm with you there. You know, sometimes really short and sweet wins the day because they've seen the trial, right? They've seen the evidence, and Joseph Scott Morgan, you know all about forensic evidence. And so to that end, how important is it in this case? We've heard a lot about the cell phone and DNA not being on it and whether or not the cell phone was just dropped by Chad Oulson in this case, or as the defendant says in his story, was he hit in the face with it? What's your assessment of all that, please?
Yeah, I think to that point, Julie, one of the issues is, the processing of the evidence. Remember, it was reflectively, we're thinking about, it took some time for them to attempt to process for DNA, and you can certainly implant that into the mind of the jury, raising reasonable doubt relative to how swiftly you get on the evidence, have it analyzed, these sorts of things. And also, to a broader point, begin to think about the environmental conditions in that theater that night. Did they do enough? Did the prosecution, did the police do enough to analyze that environment? You think back to the infamous hot car case where we had various temperatures and all those sorts of things, that the police took a long time analyzing that. Did they do the same thing in this case relative to the ability to view things? Did they go in and analyze that? The light spectrum and this sort of thing, and how would that play with the jury? So I think that going into the jury room, I think that they've got much to consider here from a forensic standpoint.
Appreciate that. Joe Tamburino, back to you, please. Looking ahead to rebuttal, if you were the state, where would you go with that? What would you really want to finally emphasize to the jury before they go back to deliberate?
There's no reasonable apprehension that Mr. Oulson is going to cause you death or serious bodily harm. And I go back to what I said in the first hour. This guy, Mr. Reeves, he had his wife right there in the theater, and he leaves, complains to the manager, come back, but guess what? He left his wife next to the supposed dangerous man. You just wouldn't do that. So I would get to the heart of the matter. What is the reasonably based fear on? And that's where I would hit it. And then go to, obviously, that using the gun was just excessive.
Right. I love that argument you made, Joe. And yesterday, was seeing the defendant, I thought, well, he did well with some questions. There were some answers that, in my view, just weren't all that helpful to him. Joseph Scott Morgan, what did you think overall? And we just have about 30 seconds left in terms of whether or not the defendant helped his case.
Yeah, I think that probably it did not mitigate the situation any further. I think that he probably would have been best advised not to have taken the stand in that particular situation, and just let the cards fall as they may relative to this case. Remember, this is a case involving stand your ground. And, the evidence kind of bears this out, I think, and is going to be considered in the jury room.
Yeah, we'll see what the jury does. They're going to get the case today. Joseph Scott Morgan, Joe Tamburino. I have to say goodbye to you both, but thank you kindly for lending us all that analysis today. We'll be right back.
Dexcom G6. I don't have
Thanks for being with us here on Court TV Live. I'm Julie Grant. Thank you for watching this broadcast as we're watching the movie Popcorn Murder Trial play out in its final stages in Florida. They're in Dade City, kind of in between Orlando and Tampa. Tampa is where the defendant served as a police captain for 27 years. Now he's finding himself on the other side of the law, accused of murder. Let's go back in now and hear more from his defense attorney in closing arguments.
Please. Rectangle. Not square, not round. Rectangle, 6 pixels. Now, could we prove to you all that the illuminating or the reflective light that we're able to see as you see that body coming over onto row A, can we tell you for certain that this is what it is and that it is not Curtis's shoes? We tried. We spent a lot of money, experts flying from all over to get to that cop theater to try to prove with a cell phone in our hands and the actual shoe to try to determine what was that light source. And through no fault of the defense, and through all the fault of the state of Florida, we couldn't do it. Because the cop theater was pretty savvy. They had come in, taken all the hard drives in the middle of the night, on the night of the incident, from the cop theater with a patrolman, and I don't know what he was doing, with a patrolman there, cordon off Mr. Sillis. My name is Mr. Sillis. I'm here to come get some evidence. Sure, come on in. Go upstairs, take all the evidence. Cop theater flying someone down from Alabama. Here, sir, take it back to Alabama. And within 60 days, not only had they taken the hard drives, remember Mr. Peck, what he said, they had dismantled and taken the entire surveillance system. So when we arrived at the cop theater in the middle of the night, 2 or 3 o'clock in the morning, as Mr. Koenig told you, we couldn't do anything. It was a total waste of time because the responsibility of preserving that evidence was there the evening of January 13, 2014. I will tell you that they had, and you heard the testimony, they had Detective Busson, they had Detective Papanella, they had Detective Lindsay that had just gone briefly to the hospital. The 3 guys that had started the most respected unit in the Pasco County Sheriff's Office, the cyber crime unit, right there to do everything that we were prevented to do in that theater. They could have done it right there. And for one reason and one reason only, it didn't happen. Because Detective Smith now was assigned as the lead crime scene detective, prestigious position, and he decided that no, nobody was going to do anything. He was going to do it all. Remember, it was the 2nd time ever handling a crime scene investigation on a homicide case. Detective Smith had not even taken the mandatory homicide course. He told you himself. No, hadn't taken that yet. And who was his shadow partner? Proctor. Detective Proctor was the person that was supposed to teach Detective Smith. Now, if that's not the blind leading the blind, I don't know what is. Detective Proctor was cross-examined by me. And he had to admit from this very stand, he didn't want to. How long did it take him to admit? It was radio silence. Detective Proctor, you were not equipped with the knowledge. Detective Proctor, you were not equipped with the knowledge to handle a self-defense case. Because you, Detective Proctor, had only handled one before. And then there was that radio silence. And he finally had to admit, yes, Mr. Escobar, I didn't have to. I didn't have the experience. It took Detective Proctor 8 years to admit that he was not equipped to handle this case. Let's think of, it doesn't matter. It doesn't matter. Could Detective Proctor have told Sergeant Sessa, "Hey, Sarge, I know I wasn't supposed to be assigned to this in the very beginning. Detective Soto was. But I don't have the knowledge." He waits 8 years. And yet before the ladies and gentlemen of the jury, the first degree.
Objection, improper argument.
Suspended.
It matters. We're going to go through the next very important part, because the first attack is as vivid as it can be in that video. Now, you remember, you heard testimony that both sides had the FBI. I don't know where their FBI guy is, but my former
Objection, improper argument.
You heard from my FBI guy. Of course, they complained about him as well, that he was costing money. We brought you one of the leading experts in the country in video surveillance, analysis, and enhancement. Mr. Koenig has worked on the most important cases ever in this country. Fortunately, he lives right over here in Pinellas Park now. And what did Mr. Koenig do for us in those videos? He told you about a concept that is very, very important. It's called interpolation, you remember. And then when you're doing forensics, you've got to make sure that if you're going to enlarge or enhance that video in any way, it's got to be done a certain way. And that's called the pixelation of nearest neighbor. Because if you don't do it that way, there'll be problems. It's not forensically correct. And he told you what happens to big screens when we put things on. And that particular film and video have not been processed correctly with nearest neighbor. Because we don't know what's in the brains of this thing, he told you. We don't know what the algorithms are to make something that's being presented on this screen bigger. Remember, we talked about the number of pixels, and through interpolation, you could have 76,000 pixels, but if it's improperly interpolated, you can have 6 million, 12 million pixels that were never in that particular film and video to begin with. And guess what? You don't know what they're doing with it because it's proprietary. They don't want to release the secret so that a forensic expert can analyze it and make sure that what you're getting is truly forensically correct.
Objection, improper characterization of the testimony.
And so, what happens? The first attack takes place. We brought you that video. We're going to see it in a few minutes. We actually put circles around the two particular areas of focus. The reason that Mr. Koenig did that because he wants our eyes to be focused on that. We did it both ways. We did it without the circles. We did it with the circles. We did it at 200% magnification. We did it at 400% magnification. But he told you one thing that was important. Forensically, it was accurate. We're not putting any pixels that weren't there to begin with. And so you're able to see at 25% playback, 50% playback, 200% magnification, 400%.
All right, time for a quick break. We'll be back next. Back into the courtroom we go to see more of the movie Popcorn Murder Trial. Defense counsel still giving closing arguments.
And if you say that it's Curtis crossing his legs, it could very well be. Why was that crossed leg at that very moment moving in order to show the reflective characters of that shoe? Why? Why? Because Mr. Oulson, you can see, is coming over the back of his seat towards Curtis. You know, the real problem with the phone issue, the reason that we went there at 2 o'clock in the morning, is that you have camera 11 and camera 12, right? There's the screen of the theater, camera 11, camera 12. These cameras, one camera is recording, the other camera is not recording. There's no rhyme and reason. It is the dinosaur of dinosaurs as far as surveillance system is concerned. You think to yourself, complicated? Are you kidding me? But this is the problem. If the phone is not illuminated at that time, for whatever reason, it's a darkened theater. Are you going to get a light? Are you going to capture that illumination if it's not? This is black. Same thing here. If the phone is being thrown, depending upon all the positions that a phone can be thrown, and that light is not on, are you going to capture the illumination? Six pixels was of interest to us. 6 pixels. We couldn't do what Mr. Knox and Mr. Koenig wanted to do, is to bring that evidence to you for one reason and only one reason. Law enforcement failed to do their job. And so you'll see that there's about 8 seconds between the first attack and what I call the second attack, the popcorn incident. And remember, we had Mr. Knox, we had quite a few witnesses, Mr. Koenig, tell you that what someone is experiencing in that particular chair cannot be captured, that perception cannot be captured exactly from a camera that's 35 feet up in the air. Now, if the camera was right there, see what you were seeing, to witness what you were seeing, that would be wonderful. We don't have that. And remember, whose perception is it? In whose shoes do we need to step in? The shoes of Curtis Reeves. It was he that was experiencing the attack. It was he that was feeling that particular item hit him on the head. Mr. Reeves, can I have your glasses? Let's hope that I do as well as I did before. So old man glasses. They move everywhere. I'm not, the arms, the center, you name it. Everywhere. You think that they even looked at this forensically? You think they even used it in their attempted recreation? No, because they didn't have a recreation. We don't even have measurements from them. And does that particular area, something hits that particular area of the glasses, will it hit your eyelid? Something hits that area with some force. Will it cause some injuries to your eyelid? And the prosecutors picked this up. You don't want to touch it too much. I'm touching it. I want you to know the flexibility. You all grabbed it and did everything, legs, arms, whatever you want to do with it. Curtis Reeves was hit with a phone. That's without doubt. His own medical expert his own medical examiner sat there and said, you can throw a phone at somebody and not have any evidence that it was thrown and hit the face. He said that right up there.
Improper characterization of the evidence.
There's so many variables. There's so many variables. Just because you throw a phone at somebody and it hits them in the head doesn't mean that it's going to split their head open, because we don't know what the force is. We don't know if it hit something before it hit the head. There's a gazillion variables that you have to consider. But we know this. They didn't even think of this. And remember, Detective Cohen telling you that he told the tech, forget her name because she didn't have a major part, but let me see if I can quickly find it. Susan Miller. Remember Susan Miller? Koenig tells you, I told Miss Miller that she needed to take a picture of Curtis Reeves' injury to the left side of his face. Susan Miller told you, absolutely not. That was an injury that I saw. Nobody told me that. And I documented it because that's my job as a forensic investigator to do that. And you've got the picture. It's their picture. And you will see that Curtis does have a red mark. Of course, now they had to figure out, oh, well, you know, he rubbed that area, and so now he's fabricating that he was hit with a phone, even though the phone is in between his legs. Sorry, Curtis. That second attack, what are we seeing from seat 9A? If we were in seat 9A, what would we be seeing? We'd be seeing those hands coming at you. That's what we would be seeing if we were in seat 9A. That is what Curtis Reeves would be seeing. Curtis told you that after that first attack, his glasses were a bit askew. Now, you've seen those glasses. Now, if it was my glasses, it'd probably be, you know, because they're so stiff.
Objection, improper argument.
My glasses would be stiff.
Objection, still the same argument. Doesn't matter what Mr. Escobar's glasses can do.
Mr. Reeves' glasses are flexible. And so he's seeing those arms coming at him. He told you before that situation, I knew that I had to retrieve my firearm because this guy was coming at me. And Mr. Oulson's very wife was trying to hold him back and couldn't. I want you to think about that. Here's Mrs. Oulson. Her husband has got to be somewhere, either directly in front of her, whether she's seated halfway or totally up, or to the right of her. She's using her left arm to hold him back. Now, that's pretty awkward if he was here, but not so awkward if he was right in front. Why would Mrs. Oulson have to hold her own husband back? because she knows his violent tendencies?
Your Honor, it is completely improper and evidence that is not before this court.
Oh my, that was terrible. Look at Nicole Oulson. She lost her husband. She, as you saw, has a finger that's very badly injured as a result of this incident. And it appears that what she was mouthing there was that he's a liar. It was very low and very hard to hear, but according to our crew, we have our Julia Janae in the courtroom. What defense counsel said was that Nicole Oulson knew of her husband's violent tendencies. That, of course, drew an objection from the state. They're at sidebar there. Let me bring in Don Malarsic. Oh, Don, this was a bad move there, wasn't it? Your thoughts, please.
Yeah, this is really bad, Julie. There's obviously no evidence of that. I'm imagining that the prosecution is talking to the judge about the possibility of a mistrial or some other sanctions against the defense, some proper instructions to the jury that that comment was out of line. It should be stricken. There was no evidence at all of any violent tendencies. Certainly none of that evidence came through the surviving spouse. This is a huge problem for defense. The government's in a tough position because if they feel that the case is going well, do you really want to ask for a mistrial? And I would guess probably not. So the judge is left with, how do I unring this bell? How do I get the jury to not consider this evidence once they've heard it without bringing too much attention to it? So I'm guessing that that's what the conversation is at the sidebar, but obviously huge mistake. Defense.
Right, Don. And look at Nicole Oulson, obviously visibly upset and angry at that comment, understandably so. And you always make excellent points, but the one I want to expound upon, if you don't mind, please, Don, is if you're in the spot of the prosecution, you know that was improper, shouldn't have been said. But what's next? What do you do to fix the problem, right? Because to your point, Don, if you're winning, and they very well may be, they've put on an excellent case. The prosecutor gave a tremendous close earlier today. Do you want to stop things at this juncture and ask for a mistrial? What do you think the state ought to do? If you were in the position of those prosecutors, what would you say to that judge, Don?
I would say, Judge, that this is probably warrants a mistrial, but we're not asking the court for a mistrial at this time. We want the court to instruct the jury that that statement was entirely improper. It must not be relied upon. It should be strict to the record. On an admonishment against the defense attorney in front of the jury, and you want some limiting instructions that the jury must only consider the evidence that was admissible and offered to them through the course of the trial.
Called a curative instruction, if you ever hear that term. Excellent explanation from you, as always, Don Malarsic. Thank you so much. Glad we have you on the show to give us legal analysis. I'm being told we're going to squeeze in a break because we're at the bottom of the hour. Stay right there. There's much more to come here on Court TV Live with a movie popcorn murder trial.
This is an important message.
Welcome back. Wow, this trial is really something. We had a moment just a few minutes ago that could have arguably been grounds for a mistrial. Let's watch some more of defense counsel's arguments to the jury.
They had some special procedure going on, Detective Proctor, that before he turned on the recorder, he wanted to determine whether a corporal from the Sumter County Sheriff's Office, what he was going to say, whether he was of the right mind, I guess. And even Corporal Hamilton told him, you're not supposed to do that. You got to report an interview, record it from the very beginning, and preserve the evidence. Because remember, we're preserving the evidence not just for the prosecution. We're preserving the evidence for everybody. The prosecution, the defense, and most importantly, the community in our system of justice. And Corporal Hamilton, finally on cross-examination, says, yeah, Rick, you're right. Really, what I saw was a silhouette. Well, wait a minute. If all you saw was a silhouette, then what's this bit about, man, you can see 10 seats down, you can see 20 seats down. It's as clear as day during those previews. Why? Why can Corporal Hamilton only see a silhouette? Never see Mr. Reeves, never see a gun. Because the reality is that it was dark. And why can't I provide you that evidence? Through no fault of our own. It was never preserved. Remember, Mr. Knox told you, light meter, noise meter, it's a no-brainer. Things have been used in investigations forever. But what was told to you here in this particular courtroom that's even more powerful? You remember, I believe it was Amy Parrish, if I'm not mistaken, it was the forensic tech that Mr. Michaels was interviewing. And she says, I've got a specialty. My specialty is be able to actually photograph accurately in dark areas. Now that's like a no-brainer or no-brainer, right? You got your forensic investigator right there. You got Detective Aaron Smith right there. You certainly want to, as all the experts have told you, you want to be able to stand in the shoes of Mr. Reeves and capture everything that he was seeing, everything that he was experiencing, and you don't do it. You remember their photography was such a disaster that they had to come back 2 weeks later, even under Aaron Smith's, remember he told you, my main focus there at the crime scene was I wanted to make sure that they had good photography. Of course, the spotlights that they needed were right outside in the parking lot of the forensic lab truck that they never used. Instead, they brought flashlights. So they bring flashlights, they don't use the equipment that's in the truck, and by all means, let's not use your expert that can actually photograph in the dark and replicate that light. So what do we do now in our criminal justice system when that has disappeared through no fault of the defense, but all fault of the government? He says it doesn't matter. You judge for yourself. So Mr. Proctor, Detective Proctor, now Mr. Proctor, He interviews both of those individuals, and clearly, from both of them, they tell him, hey, there's some profanity coming from that silhouette. It's coming back towards Mr. Reeves, and we don't hear a peep from Mr. Reeves. Unrefuted, clearly, profanity. The way, at that moment, Mr. Oulson was using it towards Mr. Reeves. Behavior that indicates that someone who's uttering those words has to be totally out of control. Who does that? Remember the environment. What's your environment? We're in a theater. You're supposed to sit down, enjoy the experience, watch the preview, watch the movie. Quiet. It's peaceful. It's relaxing. There's someone standing up in a fit of rage, acting like I would bet nobody in this entire room has ever heard before. In a theater. Is that a cue? Is that a good cue to understand that the gentleman, if you want to call him that had already attacked you once, is about to attack you again, was out of control? But that's not important to Detective Proctor. Because remember, he doesn't know what a structured interview is. He doesn't know what a structured interview is for a self-defense case. He didn't even want to know what Curtis's experience was in being able to recognize danger, assess that risk, and act accordingly. Please, ladies and gentlemen of the jury, please listen to that interview of Detective Proctor to Curtis Reeves. The proper questioning, according to the experts, would have been, you've got to know details. Tell us what courses you've taken. Tell us how long you've been tactical. Tell us the experiences that you've had in the past. Because why? Remember the law that we read here? The law tells us that's what we must do. Police officer, jury alike. We must stand in the shoes of the individual that was facing that danger in order to accurately understand their reasonableness. Doctor didn't ask any questions concerning lighting.
Just have to say, I am loving all of your comments you've sent in to us at Court TV on Twitter and other places on social media watching this trial. Wouldn't you love to know what this jury is thinking? Defense counsel still going with his close. You know, at some point, it becomes redundant, right? I've seen him address some issues over and over again. A lot of times, short, sweet, to the point wins the day. We'll see. We'll be right back after this.
Tonight on Closing Argument.
Welcome back. Defense counsel still going on the closing argument. Appreciate your comments and your feedback. Let's watch together now.
He admits it was a brief interview with Mr. Reeves. He admits he had absolutely no experience in dealing with self-defense cases. But he makes a decision within a minute with brass. Did he really go to brass? Did he make his decision? Is this a case that he really didn't want to investigate because it wasn't supposed to be assigned to him? Was it just dumped on him? His partner was supposed to be Aaron Smith, crime scene detective, right? He had just gone into the homicide unit in December of 2013. Why are we putting Aaron Smith as a lead crime scene detective when he just joined the homicide side of major crimes in December of 2013? Do we remember the number of police officers that were read out loud before jury selection? Monumental. There were 130 some witnesses. They had the entire battalion of the Pasco County Sheriff's Office there at the theater. Aaron Smith. That's the guy they choose. If you remember, he started doing interviews first, right? Because he wasn't supposed to be that either. When he first got there, it assigned him to do interviews. Now, did he become crime scene detective because Proctor, the mentor, suggested that that's the position that he should have? Only doing one crime scene investigation before. As a crime scene detective, back as early as the academy, as the lead detective in the case, both of them, back as early as the academy, every single police officer that came before you, I asked that question. Tell me what was told to you as early as the academy. Rick, what was told to me is that I had to be very careful with the issue of contamination, witness contamination. Well, why did they want you to be so careful with that? They wanted me to be so careful with that because it is a big, big problem in that individuals that talk to each other, whether that information is right or wrong, they adopt that information as their own and start believing it as their own. And you can't, he testified, you can't undo it. Because you don't know reality from falsity. And how did we experience that here in this very courtroom? How do we know that happens beyond every expert telling you they came up here, every police officer? How do we know that? Let's talk about an interesting fellow by the name of Mark Turner. Mark Turner was married to Mrs. Turner, right? Joanna. And Mark Turner was called by the prosecution. Now they're saying, again, it's not important contamination. You experienced it here. What did Mark Turner tell you? He said, I came into the theater during the middle of the previews. And when I sat down, Mr. Oulson was standing up. And he was facing Mark Turner. And he was standing up in front of what would have been Vivian Reeves. And he was just standing there. He was playing with his phone, looking at me. And when Mr. Reeves came up, because remember, Mr. Reeves wasn't even there. Mr. Reeves came up the stairs because he had been at the manager's desk. Now let's think about that. This witness that truly believes that Mr. Oulson was standing up, playing with his phone during the entire time that Mr. Reeves was gone. Did you hear that from anybody else? How can a witness believe that? It's worse. Madam Clerk, may I have the pictures of Mr. Reeves?
You know, as I'm watching this closing argument, I can't help but think of something I've said before on the show. I'll say it again. One of the keys to being a great trial attorney is knowing when to sit down. Let me bring in an excellent trial attorney we have watching along in Akron, Ohio, where he practices criminal defense. He teaches trial advocacy to lawyers and law students. Don Milarczyk is standing by. Okay, Don, give us your assessment of this close, if you would, please.
Too long and too disorganized, Julie. You're absolutely right. You have to be disciplined as a trial lawyer, and you have to have a theme, and you have to make sure that your closing argument has a beginning, middle, and an end. You want to end on an emotionally powerful theme that drives home your point of innocence and your theory of self-defense. What I've seen here is this defense attorney that seems to be meandering around every single point that he thinks of, and then digests it, talks about it. I can't find him moving forward in a consistent manner. He talks about a point, then he circles back to another point. If you noticed, the objections are getting sustained more often than they were in the beginning of this case, but I think he missed a really golden opportunity to really give a powerful, tactful, insightful, limited 1 hour closing argument. You got to remember, it's Friday. The jury's got to be tired. They've been sitting there all day, so you have to be respectful of their time, more importantly. And I'm feeling that this defense attorney has squandered that respect that he has to have for the jury's time and their efforts in this case.
Oh, you're absolutely right. I know you read the jury every time you're in trial, right? And you're looking at the clock thinking, okay, if I'm hungry, their lunch bells are going off too, right?
Right, absolutely. And that's it. I mean, I understand, right? This is your closing argument. This is a case that he cares passionately about, and you really want to make sure that you do a good job for your client. But this isn't about you. It's about the jury. And you got to believe and respect that they understand the evidence. They heard it all. They don't need to be lectured about it on every single witness. And that's when you start to lose some of your credibility as an advocate in front of that jury.
Bingo. Don Milarczyk, we could talk to you all day. We have to let you go, though. It's Friday. You've got to get your weekend started. Thank you so much for being on the program. We'll see you next week. And thank you for being with us. Don't go anywhere there, because there's so much more to come. Ashley Wilcott is going to be here next. We're going to see Rebuttal after the close. And then today, we're going to be on a verdict watch. I'm Julie Grant. It's been great being with you.
Are you on Medicaid and Call 800-279-5106. 800-279-5106.
Believe that this cell phone light was so incredibly bright that it was ruining his movie experience for the previews.
The danger facing Curtis Reeves need not have been actual.
Because he's a fragile egg that at any moment can break and be killed by either popcorn or even a fist. We got to address it.
He's not a trigger happy retired police officer.
Breaking news this afternoon, we are in closing arguments in the movie Popcorn murder trial. The fate of Curtis Reeves will soon be in the hands of the jury. We'll get a live report from Dade City, Florida later, and our legal experts will discuss which side made the best of their closing arguments. And in Kentucky, Court TV has been in the courtroom monitoring the trial of Brett Hankison. He is the former Louisville police officer who's charged in connection to the botched raid that killed Brianna Taylor. Today, jurors visit the crime scene. We are bringing you all the important moments from those trials, as well as other legal headlines from Ghislaine Maxwell and Scott Peterson. All that and more coming up this hour. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Honored to be with you this Friday afternoon. We want to start first and return to the courtroom in the state of Florida in the case against Curtis Reeves. You have not missed any of the closing argument. Mr. Escobar, the defense attorney, is continuing to make his closing argument. Let's go back in that courtroom. You have not missed a thing.
Flashlights instead of the spotlights that were in the trunk. What else did Detective Smith do in this case? I can tell you, right from under his nose, video evidence in this case was seized by a private entity and flown to Alabama. Do you think that when Detective Proctor went into that theater and he looked up and he said, ooh, got some cameras there, you know, that could be wide angle cameras, you know, hey, listen, I want to go see that immediately, certainly before I charge Mr. Reeves. No, he couldn't do that because he charged Mr. Reeves before he went into the theater. But could he do it after? Say, well, listen, I've already charged him, but let me take a look at that video and let me see what it has, so that if it has something that corroborates Mr. Reeves's testimony, I can maybe uncuff him and say, hey, we're going to take this slow and we're going to really do our job here the way that we're supposed to do it, so that innocent people aren't convicted. DNA and video. How many times in America do we see individuals that spend...
Objection, improper argument.
DNA. Can use it today. Can use it 20 years from now. 30 years from now. To find out the truth. With one exception. When you grab a phone and you mess with a phone and you destroy the ability to get DNA in its original form, in its virgin form. What did Detective Smith do to compound the problem? 2 weeks later, still had not been processed for DNA. Detective Proctor tells him, hey, Smith, I need to find out whose phone that is. Can you go into evidence and let's open up those packages and let's turn on that phone and see whose phone it was, despite the fact that they already had information from Mrs. Oulson that this was her husband's phone. Yeah. Who else's phone could it be? Well, wait a minute. Okay, you really need to find out. I get it, detective. Before we open the package, forensic investigators, come here. Let's swab the phone, preserve DNA, then you can do whatever you want with it. Nope. Let's get another glove. Let's grab the phone. Let's turn it on and continue to destroy evidence that was so crucial in this case. Was it total ignorance? Was it? It doesn't matter. These two detectives were a train wreck. And so they have to go to Alabama, despite the fact that Busone, this was one of the greatest moments, I think, of this trial for Aaron Smith, because he got up here and he says, Detective Busone is my friend. He's a good friend of mine. Detective Busone is. Like if somehow Detective Busone was going to protect him. And Detective Busone, because remember, Mr. Smith has said, oh no, it wasn't me. It was Detective Busone that had to go do something else, and that's why I took over the video process of this case. Detective Busone came in here under oath, despite the fact that he may be friends with Mr. Smith, and said, oh no, it didn't happen that way. He was the one that told me, get out of here, I'm handling this. So what do we think about that? Can we have confidence? Can we have confidence in the investigation? Do we need that confidence? Or do we just say, it doesn't matter? Detective Busone, God bless him. What's ironic about Detective Busone is that who imaged the hard drives when they finally got their hands on them? Detective Busone. He told you what he would have done, certainly not giving the cop theater any authority to do anything with that. He needed search warrants, whatever was needed. He was going to do it. He was going to image it. He was going to preserve it. Now somehow, 15 hard drives, 10 hard drives, impossible to decipher at this point. Because guess what? When they went to Alabama, they never opened the case. They never opened the case. Peck gets sued. They never opened the case. Some lawyer, not all lawyers, are trustworthy. Not all doctors are trustworthy. Not all architects are trustworthy. You got some lawyer that's representing Comp Theater and they say, oh, thank you very much. You've given me this case. Oh, you've given me this list. Is that what's in there? Yes, that's what's in there. Okay, well, we're not going to open it. We're just going to take it over to evidence, or we're going to put it in evidence. There could have been 3 kilos of cocaine, nobody would know. Until they opened it. Is that the kind of investigation that we demand in our criminal justice system, to have the confidence to make decisions? Or is that the kind of evidence that the law and the rules and the jury instructions tell us absolutely not? You've got a burden, and you better meet it with evidence that we can feel comfortable and reliable. And so what happens? They come back, and at some point in time, they give this suitcase, whatever it was, locked to Detective Oulson so that he could copy whatever was in it. I think we've talked about Susan Miller and the fact that she had a very limited role, but a very important role here. And that is recognizing that when she looked at Curtis Reeves, you could tell that he had some injury and wanted to document it. John Sillis was the midnight rider. He was the employee that was summoned over to the Comp Theater in order to seize the hard drive. He did a pretty good job. Approached the deputy there and said, "Hey, I'm coming to get evidence," and the deputy just led him right through. And remember what Mr. Peck told you? Yeah, that's exactly what he did. And you know what? When I got back from vacation in March, it was a brand new system. Sillis, Peck. We talked about Dawn Simpson. She had absolutely no interest in anything in this case. She was there at the counter trying to get some posters for her daughter. And she told you without hesitation, when I looked over at Mr. Reeves, he waited patiently. When, I stepped over to the side and I heard that conversation, it was a conversation of a calm man, polite man, not an angry man. Matt Reeves. Likewise, a law enforcement officer for the Tampa Police Department. Who was the first one to come to the aid of Chad Oulson? Matt Reeves. He was the one that caught Matt Reeves. They caught Mr. Oulson. And summons another individual. Hey, help me. At that point in time, he didn't know who had a weapon, who didn't have a weapon. But he immediately went to work on Mr. Oulson to try to save his life. And of course, he's a police officer, so he's a liar. So he says he's a police officer, he's a liar. When he came here and told you under oath, just a lie. So you know what? Disregard it. That doesn't matter. I submit to you that Matthew Reeves heard his father's cry that day on January the 13th of 2014. What's shocking is that when Detective Smith interviewed him, and he drew a diagram of what was taking place for Detective Smith. What did Detective Smith do with that diagram? Did we see it? Did we see that diagram? No. Detective Smith destroyed a piece of evidence that Matthew Reeves constructed for him. A witness there at the theater at the time of the event. Dr. Michael Knox.
Mr. Escobar, we got to take a break.
Yes.
Take 10 minutes.
And the judge just said, Mr. Escobar, maybe let's please take a break. So he has been doing his closing argument in this case. While they take a break, we are going to take a break. When we come back, we'll bring you more of this closing argument by defense counsel in the Curtis Reeves case.
In honor of Black History.
going to take you right back into the courtroom in Florida. The question becomes, is Mr. Escobar doing a convincing job for this jury to walk away and determine that this shooting was done in self-defense? Let's go back into court for continuing closing argument by defense counsel.
Deputy Demas, Roy Bedard. Remember their testimony, because it all matters. Roy Bedard, the only use of force expert that was presented to you today, gave you an opinion under oath that absolutely refuted the government's theory of the prosecution. Their previous witness. Bruce Koenig. I'm going to show you two small clips that Mr. Koenig provided us so that you could see all the evidence. Matt, go ahead. May I stop it right there? Who is it? Clear in the other row. Row A. Chad Oulson. What's that? 1, 2, 3, 4, 5, 6. At that very moment. A coincidence? The phone? Or the shoe? If it's the phone, the phone. If it's not the phone, it doesn't matter. That's the one thing that doesn't matter, because where did we find that phone? In between Mr. Reeves' legs, immediately after the shot. They've given you absolutely no evidence as to how it got there. But if it was the shoe, and that leg was moving, it was moving for a reason. Mr. Oulson. First attack. Next one, Matt. Stop right there. The best that we could give you in trying to really feel from seat number 9A what this gentleman was seeing was this. Matt, go through the progression, please. Ladies and gentlemen, this all happened within seconds. The actual shot, 0.72 seconds. Less than a second was the shot. And Roy Bedard nationally recognized expert in the field of use of force, told you under oath that Mr. Reeves did not fire his weapon in response to the popcorn. Thank you.
Please. Defense counsel has finished their closing argument. Has it been successful? I'd like to bring in at this time our guest legal analyst with us today, Karen Felicia Nance, criminal defense attorney from San Francisco, California. Karen, always great to have you on. Tell me, do you think this defense counsel has done an effective job convincing this jury that Curtis Reeves shot Chad Oulson in self-defense?
No, I don't believe that defense counsel has done a good job. I think that the prosecution did an amazing job, and they were a lot more organized on the prosecution. It was long, not nearly as long as the defense's case, but the prosecution was very artful, I believe, in starting with the facts and then went to the law. Now, the representation from the defense was that they were going to start with the law and go to the facts. They did start with the law, and then there was just a mishmash, back and forth, back and forth. It was very disorganized, a lot of repetition of the facts. And I think that the whole tone of the defense was questionable in that it wasn't just impassioned, it was jarring. At times it was yelling, at times it felt like a lecture to the jury, and I don't think that that was effective. In the length of the closing of the defense was just too long.
And that's what, I love to read what our viewers are saying, especially on things like Twitter. And that's what people are saying. It's too long. This defense attorney has been going on for too long. But let's talk about some other aspects of the closing, because not only the tone that you've described as well as the words, what about the fact, did you notice that, number one, the courtroom's packed with family for both sides? You have the victim who was shot in her finger, as well as was married to the victim, Chad Oulson, who's deceased. Nicole is there with her family. On the other side of the courtroom, you do have family members related to Curtis Reeves, his wife, children. They are all there. But Nicole, Chad's wife, who was shot in the finger and was in the movie theater that day, have you noticed she has been very expressive? She has been talking to the person seated next to her, who I believe is her brother or brother-in-law. I think it's her brother. In any event, all of that's been going on at the same time the defense has been making their closing argument.
Right, and I think rightly so. I mean, she lost her husband. She suffered a serious injury to her wedding finger, no less. And so that's going to be with her the rest of her life. Just every morning she looks up, knowing that her husband's not by her side, and then going through whatever debilitating injury that she suffered from the shotgun. So this is a trauma that will stay with her the rest of her life. I do see that she is making some comments, but it's not disruptive. She's very quiet. She's not making any unusual noises or anything like that that's calling attention of either of the attorneys or the judge. So I think that she's being respectful. On the other side, when the prosecution started their case, I did see Mr. Reeves kind of grimace, like a look of not disgust, but not agreeing with what the prosecution was saying. I believe his wife, Ms. Reeves, has been very stoic. The daughter, she's been very her expressions have been very even. And the son, Matthew, he just looks down for the most part. So I think that everyone's holding themselves and respecting the rules of the court and not being disrespectful in terms of the immediate family of both Mr. Oulson and Mr. Reeves.
And I agree with you, Karen. If I were on the bench during this trial, I don't think anyone has been disrespectful. But I'm also going to suggest this. If any attorney loses the attention of the jury because they're talking for a long time or they're not compelling in their argument, guess what? I always notice jurors are then looking around the courtroom and looking at other people people, they might lose focus on the attorney who's trying to convince them. So are they noticing what family's doing? Don't know. So we'll have to wait and see what this jury does. You're going to stay with us. When we come back, there will be a rebuttal argument by the state. What will the prosecution argue? We'll be right back on the other side of this break and bring that to you.
The following information is for
Welcome back to Court TV Live. Good Friday afternoon. I'm Ashley Wilcott. We will get back to our trial coverage in a moment, but first, we want to get you caught up on several legal stories across the nation. President Biden has nominated Federal Appeals Judge Ms. Brown Jackson to the Supreme Court today, the first black woman to hold that position in the court's 233-year history. Jackson's nomination delivers on Biden's campaign promise to place an African-American woman on the Supreme Court. Jackson is a Harvard Law School graduate and received bipartisan support when she was confirmed to the U.S. Circuit Court of Appeals. A juror from Ghislaine Maxwell's sex trafficking trial will be questioned under oath to determine if he tainted her conviction. This man is known as juror number 50 and indicated on a juror questionnaire that he had never been a victim of sexual abuse. However, during an interview, he later revealed that he was, and this happened after the trial's conclusion. Not only that, juror 50 says he relied on his experience as a sexual abuse survivor to sway other jurors during those very same deliberations. The judge has denied Ghislaine Maxwell's bid for a new trial at least until after the hearing, which is scheduled to take place on March 8th. In another case that hinges on a potentially biased juror, Scott Peterson. He will be back in court today for a motions hearing in his habeas corpus case. Juror Rochelle Nice, nicknamed Strawberry Shortcake, is expected to take the stand today. She is accused of lying about her history of domestic violence so that she could get on that jury and then vote to convict Peterson, and he was convicted. The hearing is scheduled to last a week. Scott Peterson was convicted of killing his pregnant wife, Lacey, back in 2002, and he is currently serving life in prison without parole. And that's it for your legal news briefs. We want to take you now back into the courtroom in the state of Florida, where, as you know, with the trial, this state has the opportunity to present a closing argument, and then the defense, and always in our criminal justice system, the prosecution can have the last word. We're going to take you back to court now because the prosecution is about to present their rebuttal.
At the beginning of the case, in opening arguments and also during jury selection, we had a conversation about sympathy. So it's important to remind you all about sympathy as we get to the very end of the trial. Now, as you all know, sympathy should never play a part in the justice system. It wouldn't be fair to anybody. We would not want you to find the defendant guilty because you felt bad for the Oulson family. Wouldn't be fair. But in the same vein, we don't want you to find someone not guilty because if for any reason you feel bad for the Reeves family. Now, sympathy, of course, is a human emotion, but it really does have no part in the criminal justice system. In fact, there's an instruction that Judge Barkel's going to read to you, and I'm just going to read it to you very quickly just to show you that it's in there. It says, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. So I know it goes without saying, and I almost feel bad saying it, I know that you won't let sympathy affect the verdict. You also know that the judge is responsible for any sentencing. You should not let that factor into your deliberations at all. You are the fact finders and the law appliers. Any sentencing issue is for the judge. Now, sometimes in trials what happens is this. Sometimes when you walk back in, and I know this might sound silly, but sometimes when you walk back in, someone might be in the audience. Might be a family member, might be a friend of either side. They might give you a smile or a glance, or sometimes people look away. Obviously, that does not have any impact on your deliberation. If any of us looked over and smiled, or at some point we looked like we weren't happy, the same for the defense table, has no bearing on the case. It would kind of be like putting it into the shiny object portion. It really doesn't mean anything at all in this particular case. So it's just very important for you to remember that. There were some comments that were made during defense counsel's closing that I do want to address. And then afterwards, we're going to fairly quickly just go through some things on the video, and I'm going to sit down. A couple very minor points, quickly address them. Defense counsel in his closing argument talked about DNA, how the defendant here could not be excluded. Well, there was a stipulation that was read, and really what the stipulation said, one part of it was there was not enough DNA on the phone to determine anything. Couldn't be included, couldn't be excluded, didn't mean anything. There just wasn't enough DNA on there. Doesn't really matter, because we all know based on the evidence, this phone was never thrown. The reason that the phone was where it was because either of two things happened, and no one knows. But the reasonable inference from the evidence is that when he reached over for the popcorn, it fell, or at the time he was shot, it fell. We know for a fact, though, with 100% certainty, that at no time was that phone ever used as a weapon, wasn't used to punch the defendant, and certainly was never thrown at the defendant. We know that for a fact because why? Because there's absolutely no injury. And even if that was some miracle, there's not a single person that saw an attack with a phone in the entire case, including his wife. We know with 100% certainty there was no phone at issue. The reason it's on the ground is because it was dropped at some point in time. That's it. There was another mention in closing argument from defense counsel about how if you have a phone, you have this phone, it should be placed into airplane mode. Here's when that's important. If a phone is being searched for videos or for photos or for text messages, the content, you can save the content by putting the phone in airplane mode, or you put it into a certain box. If you're going to be looking at it for DNA, which in this case doesn't matter because it's just a shiny object, but if you were looking at it for DNA, you don't care if the phone's on or off. That's just a shiny object. Doesn't mean a single thing. Defense counsel talked about the timing of certain things, and we'll go through it on the video. But he mentioned that Nicole Oulson stood up, and prior to the popcorn being thrown, she had her hand on Chad Oulson and she was holding him back. Well, how do we know that's not true, that that's not the proper timing in this case? Number one, it's not on video. Number two, we go back to this point about eyewitnesses. Not a single person testified that there was a struggle where Nicole Oulson was trying to hold back a charging Chad Oulson. Who didn't see that? There's nobody in the entire case that saw that happening. And if it happened right in front of who? Vivian Reeves, Jane Roy. Nobody saw that. Why? Because that never, ever happened. You keep going back to the defendant starting it and the defendant ending it and a popcorn toss. And that really is this case, unfortunately, in the most simplest of terms. That's just what happened. It's sad, but that's exactly what happened. Defense counsel brought up, and it's kind of the reason why I brought sympathy up with you, all these things that the defendant had done. But it almost seems like the argument is this. Because in his past, he did these things. You know what? We shouldn't be having a trial. We shouldn't have you here as jurors to even discuss the fact that Chad Oulson was unlawfully killed. He's excused from killing someone based on his background, training, and experience. And if you think about that, it's really an unbelievable argument. Now, in theory, we have laws in the United States that apply to every single person, in theory. From the President of the United States all the way down to Pasco County, every single one of us is bound by the same laws. You can't unlawfully kill somebody. It doesn't matter if you're the head of security at some point in your life of Busch Gardens. It doesn't matter if you're a police officer. It doesn't matter if you're a police officer today. Police officers are not given free passes. Nobody is ever above the law. Ever. You never start out one step ahead. Ever. It's as if to say, you know what? Chad Oulson's life was meaningless because he graduated summa cum laude. Chad Oulson's life is meaningless because he started the SWAT team that they use today. Chad Oulson's life is meaningless because of the things he did at the Tampa Police Department. His life is meaningless. We shouldn't be here. That's sort of what's being said. Nobody ever starts above the law. Ever. Doesn't matter who you are, doesn't matter what job you have, it doesn't matter how much money you make. We're all judged equally under the law, no matter what. He killed another human being in a crowded movie theater next to his wife for no reason. Nobody should care what he did in his past. It's what he did on January 13th of 2014. He killed another man in a movie theater. Defense counsel talked about this first attack happening so quickly. It happened so quickly, he didn't even mention it to Detective Proctor, right? It's because it never happened. There was a conversation about Detective Proctor making a mistake because he never, ever had investigated a self-defense case. And I mean this as almost sarcastically as I'm going to say it. If he never investigated another case after that, he still has never investigated a self-defense case, because this is not a self-defense case. We're going to quickly go through the video. It's kind of like the cross-examination with the defendant.
The state is summing up in rebuttal their position. This is not a self-defense case. You're not going to miss any of this rebuttal. We're going to take a break. When we come back, we'll go straight back into that courtroom right where we've left off.
Retired Police Captain Kurt.
Let's get you back inside the courtroom in Florida where the prosecution is having the last word in their rebuttal to the jury.
computers, if you get the computers in the back, the MOV files are the ones you can open with QuickTime. Of course.
Yep.
We are looking at the rebuttal argument. You can see he's having a few issues with the technology. Still with us, Karen Felicia Nance. Karen, do you think it's been an effective argument to say, first of all, at no time was that phone ever used as a weapon? We know that because there's no injury.
Based on the way the prosecution presented it, I believe it was extremely effective. There's no DNA evidence. The parties stipulated to that. No, it was inconclusive as to whose DNA was on the other than Chad Oulson's. I believe that he was very effective with his generalities, right? He said their sympathy doesn't play any place here, and nor sentencing, nor the expressions of the people in the courtroom. So I thought that was very effective.
Yep, and he also said, you know, the background of the defendant doesn't matter, what he was trained in, that really isn't the point of the fact that he did shoot and kill Chad Oulson. At least that's the state's position, that that was murder and not self-defense. Let's go back into the courtroom to see. He's trying to get the technology to work and see if he's resuming.
Here's the beginning where we were talking about the reflection being the shoe. At no time was the reflection ever the cell phone. It has always been the shoe. It's not a coincidence. This is the very first frame where you can see the defendant's shoe as he's walking. It's going to go back and forth. Always motion. That's the shoe. Now, the defense counsel talked about all these experts they were trying to get and all the money they were spending. They save a lot of money just by looking at the video because it's very obvious that it was the shoe. What's the importance of this? The importance of this is the defendant and his wife coming into the theater. And it's really nothing in that they're just walking in the theater, but the camera's able to pick them up because it's within the motion sensor area. Okay? That's the importance of just watching the very beginning. An almost insignificant event of two people sitting down triggers the motion activated camera. Now, when you're looking at this, if you can look, you see the defendant is on the left side, and this is Vivian Reeves on the right side. In front of Curtis Reeves, you can see this is Nicole Oulson. So they sit down, Nicole Oulson is already there. Here's the next time we see the shoe. He's crossing his right leg over his left leg. There's the shoe. Okay? We don't have multiple cell phones. Nothing's happening. This is obviously his shoe. No speculation whatsoever that a phone was ever in play. is leaning all the way in. Back appears to be fine there. Getting up to go to the manager.
Closing arguments in this case have gone on for most of the day. What happens next? Jury instructions. We're going to take a break. When we come back, it's the top of the hour. We will bring you those jury instructions and what the judge has to tell the jury. We'll be right back here on Court TV Live.
Are you ready?
Welcome back to Court TV Live. Good Friday afternoon to you. I'm Ashley Wilcott. Thank you so much for joining us this afternoon. We have been covering the case out of Florida against Curtis Reeves. He is the one that's accused of murdering Chad Oulson in a movie theater over a cell phone and popcorn. We're going to take you back into court because rebuttal is being presented by the prosecutor in this case. He's just about to go through the video that has a very limited view of what happened in that movie theater.
Once the defendant comes back into the theater, as Derek Friedoff indicates, once again there's bickering. Chad Oulson turns around in his seat. Coincidence? The defendant's right leg is moving. As he moves forward, you see the light. Absolutely, with 100% certainty, his shoes. And as we indicated, there is absolutely no way at this moment that a phone is being thrown as he goes forward. And his explanation for not reacting, not putting his hands up to his head, not exclaiming anything, not having any injuries was because he took karate some time ago. Now, what did the defendant indicate? Now, remember, there's this first attack. There is no first attack. However, what the defendant indicated is that during this blue screen time, and remember, we had a conversation up here. He's like, well, the camera doesn't hit row B. This camera's not picking anything up at all because there's not any type of significant event that is being recorded. So when the defendant wants you to believe that during this period of non-recording, Nicole Oulson is fighting back with Chad, who's a raging lunatic, it's not picked up by the video because it's not happened, because there was no phone thrown. It's an absolutely made-up event that didn't take place. Now, the other important part of this, I'll tell you in a second. So now he's reaching over, he throws the popcorn. The popcorn has now hit him. After the popcorn has hit him, the defendant is going forward. Now, there's another flash down here, which is obviously his shoe. He has been hit with the popcorn. The gun's at the hip. He reaches forward, and he shoots him. Popcorn, thrusts forward, and shoots. Now, Roy Bedard. Let's talk about Roy Bedard real quick. Roy Bedard did testify 2 years ago in a case that I prosecuted. And what Roy Bedard does is he travels around the country, testifies for the state, testifies for the defense, and he educates juries on self-defense. Now, the unlogical or the illogical leap is that because Roy Bedard didn't testify for the state in this case, that means the defendant's not guilty. That's the extremely illogical leap. Because if you took that position, anytime somehow Roy Bedard becomes the person that is critical for any case. So for the rest of my entire career as a prosecutor, if Roy Bedard testifies in a case where I'm the prosecutor and he's on the defense side, I guess I should just hang it up, right? I'll just jump off the case then, because if Roy Bedard's on the other side, that means that person's not guilty. That's how illogical that argument is. Now, we know, based on the evidence, that this was, unfortunately, about popcorn because of the defendant's statement. But let's, for just a second, let's suspend the reality, because that's what the defense wants you to do, is suspend the reality that it was about the popcorn, and that it wasn't. What that means is, if you want to believe what Roy Bedard stated, and he wasn't asked, who knows if he knows anything about the defendant's statement about popcorn hitting him? We don't know. No one asked that question. We don't know where that information came from that he testified to. But let's just suspend reality because we know the defendant made that statement. If he started the process of shooting and killing Chad Oulson, think about this. It's worse for him. Because what's happening right here? There's not a single thing that's happening here. So he made the decision to kill him for absolutely no reason. But in reality, that's not true. You have to suspend reality. Because what happened was, after the shot, he made it clear why he did it. He had an explosive moment of anger. He was angry because of what happened with Chad, because Chad was standing up for himself, was saying things about texting his daughter. He reached over, he grabbed the popcorn, and he threw it on him. And when he had his hand coming back, that's when he was shot. He was not about to attack him. There wasn't any imminent threat of death to the defendant. Wasn't any imminent threat of great bodily harm. I'm not going to go through all the jury instructions with you. That is this case. That is really this case. That's the end of it. There was a question asked by defense counsel, Detective Proctor. A series of questions. And when I heard them, I thought, that was a really great set of questions, but not for Detective Proctor. And I wrote them down, so I'm going to give you a version of it. If it's not exact, it's not exact. But it was a really good set of questions. But when I say them, I want you to think about it from the defendant's point of view, not from Detective Proctor's point of view. And this is what the questions were. Is it important to be right and accurate in a homicide? Dealing in possibilities is dangerous in criminal court because a man's life is in your hands. And that's really powerful. And that's exactly what was at issue in this particular case. The defendant here had a man's life in his hands in a movie theater on January 13th of 2014. Chad Oulson went to the movies and he never came out of that movie theater. His life was taken from him. It was an unjust shooting. He didn't deserve it. Not under that fact pattern in that theater on that day. We come back full circle. The defendant started it. The defendant ended it. And yes, unfortunately, a man was killed because popcorn was tossed. The defendant is guilty of either murder in the second degree or manslaughter. And he is guilty of aggravated battery as well. Thank you.
Thank you, Mr. Rosenwasser. Yeah, just push it back. That's fine.
We are watching the rebuttal argument made by the state in this case, saying to this jury, he is guilty. It was not self-defense. It was murder in the second degree and also aggravated battery, and that's for the shooting that injured the finger of Nicole Oulson, who's married to Chad Oulson, the one who was killed by the shot from the defendant. The defendant has never denied that he shot Chad Oulson. In fact, he even said while on the stand, he intended to shoot Chad Oulson. He says it was in self-defense. This jury is going to have to make that decision, and whether or not he will be acquitted because it was self-defense, or in the alternative, found guilty of murder in this case. Still with us, we have Karen Felicia Nance, criminal defense attorney, PI. Also want to welcome from Phoenix, Arizona, former criminal defense attorney who represented Jodi Arias, Kirk Nurmi. Thank you for joining me, both of you. Kirk, let me start with you, if I could, please. What has stood out to you about these closing arguments?
Well, you know, it's been said over and over probably by now, but the length of this defense, or excuse me, yes, the defense closing was unbelievable. I mean, I think back, I did death penalty cases, 4-month-long trials, arguments might last shorter than they took in this case. And there was a lot of irrelevant information they advanced. So I wondered at what point in time, when they were advancing this information and they were getting all these objections from the state, the jury was probably agreeing with this is not relevant, how they turned the jury in terms of this long meandering argument. So I think that was one of the big highlights, and I think that's why we saw the state come back in their rebuttal and give a pretty brief and saying all this stuff is irrelevant. What happened in the theater is what you need to focus on, which is exactly what the jury should be focusing on and probably wanted to hear at that moment in time.
Karen, strategically, do you have any thoughts about the fact that Kirk's right? There were a number of objections during the closing argument by the defense, and the objections made by the prosecution, that's never done lightly in my experience on the bench, because we know trial skills wise, you're not supposed to object during closing argument unless it's so egregious that you really need to. You need to give them the respect to make their argument. But there were a number of them, and the judge sustained a number of them for the improper argument. Do you think there was any strategy around trying to get a mistrial or trying to do something other than just making argument?
I don't know, Judge Ashley, what the defense's motivation was for arguing things that they knew were not going to be admissible. It doesn't hurt, I guess, from their perspective to try to see if it can slide in, and maybe the prosecution won't object, or maybe if the prosecution objects, the judge will not sustain the objection. That didn't work in this case. And I agree with Kirk that it was very long and rambling, the defense's case in terms of its closing. And I would have expected more from these two attorneys that are very skilled, have been working on this case since 2014, that they would have had it together better than they presented it. I thought it was very masterful what the prosecution did in their opening, the beginning of their closing argument, and both with the rebuttal, because it was short, it was sweet, it was direct, and I think that the jury by that time was ready to just get on with the rest of the trial. But I think they really appreciated the fact that the points were made by the prosecution very succinctly, very directly, and I think very persuasively.
And, you know, both sides did use demonstrative aids, being the video and what the picture showed when there was when it was stopped. And I think that that's always helpful to a jury, because when it comes down to it, to both of your points, you're right, Kirk, it has to be a decision as to what happened inside that movie theater. You are both going to stay with us. We're going to take a break. When we come back, we're going to bring you more of what is going on in this courtroom in the Reeves case, and Julia Janae will be joining us live.
In honor of Black History.
Okay.
I'll be back in a minute.
All right. I'm gonna deny the motion for judgment of acquittal. I find that the state has provided evidence to overcome the argument of the defense. Thank you. All right.
And back to the movie Popcorn Murder Trial. You can just see what happened in court after all of the closing arguments, rebuttal were finished. The judge denied the motion for an acquittal. Not surprising. That's not unusual in a criminal trial, but you always want to make that if you're a defense attorney and put it on the record. Now I'd like to turn to our own Court TV legal correspondent, Julia Janae, live outside the courthouse. Julia, I know that you've been there, you've been in the courtroom, you've been covering this trial. Tell us first of all, any emotional reactions today inside of the courtroom?
There were emotional reactions during those closing arguments, really more than we've seen during this trial. It just shows you things are coming to a head inside. There were more people in the gallery than we've seen on any other day. And it's a moment that happened during the the closing arguments for the defense in this case. The attorney for Curtis Reeves, Richard Escobar, was explaining to this jury how Chad Oulson was acting in the moment of this confrontation, that he was someone who was coming after the defendant. And he said the wife of the victim, Nicole Oulson, that she knew about how her husband was going to be reacting. There was a moment that got even a reaction from her, as she has been sitting so composed during so much of this trial. Take a listen.
He's seeing those arms coming at him. He told you before that situation, I knew that I had to retrieve my firearm because this guy was coming at him. And Mr. Oulson's very wife was trying to hold him back and couldn't. I want you to think about that. Here's Mrs. Oulson. Her husband has got to be somewhere, either directly in front of her, whether she's seated halfway or totally up, or to the right of her. She's using her left arm to hold him back. Now, that's pretty awkward if he was here, but not so awkward if he was right in front. Why would Mrs. Oulson have to hold her own husband back? Because she knows his violent tendencies?
Your Honor, it is completely improper and evidence that is not before this court.
You hear there the objection from the state over that comment there. And Nicole Oulson, her reaction after this was looking at the defense counsel, shaking her head, saying, he's a liar. He's a liar. That isn't what happened. There isn't any kind of violent tendencies that I knew about from my husband. Not too long after her shaking her head like that, she was then crying. And you really haven't seen her break down in any emotion during this trial. Her attorney has said that she's been holding it together. She's flipping out inside. But it seemed that with that comment, she was no longer able to hold all of that in, just hearing the characterization of how she felt about her own late husband.
Thank you for all that information, and also noting how many people are in the courtroom on both sides. You have her family on the side for the victim, and you also have the other side with lots of people there supporting the defendant in this case. Tell us, if you would, please, let's break it down by argument. First of all, the prosecution's closing argument. They go first, of course. What are your takeaways from that?
You know, Scott Rosen, he was very direct in his closing argument. He went through the elements. He was very passionate, brought a lot in front of this jury, and he didn't take a lot of time when he was doing his closing argument to them. He told them that you have to look at what happened in that moment, that this is not a defendant who would get sympathy, would deserve sympathy, or even that sympathy should even play a role in this case, but rather that you look at the law and apply it. Take a listen to how he characterized it in front of them this morning.
No human in the world gets hit with a phone that hard and doesn't yell, ow, oh my God, I can't believe this, to go for their head. It never happened. None of it happened. What happened was he killed Chad Oulson for no reason.
He kept using the words intentional, that this was something that was done intentionally, that there was no thought given to Chad Oulson's life, that you don't get to shoot someone just because they throw popcorn on you, just because there's a punch. These jurors taking it all in. Hard to tell the difference between how they looked as far as receiving the information on these closing arguments, but I can tell you that they were a lot fresher in the morning during the listening of the prosecution closing arguments, and that changed a bit once we got to the defense's side, Judge Ashley.
All right, before we talk about the defense's side, it's different in different courtrooms. Were they allowed to take notes during the actual closing arguments?
As far as I know, they were allowed to. I didn't see a lot of note-taking, so whether or not that meant that they didn't have their notepads there, but it did not seem that the judge has taken their notepads from them. Another interesting optic inside of this courtroom is the fact that because of these monitors that the attorneys chose to use that were not the typical courtroom monitors, the jury is really the only one who gets to see a lot of this evidence that was coming in. That required Judge Susan Barthel to have to come down and sit in a chair that's right next to the jury box so she can see all of this evidence, and she let them know that this is what she would be doing periodically during the trial. But when you're looking at it from the gallery, she almost looks like a juror there. She's sitting next to them, taking note of what's going on. She's being thoughtful, and I'm sure these jurors are on a little bit more high alert, knowing the judge is right there next to them as they are taking all of this in.
And you and I both know from handling trials, covering trials, that that is not what we see most of the time. All right, let's move now to the defense's closing argument. Tell us, if you would, what you noticed about that argument that they made.
Richard Escobar went considerably longer than the prosecution did with their closing argument. And what wasn't of their benefit is that we were getting so close to the lunch hour. So I did notice some jurors seeming to be a little bit strained in paying attention. They definitely did still give their attention to the defense closing arguments, but just because of the length of time, there seemed to be some lulls in their attention span. But I will say of Escobar, great attorney, someone who was very passionate as well in front of this jury, and he used a different noise level depending on when he was talking, a really dramatic difference. He started very fiery when talking about the law and then drew it to a very smooth, calm voice that really made it a struggle to hear in the back of the courtroom. Take a listen to that contrast.
If after carefully considering, comparing, and weighing all of the evidence, all of it, ours and theirs, there is not an abiding conviction of guilt, but it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond and to the exclusion of every reasonable doubt. If you have a reasonable doubt, you shall, not can, not possible, you shall find the defendant not guilty. Because it's their obligation and it matters. Not once in his entire 27 years of law enforcement, not once, did Curtis Reeves pull a gun and fire that gun, which is not a trigger-happy retired police officer.
Escobar got up close and personal to this jury. He spent a lot of time very close to the jury bar where they're at the box. He talked in a voice that was just very calm there for really the majority of his closing argument that made it, I think, a little bit even more difficult for this jury to keep engaged because it just was that lull getting close to lunch. They're used to a lunch between 11 and 12. We went almost until 2 o'clock with those closing arguments from the defense. He also brought up the point of this short amount of time and the close distance between these two men, saying that that is what created the danger for Curtis Reeves. That's what created the disadvantage. And he also said a phrase that I was surprised to hear so much in a closing argument. He said that you as jurors have to put yourself in the shoes of the defendant in this situation, and that's the law, something we don't typically hear and often hear objections to, Judge Ashley, but we didn't hear an objection from the state on that particular line, even though they objected to many things during that defense closing argument.
I love talking to you about the law and trial skills because you're right, that's the golden rule. You're not supposed to do that in closing argument. You're not supposed to say, put yourself in that position. So interesting, no objection was drawn. And they did it. So we are waiting to see what happens next. I know, though, that, Julia, you need to leave us. Thank you so much for joining us from Dade City, Florida, outside of that courtroom. We are going to take a break. Of course, we'll continue to bring you coverage of the Reeves matter, but also we want to talk to you about the latest in the Hankison trial because the jury took a field trip today. That and more when we come back.
Your heater busted. Computer
tragedy that captivated the country.
Police officers shot and killed Brianna Taylor in a botched raid on her home.
Somebody shot my girlfriend.
Only one of them, Brett Hankinson, is facing charges.
The charges have nothing to do with the shooting death of Brianna Taylor.
The indictment had to do with bullets that went into an adjacent home.
Please continue to say her name.
The Brianna Taylor botched raid trial. Live coverage today, only on Court TV.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. In the Reeves case in the state of Florida, just to keep you posted as to where we are, the court has said they're not quite ready with the jury instructions, and so we're going to wait for that to begin. In the meantime, we want to turn our attention to Kentucky, where we're in day 3 of the trial of the former police officer Brett Hankinson. Hankinson, as you may recall, is charged with 3 counts of wanton endangerment because he fired shots allegedly into a nearby apartment during the raid on Brianna Taylor's home. Today is a special day in this trial as the jury is actually taking a trip to see the crime scene for themselves. We'll bring you the latest information on this trip when it comes in, but first, how did we even get there? Court TV crime and justice reporter Joy Lim-Nakrin has more on the background of this case.
It was a tragedy that became a flashpoint in the Black Lives Matter movement. In March of 2020, police officers in Louisville, Kentucky shot and killed Brianna Taylor in a botched raid on her home. Her death sparked outrage and protests. After a 6-month investigation led by Kentucky Attorney General Daniel Cameron, only one officer will face criminal charges connected to the shooting.
The grand jury voted to return an indictment against Detective Hankinson.
Brett Hankinson faces 3 counts of wanton endangerment, but not for endangering Taylor. Instead, the charges stem from shots he fired through covered glass that penetrated into a unit next door with 3 people inside. Louisville Metro Police were working on a narcotics investigation and served a no-knock search warrant on Taylor's apartment when it happened.
Officers encountered rifle fire. Officer down.
Taylor and her boyfriend, Kenneth Walker, were awakened by pounding at the door. Walker grabbed his weapon, thinking someone was breaking in. He fired his gun once, striking Sergeant Jonathan Mattingly in the leg.
EMS is around the corner right here. We need EMS here now.
Officers unleashed a hail of bullets, hitting Taylor multiple times.
911 operator, where's your emergency? I don't know what's happening. Somebody kicked in the door and shot my girlfriend. Can you check and see where she's been shot at? I can't know the stomach. Okay. Is she alert and able to talk to you? No,
This video obtained by Court TV captured an emotional Kenneth Walker just moments after his girlfriend was shot dead by police. The city of Louisville paid out a historic $12 million settlement to Taylor's estate.
As I understand, is the largest amount ever paid out for a black woman in a wrongful death killed by a police in America.
But the Taylor family says there is still a long fight ahead in their quest for justice.
It's time to move forward with the criminal charges because she deserves that and much more. Her beautiful spirit and personality is working through all of us on the ground. So please continue to say her name, Brianna Taylor.
Former Detective Hankinson, he is free on bond and has pleaded not guilty to the charges.
Joy Lim-Nakrin joins us now from Louisville. Thank you for all your great reporting there, Joy, on the ground. Tell us about this trial and some of the evidence that you've heard today, specifically around Hankinson.
Yeah, well, really the strongest evidence that the jury got to see today, I would say, was during their jury tour. They actually went to the scene of the incident in question. They got to see the apartment where Cody Etherton and his family lived. Of course, Cody Etherton and his family are the alleged victims here of the wanton endangerment, and they lived right next door to Brianna Taylor. So the jury also got to enter the apartment of Brianna Taylor and really look at the trajectory of where those bullets went through. At the same time, earlier in the day, we heard testimony from the chief at the time, Robert Schroeder, who actually terminated Hankinson from the force. Let's listen.
At some point while you were the chief of police at Louisville Metro Police Department, was there a completed PI, Professional Integrity Unit investigation done in this case?
The Professional Integrity Unit investigation was still ongoing. However, I did review the Professional Standards the Public Integrity investigation as it stood.
Okay. After reviewing that, did you make a determination regarding the employment of Detective Hankinson?
Yes, sir.
And what was your decision reference his employment with the Louisville Metro Police Department after your findings of that investigation?
He was terminated from employment with Louisville Metro Police.
Okay.
So interestingly enough, that in that termination letter, Schroeder actually cites a 2019 incident for which Hankinson was disciplined, and that involved some reckless conduct, it says, according to that letter, involving the injury to an innocent person. So you can see on your screen that portion of the letter that I'm talking about. It says, quote, "You further failed to be cognizant of the direction in which your firearm was discharged. Some of the rounds you fired actually traveled into the apartment next to Ms. Taylor's, endangering the 3 lives in that apartment. You have previously been disciplined for reckless conduct that injured an innocent person in professional standards case number 17062, for which you were disciplined on January 9th of 2019. Now, in addition to this, according to local media reports out of Lexington, Kentucky, Hankinson previously worked there and was resigned, and the chief then instructed other officers or other departments not to employ him again.
Wow, and that's just kind of crazy when you hear that evidence in terms of here we are again. Nobody was hurt, thankfully, by his gunfire that he's accused of wantonly discharging. But I will say, to hear that he has that kind of history in the past, I think has got to be hard for Brianna Taylor's family. Tell me this, Joy, as you've been there, have you had an opportunity to speak with any family members related to this case?
Yes, I have, Judge Ashley. You recall earlier in the week I did get the chance to speak to Brianna Taylor's sister, Janiyah Palmer. Well, today I got a chance to speak with Tamika Palmer, Brianna Taylor's mother, who of course has been very outspoken about her death. Let's go ahead and listen to part of her comments about this trial.
It is about Brianna. You know, it all started from that, what they did to Brianna. So to say it's not is, you know, it's the wording they want to use, but clearly it's definitely about Brianna. The charges aren't the charges they should be for this case, I don't think, but here we are.
What charges should there be?
Murder, of course. That night they did a number of things wrong, and they've been trying to cover up this thing from the very beginning. So I just don't, to charge him for wanton endangerment of one family in the neighboring apartment is insane to me. That building has 8 families total. So A, he should have been charged for 8 families, and then to not be charged for the apartment you shot into to even get into that apartment is insane.
Now, Tamika Palmer actually appeared in court at one point wearing a jacket which had a B on it, supporting, you know, her daughter, Brianna, and she was escorted out of the courtroom for that. Of course, you know, she had some feelings about it, Judge Ashley.
All right. Thank you so much, Joy, for all your excellent reporting and sharing with us how everyone is doing and what it's like to be there in the courtroom. So significant. Joy Lim-Nakron from Court TV. Still with us now, I have Karen Felicia Nance and Kirk Nurmi. I want to speak with you both about this case. Let's start with you, please, Karen. Traveling to the scene of the crime, in a case like this, they'd already had pictures introduced into evidence that showed the actual apartment complex and the common wall and all the shell casings, but they also got to travel to it today. What does that tell you, if anything?
It's very helpful for the jury. You can see something on a diagram or in a picture, but actually being at the scene and seeing the close proximity between Brianna Taylor's apartment and the apartment that's adjoining, where the 3 people were almost shot, where the bullets went into their home. 32, I believe, was the count. And so I think that it actually adds to their ability to make an informed decision in this case of whether or not this Mr. Hankinson, former Detective Hankinson, is guilty of the wanton endangerment that he's charged with. So I think it's extremely helpful.
And Kirk, you were, I know, the former attorney for Jodi Arias, or the attorney for Jodi Arias, rather, is what I meant to say. Tell me this, did you ever have any occasion to go visit the scene, or was there any motion to visit the scene that was denied? Is this typical in your experience?
No, I think these kind of field trips, if you will, are really atypical. And they're really probably only used in situations like this where a crime scene is hard to digest with pictures, right? In certain murder trials, you have pictures of rooms, what have you. They're pretty easy for people to digest. But in this case, you'd probably want the jury, if you're the prosecution, to see the completely reckless nature of this conduct, right? Because you're going to demonstrate that by, here's where all the bullets are, here's how many people were around. Yes, there was only the one named victim, but here's how many people could have been injured by Officer Hankins' reckless actions. You're going to want the jury to go back on that bus or however they got there and say, that's crazy, I cannot believe he did that. Because that's the kind of thing that's going to get you closer to the conviction you're seeking if you're the prosecution.
And walking through, I agree, is always going to give you a better understanding of where everything is relative to everything else. And in this case, we know the significance is the apartment and it being adjacent to the one in which Brianna Taylor was killed. All right, you're both going to stay with us. When we come back, we're going to return to the Reeves trial for the jury instructions. The court has been putting those together, not quite done. When we go back, we will show you what those are from the court.
Retired Police Captain Curtis Reeves
Returning now to the case in Florida against Curtis Reeves, accused of murdering Chad Oulson in the movie theater. Of course, he claims self-defense. I want to talk with our legal analyst guest today, Karen, Felicia Nance, and Kirk Nurmi still with me. And I want to talk about logistics because closing arguments have been done and we have been expecting the court to read jury instructions to this jury, and we plan to go back to that live when that happens. In the meantime, the judge has basically said not quite ready. They're shuffling papers, bringing them out. I know as a former judge, the reality is if you get to these jury instructions and they're last minute changes and then you have to make enough copies for everyone to have those, and if the jury's going to go back with them making those copies, all of those things can take some time to get those things in order before you can proceed. But unusual or not, Karen, let me start with you.
I think that it's par for the course. It's unusual, clearly, for the jury because they're not used to, these individuals are not used to the court proceedings. And so it's just one delay after another. It's Friday afternoon. They had to sit through a very long defense closing argument. And I think they're pretty much wiped out for the day. I can't imagine that if the jury instructions are going to be very long, more than an hour or so, that the judge may wait till Monday or Tuesday. I'm not sure if they're in session on Monday, but I think that expecting them to be attentive and to comprehend everything at this late hours, asking a bit much of them on a Friday afternoon.
And this is a live shot, so our viewers know, and the jury's not in the courtroom. Let's talk about this because I love Emanuela Grinberg with Court TV is there, and she is telling us about deliberations. And here's what we know, Kirk. Let's talk about some of this. That, for instance, jury questions, when they have them, will be answered or addressed in open court. They will get a computer when they're deliberating to look at exhibits, so they can choose to look at that video again and again and again while they're deliberating if they choose to. They can deliberate as late as they need to in order to reach a verdict. So to your point, Karen, who knows how late they may go and how late they're going to be there, even getting through those jury instructions before they begin deliberating. Whether or not they're going to deliberate Saturday if no verdict is reached today has not yet been decided. So that's going to be up in the air at this moment in time. Let me throw that all to you, Kirk, and say now, what is your opinion, and normal or not, in the process and where we are?
Well, certainly, you know, the process sometimes does get stalled out by logistical reasons. Remember, Ashley, we had that appeal to a motion that the state objected to, so maybe that's some of the reasons. Maybe another curative instruction was added in there. But I think Karen hit the nail on the head. You know, at this point in time, it's nearing 5 o'clock in Florida now. I'm sure the jury is just exhausted and probably wants to go home and think about this. And I don't know how well they would absorb the jury instructions, but it sounds like the judge is going to go ahead and read those to the jury today. But I think this can be a long, exhaustive process. And so the jury's going to, based on that exhaustion, decide whether they're done for the day, done for the weekend, or want to come back and get it over with. It's going to depend a lot on their personal schedules and inclinations in that regard.
All right, let's, we have live video here. We can see what's going on in the courtroom, and the judge is there, it looks like, making notes. So what we also know is that the judge has not yet decided whether or not the jury will be sequestered. She says typically with second-degree murder charges, they are not, but they'll cross that bridge when they come to it if they need to. Your opinion, Karen, should this jury be sequestered if they begin deliberations and then have to come back to finish on another day?
I believe that they should be sequestered. I think there's so much publicity out about this case, and their family members, friends, everyone's been keeping up with this case nationally, if not internationally, and I think it would be hard to avoid any of the outside influences. So I think in this particular case, unlike other secondary murder cases, this one, the jury should be sequestered.
All right, and our field producer, Emanuela, has also let us know that they were on a restroom break. It looks like, again, the judge is writing, not sure what she may be doing as she's preparing to read the jury instructions. Do you think, Kirk, that the jury instructions are likely to go back with the jury in writing on pieces of paper in case they want to refer to them?
I think that's likely. I'm not sure what the standard procedure would be in this county, but it's often the case that the jury get their own copy of the instructions. They get to take them back in consideration of their deliberations. And, you know, they're probably going to want those. Going back to Karen's point earlier, they're probably tired, so they know that they might not absorb it all so well. And particularly if the deliberations do go past the weekend or don't start anew until Monday, they might want to have those there so they can consider them when they're deliberating further, depending on how long those deliberations take.
Yep. Let's go back to court. And I thought maybe they were starting. It doesn't look like they have quite yet. I just have to say, tongue-in-cheek a little bit, but one of the things I really always hated when I was on the bench was having to get copies made during a trial, because I felt like that was always the time. The copiers did not work and cooperate, and we'd be stuck having to make copies of jury instructions that might have been changed before they had to be read to the jury. And honestly, these things happen, and it can be a frustration to the court, but it's the reality, because, Kirk, I too am familiar with and accustomed to giving the jury instructions to the jurors so that they then have those in front of them and they can actually refer to them, because let's all remember, the whole point of the trial is this jury has to determine what facts they believe to be true, and then they have to apply those to the law. Let's listen in. It looks like she's, we may not have audio on this as she begins to read the jury instructions. All right. Oh, I think we do. Let's go back to court.
They're not answering.
Very good. Jurors in the courtroom, Your Honor.
Very good. Thank you, Deputy. Thank you, ladies and gentlemen. Deputy Martin's about to hand you all copies of the instructions, and I'll get started. Thank you all for returning. Were you all able to abide by my instructions during that last recess? All right, thank you. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Statement of charge. Curtis Reeves, the defendant in this case, has been accused of the crimes of murder in the second degree and aggravated battery. Introduction to homicide. Curtis Reeves is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Chad Oulson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing in deciding if the killing was... It is the top of the hour. Time for a break. Karen, Felicia, Nance, thank you so much for all your expertise as a guest legal analyst today. We will be back on the other side with more of the jury instructions that are being read to the jury in the courtroom in Florida.
When you're looking for answers,
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Thank you for joining us this Friday afternoon. We have been covering today live the case in Florida against Curtis Reeves, accused of second-degree murder of Chad Oulson in that movie theater. And his fate awaits only the jury instructions. That's what is going on in the courtroom right now. This judge is reading the jury instructions to the jury before they begin their deliberations. Let's go back live.
Possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. One, Chad Oulson is dead. Pardon me? Yeah. And two, Curtis Reeves intentionally committed an act or acts that caused the death of Chad Oulson, or B, the death of Chad Oulson, that was A, B, the death of Chad Oulson was caused by the culpable negligence of Curtis Reeves. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. aggravation of a felony by carrying a firearm. If you find that Curtis Reeves committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm, you should find him guilty of manslaughter with a firearm. If you find Curtis Reeves committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, or used a firearm, then you should find him guilty only of manslaughter. Justifiable use of deadly force. An issue in this case is whether Curtis Reeves acted in self-defense. It is a defense to the crimes of second-degree murder and manslaughter if the death of Chad Oulson resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Curtis Reeves reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older upon him. And I'll now instruct you on the elements of battery on persons 65 years of age or older. The crime of battery on a person 65 years of age or older involves the following elements. 1, Chad Oulson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. And 2, Curtis Reeves was at the time 65 years of age or older. It is not necessary to establish that Chad Oulson knew or had reason to know the age of Curtis Reeves. Unintentional touching or striking includes situations where Chad Oulson knows that a touch or strike is substantially certain to result from his act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of an aggravated battery against himself or another. And I'll now instruct you of the elements of aggravated battery. The crime of aggravated battery involves the following elements. The first element is a definition of battery. 1, Chad Oulson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. 2, Chad Oulson, in committing the battery, A, intentionally or knowingly caused great bodily harm to Curtis Reeves or permanent disability to Curtis Reeves or permanent disfigurement to Curtis Reeves, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Unintentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing Curtis Reeves need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Curtis Reeves must have actually believed that the danger was real. If Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Curtis Reeves and Chad Oulson. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you shall find Curtis Reeves not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Curtis Reeves was not justified in the use of deadly force, you shall find him guilty if all the elements of the charge have been proved. Aggravated battery. To prove
These are the jury instructions. Every judge, I had to do it too, has to read the law to the jury so they can then apply the facts as they find them to the law for the case. Now, interesting, note the time, I don't know, 5:10 right now. This judge is just now reading the jury instructions to the jury, and she has not yet said whether or not they will be sequestered. She has said they can stay as late as they need to reach a verdict. So it begs the question, a little unusual, if they don't reach a verdict tonight, they won't have their belongings, but they may have to be sequestered. A lot that you're going to want to stay with us to find out. Here on Court TV Live, we'll be right back on the other side.
In honor of Black History
Let's go back into the courtroom in Florida versus Curtis Reeves. Although it's 5:15 on a Friday, the jury is listening to the jury instructions being read by the judge. Let's go back to live court.
Transferred intent. If a person intends to shoot a person and in the process shoots a different person, the law transfers the intent to shoot the intended person to any person who was actually shot. However, if the death of Chad Oulson resulted from the justifiable use of deadly force, then you must find the aggravated battery or felony battery or battery of Nicole Oulson was also justified. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you shall find the defendant not guilty. If you have no reasonable doubt, you shall find the defendant guilty. It is up to weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified?
Still with us in Phoenix, Arizona, former criminal defense attorney who represented Jodi Arias Kirk-Nurmi, and now I'd like to also welcome in Orlando, Florida, criminal defense attorney Mark O'Mara, who represented George Zimmerman. And I've got all the famous phenomenal criminal defense attorneys on with me today, gentlemen, which I'm very appreciative of because, first of all, I'd like your preliminary thoughts on 5:20 on a Friday afternoon after a long week of listening to testimony, very long closing arguments today, and the jury is now receiving these jury instructions, knowing that although they can stay as late as they need to reach a verdict, there's a lot to go through. What do you think about this logistical aspect of it, Mark?
You know, there's arguments on both sides, I guess, but my concern is, like you say, a week's worth of testimony, closing arguments, which the lawyers love, but sometimes can be a little bit boring for the jurors. But more importantly, if they have fatigue, how is that fatigue going to enter into their deliberations? I think that they should have probably stopped when they did after closing arguments, but come back tomorrow on a Saturday just to keep the progress moving. Give the jury instructions then, let them get a fresh start on deliberation. That gives them most of a day, which is a good lengthy period of time to do it. And then, yes, they can plan if they need to be sequestered over Saturday night. But doing it tonight, I think, is dangerous because of the fatigue. However, judges have great discretion, as you know, Ashley, to do it the way they want to do it.
Yep. And the reality is, I must point this out because when I was on the bench, of course, this this trial at this moment in time is the most important thing to the judge. However, every judge has a busy docket, lots of other trials, and we don't know when her next trial is scheduled to start. It doesn't mean that she's going to forego justice, but it was always a balancing act. Logistics in terms of getting trials on the calendar, getting them heard, finishing, getting to the next one, I think for a judge is a really tall order sometimes. Kirk, problematic or not that this jury will begin deliberating late in the afternoon on a Friday evening?
Well, we don't know that they will. I mean, they could go back and just decide that they're not going to go beyond the day, that they are too exhausted, as Mark pointed out, because they heard hours of closing arguments. Now they're hearing jury instructions. So it's quite possible that they've had enough. Maybe they want to think about it before they go into deliberations. They could take a preliminary vote to see where they're at, see if they think there's any chance of resolving it this evening, because jurors aren't going to want to be sequestered. Jurors aren't going to want to work on the weekends. I guess working on the weekends is now something that happens in the COVID era, but, you know, the logistics of opening the building and everything used to be prohibitive for that sort of thing. So maybe they'll want to work the weekend. Maybe they'll take an assessment. It's just hard to say how the jury feels individually and collectively what kind of progress they can make given their most likely exhausted state of affairs.
And you know, we know from trying cases, and I know from being on the bench, that juries handle it differently when they go back in that deliberation room and what they do first. Sometimes you hear after you talk to jurors that the first thing they did was take that preliminary vote to then decide where to go from there. Some said, no, we want to talk about everything before we take a vote. I'm so curious because I have each of you that represented very high-profile defendants, high-profile cases. So Kirk, let me start with you, Jody Arias. Did you get an opportunity to speak to any of the jurors afterwards to find out how they started when they went back there to deliberate?
Boy, it was a long time afterwards. I think everybody needed a cooling off period, but I did have that opportunity to do that with, you know, particular jurors that connected, and I won't go into those discussions for probably obvious reasons, but that was always a good thing, not only in terms of deliberations, but, you know, Miss Arias, we had a death penalty was on the table and we had a second trial at hand. So I was grateful for that opportunity, but it depends on the disposition of each individual juror. And, you know, keep in mind the Arias case was like a 5-month-long trial, so they probably had enough of hearing from me for quite some time and needed a rest.
And that's fair. It's a long trial, 5 months. And I know in this trial, we've been here for a week, still a long time, but not the same as one that goes for months and months. And Mark, you had an acquittal in your case. After an acquittal, do you even want the opportunity to speak to jurors, or is it more of like, nope, not saying a word, I'm out because I just got an acquittal for my defendant and there's nothing more that needs to be said?
Right, you sort of want to grab your trial bag and just go home. But in that case, we were reached out to by 3 separate jurors, 3 separate occasions that really wanted to talk to us about it. Part of the reason why is because there was some publicity after the fact, and people were saying that something different happened in the jury room. So there's a lot of that going on. But yes, I really enjoy win, lose, or draw. You like talking to the jurors because those are the ones, you know, you always want to be a fly on the wall. And we did get some good insight, and they did what I think they should have done, which is don't they take that preliminary vote. I don't like that because that just starts all of a sudden maybe separating the people, right, putting them off in the corners. So what they did was what I think they should do, pick the jury foreperson and then sort of move forward. Let's, you know, let everyone give their quick idea and then let's get into the evidence. And that's a more deliberative way to handle it than just starting out with that first vote, because sometimes when people say something, they stick to it, and that can be dangerous.
Yeah, it's such great insight. Thank you both for offering that, letting me put you on the spot unexpectedly to both of you, because it gives us all and our viewers real insight into what can happen back in that room that is confidential, that nobody knows about, nobody's allowed, it's not recorded, but you all have just shared some great insight. Thank you for that. Court TV is going to stay on verdict watch in the Reeves trial, but we are going to shift gears because next we are going to turn to the case of the Oxford school shooting. A judge has decided Ethan Crumbley's parents will go to trial for involuntary manslaughter. We're going to take a look at some of the crucial evidence presented at yesterday's hearing, including a video of Ethan and his mother, Jennifer, shooting together at a gun range. You don't want to miss that. Up next.
Sunday Lawn Care. Cut!
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Honored to be with you. Thank you so much for joining us. Right now, we want to get you caught up on all the biggest legal news stories here in national news. First of all, President Biden has made it official. Today, he nominated the first black woman to the Supreme Court, the first to hold that position in the court's 233-year history. This nomination delivered on Biden's campaign promise to place an African-American woman on the Supreme Court. Jackson is a Harvard Law student graduate, and she also received bipartisan support when she was confirmed to the U.S. Circuit Court of Appeals. A juror from Ghislaine Maxwell's sex trafficking trial will be questioned under oath to determine if he tainted her conviction. The man known as juror number 50 indicated on a juror questionnaire that he had never been a victim of sexual abuse, but then later revealed that he was after the trial's conclusion. Not only that, but juror 50 says he relied on his experience as a sexual abuse survivor to sway other jurors during deliberations. The judge has denied Ghislaine Maxwell's bid for a new trial, at least until after this hearing, which is scheduled to take place on March 8th. And another case that hinges on a potentially biased juror, Scott Peterson. He will be back in court today for a motions hearing in his habeas corpus case. Juror Rochelle Nice, nicknamed Strawberry Shortcake, is expected to take the stand today. She's accused of lying about her history with domestic violence so that she could get on the jury and vote to convict Peterson. The hearing is scheduled to last a week. Scott Peterson, as you may recall, was convicted of killing his pregnant wife, Lacey, back in 2002. He's currently serving life in prison without parole. And that's it today for your legal news briefs. We want to turn now to Rochester, Michigan, where parents of the alleged Oxford High School mass shooter Ethan Crumbley were back in court today to continue their preliminary examination hearing. Jennifer and James Crumbley are accused of failing to intervene when their son showed signs of mental distress at home and at school before he shot and killed 4 students and injured 7 others. This hearing was held to determine if there's enough evidence to send the couple to trial for involuntary manslaughter. In court, the prosecution played a video of Ethan at a gun range shooting at targets and even helping his mother with the gun as she takes her turn to shoot. The court also heard from Oxford High School counselor Sean Hopkins, the one who called Ethan's parents and expressed his concerns for Ethan's mental health. Let's take a listen as he describes his interaction with the alleged shooter's parents.
Who eventually showed up at the school?
Both mom and dad.
How long approximately did that take? Do you know what time that they
arrived?
Yes.
It was, I believe, around 10:30.
Okay, so you, in the meantime, where was Ethan?
He was with me. I didn't want to leave him alone.
Okay, what were you doing?
We had further conversations about some plans for him after high school. Typically, when a student is waiting for parents to arrive, it's a nerve-wracking time for the student, and I don't want them to be focused on that moment if I can help it.
Backing up just a little bit about the risk assessment. When did you conduct that with Ethan?
It was prior to calling mom.
And what kinds of things did you ask him?
I asked him if he was a threat to himself or others. And his statement back to me was, I can see why this looks bad. I'm not going to do anything. I then asked him to describe some of the words and pictures that he had written on the sheets.
And what did he say?
He stated that the pictures were a video game, but when I asked him to go deeper into the words, he continued to display the sadness that we had discussed earlier of the friend not being able to attend school, dog dying, a grandparent dying.
Did you, when he said, I can see how this looks bad, I'm not going to do anything, did you stop there or did you ask him any more questions?
I asked him specific questions about what he had written. I did not ask any further questions about a plan.
Okay. And why not?
Because he stated that he was not a threat to himself or others.
Okay. When mom and dad arrived, let's back up. How many times approximately a year do you have a situation where you're concerned about a student's mental health and their safety and you call parents in?
12 to 15 per year.
Okay. And can you tell the court what happened when they arrived? Did you go get them or did somebody else?
I went to go get them in the counseling office lobby.
And who else was in that meeting?
The student was in that meeting, and then I also texted our dean to return for that meeting.
Okay, so who arrived first, the dean or the parents?
The parents.
Okay. And where were you when the parents entered the room? Were you in front of them or behind them?
I was in front of them.
Okay. And what happened when they walked in the room?
It was different than other meetings I've seen.
Why is that?
They weren't friendly or showing care to their student.
To their son?
To their son.
Did they greet him?
No.
Did they touch him?
No.
Did they hug him?
No.
All right, still with us to help break all this down, Kirk Nurmi and Mark O'Mara. Let me ask you both, bad parenting or a crime? What is your opinion, Kirk?
Well, that is a great question because it's a great distinction, and it's a distinction that the state's going to have to make when they prosecute this case, because a lot of the members of the jury are probably going to be parents. So it can't just be bad parenting or debatable parenting or questionable parenting. It's going to have to be bad, horrible in all capital letters. They're going to have strong signs that were ignored by the parents, strong signs that they just deflected, just ignored, did not care about, and repeated ones. Not only that, but in face of these ignored signs, they gave their son, who was not old enough to own a weapon, a Christmas present capable of doing what exactly he wound up doing. So it's going to have to show some really extreme indifference to these signs, some really bad parenting in order to get over that hurdle to gain the conviction they're seeking in this case, because it is so unique.
All right, Mark, give us your opinion, if you would, on whether it's bad parenting or rises to the level of a crime.
Yeah, we know it's bad parenting. That's the easy question to answer. And then along the spectrum, does it go from bad parenting to negligent parenting? Absolutely. But is it that gross negligence that we know has to be shown for a jury to hold them criminally responsible? And I got to tell you, and agree with Kirk, when you know what you know and you're told what you're told and then you don't do anything, maybe that's horrible parenting. But when you then go out and buy him the very weapon that he uses, then yes, I do think the culpability in a jury's eyes, if and when they get there, is going to be on the parents for having allowed and therefore maybe caused the actions of the son. And we'll see how that presents itself in a trial.
And really sad in terms of parenting, and you're right, bad parenting sometimes when you read parts of what happened at this preliminary hearing, and part of it was that he said he needed to go to the doctor and get medication, and his dad basically said, toughen up, you'll be fine, gave him some drugs that said you're going to be okay, and you just need to be tougher. And so it's hard to hear that when you know it's a cry for help looking back in retrospect. Let's talk about the legal standard, though, because some viewers say, what does this mean? There was a preliminary hearing. Now we're going to trial. Preliminary hearing, and I'm going to start with you, if I could please, Mark, the standard of proof and the difference between a preliminary hearing when a judge says it goes to trial versus a criminal trial beyond a reasonable doubt.
Sure, it's sort of like not even a preponderance, but like a probable cause standard. The evidence is presented by the state to say there's enough here for them to have to stand trial. Much different and much lower standard than the beyond a reasonable doubt they're all comfortable with and aware of in a criminal context. What this really says to the judge is, here's our best case. There's enough here that they should be held accountable in front of a jury. And it seems as though, obviously, that's where we're going with the evidence that was presented so far by the state.
And Kirk, what is the significance in your mind, or not, of the fact that this is the first time in history for a school shooting that we are seeing parents charged with the actual deaths caused in that school shooting that was done by their child?
Yeah, I think the significance really is one broad significance. It really doesn't affect the trial at hand, if that makes sense, because this could be a precedent-setting case allowing and motivating other prosecutors to bring similar cases. But when we talk about the trial at hand, when we talk about the trial of Crumbly, that's probably not going to mean anything, because the real focus of the prosecutors are going to have to advance forward is what I said earlier, that horrible parenting, gross negligent, to go beyond the standard that Mark was just talking about of probable cause, but to find proof beyond a reasonable doubt that these parents were so negligent in ignoring the signs and putting the weapon and destruction in their son's hand that they should be convicted. That's really going to play in that courtroom, but it will certainly reverberate outside the courtroom to other areas in cases like this moving forward.
And I know we're almost out of time with you all, but Mark, I must ask you this. Do you think these parents would have been charged if the gun part was not an issue? If they had not purchased a gun for their son, Ethan, would they have been charged, in your opinion?
I think that was a tipping point. I think when it got to the point of the very vehicle through which all these crimes were occurring, and it was because mom and dad did it, that yes, that's sort of the how dare you. But I must say one more thing, Ashley, that you mentioned. I do see that this might be a bit of a shift or a change in the way the criminal justice system is looking. Because if we do go back over the last couple of years, you know, we are holding cops much more responsible. The Kim Potter trial, many other trials, the Ahmaud Arbery, I'm sorry, the George Floyd case. We are now holding cops responsible more than we ever did before. And now I think this is telling parents we're going to start holding them responsible for the actions of their children when it ends up with this type of a tragedy.
All right. Thank you both so much for your expertise. I always enjoy having you, Kirk Nurmi and Mark O'Mara. And Mark, I know you're going to be on with Michael Ayala later this evening because we have to step aside for a break. Thank you both. But the programming note that I just referenced, a new Court TV special on the cases that are Black history in the making, airs tonight. Court TV anchor Michael Ayala will have an all-star panel with him, including attorneys Benjamin Crump and Mark O'Mara, the man who did defend George Zimmerman. Michael will talk to our panel about the cases changing the course of history as we live it. You can watch it tonight at 7 p.m., 6 Central, right here on Court TV Live. You don't want to miss it. Coming up next, you also don't want to miss, because we are going to shine a light on the youngest victims near and dear to my heart. A 5-year-old girl is missing after she was returned to her biological parents. Is this a new trend, and what can we do about it? That's up next here on Court TV Live. Turning now to legal cases affecting the most vulnerable among us, the youngest victims. If you know me, you know I'm passionate about this. And today we want to talk about what seems like a rise in cases of children who are harmed after being returned back to their own biological parents. Let's start first with a case out of Washington State. 5-year-old Oakley Carson's life took a turn for the worse after being taken from her foster parents. Oakley was last seen about 1 year ago in Oakville, Washington. She was reported missing in December of last year after the deputies arrived at her home to perform a welfare check. A welfare check is when they go in to make sure the children appear to be safe. And guess what they found at that time? Well, Oakley's parents, Andrew Carlson and Jordan Bowers, there on your screen, are both facing charges of child neglect in connection to the older sister of Oakley. The parents are also charged with exposing another of their children, their 2-year-old son, to methamphetamine. They are going to be tried together in a trial that's currently scheduled for April 19th. To be clear, neither faces charges related to Oakley at this point, but in part that's because Oakley hasn't been found. Joining us now, Dr. John DeGarmo, a foster care expert. John, always happy to have you with me. Before we compare this case to other cases, I have to ask your opinion as a foster care expert, why a child like Oakley is returned out of foster care, is taken out of foster care from your perspective and returned to parents and then ends up missing.
That's a great question. I'll tell you, this case angers me and it deeply saddens me because it could have been prevented. Why did this happen? Because the end goal of foster care for so many times is reunification between the birth parents and the child. And that's, many times, 50% of the time, that's what happens. Sadly, 20 to 30% of the time, those kids come back into care far more traumatized, or situations like this even worse. So it's a system that is really kind of forcing more children back home. But sadly, sometimes the homes are not ready, like what happened in Oakley.
Right. And I've had so many cases when I was on the bench in which foster parents have said, hey, by the way, this is really a terrible idea and here's why. Right. But the problem is often it's here's what I think versus the facts that a judge, that parties need of these are the specific examples. And how are we going to compare this? Let's talk about some other cases, because that's a case in which we don't know where the child is. If anyone has any information, please report it. But we also have cases in which we do know where the child is gone. First, though, I want to talk about children who are missing after they've gone home. So Harmony is a case that we covered here on Court TV. I want to listen together because, again, in foster care, returned home to biological parent. Let's talk about her case and listen together to a little bit of what her mother had to say.
Yeah, I always looked like I went calling DCYF every single day. I hired somebody that could find addresses. I had my therapist call and file 51As. I had family members on his side called. What else? I wrote a letter to the mayor, and I didn't even get a letter back from the mayor until the investigation had actually hit the media. That's when they reached out to me and wrote back. Basically, probably to everyone trying to cover their own butts, it's just, I didn't even get any type of recognition about my daughter until a few weeks ago. And I've been begging for any type of answer since 2019. It's disgusting. Since Easter, when I had an Easter basket for her for over a year, I held on to that in hopes that he would just one day just decide, I've been being a jerk. And she deserves to see her mom. That was never the case. It was never about Harmony. It was about what Adam can get from having her.
So Harmony Montgomery is still missing. If anyone knows anything, please report it. Let's clarify who that was talking about her. John, the good news is that was her own mother, and her own mother reported it. That was Crystal Sorey, because the child had been returned to the father. Mother and father not together, and while with the father disappeared. How do you compare that to a case like this one where both parents are in jail for unrelated charges, but yet child returned home and missing?
What's important to know here is the grandmother noticed some concerns. Oakley went to visit the grandmother for a while, and the grandmother reported child welfare. There are scratches, there are bruises, there are swollen eyes. There were red flags. Those red flags were once again ignored by a child welfare agency. And you and I have talked about this, a child welfare agency that is so overwhelmed right now. They just can't process all the children coming back. And sometimes that's why the kids go back too soon.
And I think that's a lot of what we need to discuss, the red flags. Anybody who sees those red flags should report it, but then you have the breakdown. Sometimes it's reported, it's not investigated completely, right, and they fall through the cracks. But we are, and in our world that we work in, we see them falling through the cracks all the time because we work in that specialized niche. But to the world in general and to the nation as a whole, it seems like you hear about these cases and you think, well, certainly this has to be a one-off. It's not always a one-off. We're covering multiple cases here that this is happening. I want to talk about one that we covered, John, and unfortunately, we know what happened, young Judah, and we know that after he was returned, he actually died at the hands of his mother. If you could change one thing in the system to prevent that, what would it be?
I'd make sure that after the child is returned back home, that the child is wrapped around with services and the family's wrapped around with services where the caseworkers and the agencies continue to visit the family to ensure the child's safety. That's the first thing I would do.
And you know, it's interesting, the legalities. And so I'm here to say, yes, the feds have said reunification is the primary goal so that children aren't to live in foster care, but rather that's a temporary placement until the parents can get it together and be reunified safely for their children with them. But what happens often is if a parent does everything, a judge has to return the child to the parent's home. They don't have a choice. If there's no dependency, then that child has to go home. But if there's no dependency, then there are no services. There's no child welfare check. There's nobody looking at that home. And so when that happens, it's almost like there's no safety net, and we have to hope and pray that that child does well with the biological family. Let's end on a case with hope, but yet what it means for her future. We just covered this recently here on Court TV, Youngest Victims, Paisley. And you may recall this case, John. She was found successfully by law enforcement searching a home simply because they saw a little sliver of a blanket in stairs, and after they took the stairs apart, lo and behold, there's little Paisley, dark, wet, cramped space with the mother under those steps because they were hiding her. They had her. So the good news in the last minute, good news, thank gosh, Paisley was found. However, what kind of trauma does that cause a child?
Oh, the trauma will be with her for lifelong trauma. She will need lifelong therapy and counseling. There's going to be issues of trust. There's going to be issues of attachment. There's going to be many, many different anxieties. You know, when I first heard about this story, I thought to myself, she's going to be dead. She's going to be found dead. So when I saw that she was alive, I was like you. Thank gosh. Thank God. It was a miracle.
Yeah, absolutely. See something, say something. I cannot emphasize that enough. John DeGarmo, I so appreciate all your expertise in foster care and being here with me on Court TV covering the youngest victims. Please, if anyone out there has a tip on the location of Oakley Carlson, call the Sheriff's Office, 360-533-8765. You can see the number on your screen. There's a picture of beautiful Oakley missing for almost a year. Somebody knows something. All right, we want to let you know that Michael Ayala will be up next, his specialist tonight. Thank you all for joining us at home. You don't want to miss it. Stay tuned. We'll be right back here on Court TV, your front row seat to justice.